Hey, everybody, I want to go ahead and get started for this year's seminar. A couple of quick things before I turn it over to Chancellor Butler. Thank you all for registering. You should have received an email yesterday or this morning with links to all the materials and a link to the CLE reporting form. If you didn't receive that, shoot me an email and I will get all that to you. And then if you have any questions during today's program, use the chat function. I'll be monitoring that and asking the participants all the questions that come in. But I will go ahead now and turn it over to Chancellor Butler and let him make our official welcome.
Can everybody see me? I can't see myself.
We cannot. We can hear you.
Well, okay, how do I fix that?
So in the bottom left corner, there should be a button that says Start Video beside the mute button.
Well, it says my video is disabled.
I can never, okay. Now try it. See if it works.
Start video.
Yes. There we go.
Okay. All right. Good morning, everybody. This is about the 18th year of this annual seminar, which began, I think, like in 2003. And we've been fortunate along the way to have presenters from the various bar associations across the state, including the Tennessee Bar Association, various chancellors, Court of Appeals judges, Supreme Court judges, and many, many others. And the attendance has been increasing every year. But the history of this seminar is firmly rooted in the practice in the Chancery Court for Henderson and Madison and Chester counties. Now, by history, the Chancery Court is a good example of our English heritage. In the early days, the Chancellor was empowered to administer justice, what they call according to the length of his forearm. In other words, as his conscience directed. Even though the word chancery is equivalent to equity, the court has now been vested with jurisdiction over many subjects and in many areas that are not inherently equitable. In 1984, the Tennessee legislature undertook a reorganization of the trial court system in Tennessee, but they were very careful that nothing in that law should be construed as altering or diminishing or abolishing the Chancery Court or the constitutional and the historical distinctions between Chancery Court and Circuit Court. The jurisdiction and the procedure of the Chancery Court constituted a part of our law that our ancestors brought to us from England when they came and when they founded the colony of North Carolina. And when that colony later became a state, this jurisprudence from England was recognized. And the administration of this jurisprudence was provided for in the North Carolina Constitution. And in 1782, I believe, the legislature in North Carolina conferred this jurisdiction upon the courts. Tennessee was then a part of North Carolina, and that jurisdiction became our law. And so when Tennessee became a state, both the deed of cession and the acts of Congress admitting Tennessee as a state of the Union made the laws of North Carolina our law, and until we saw fit to change that. And so in our first Constitution and in all our subsequent constitutions, the jurisprudence and the procedure of the Chancery Court were fully recognized and abundantly provided for. And when that procedure now has been modernized and simplified and improved, the jurisprudence has not been changed, except to extend that jurisprudence and to enlarge upon it. So the original jurisdiction thus derived from the colony and then later the state of North Carolina from the equity jurisprudence in England is called inherent jurisdiction to distinguish it from statutory jurisdiction. So that's one of the distinctions between Chancery Court and Circuit Court. Circuit Court is bound mainly by statute. Chancery Court is bound by statute, but also has inherent jurisdiction. And we have what they call equitable maxims. I'm sure you've heard of those. And these are the sources of a vast number of particular rules concerning rights and remedies, and they are a component part of the equity jurisdiction in Chancery Court. They're aptly called the laws of the laws. And one of the main maxims is that equity will not suffer a wrong without a remedy. This maxim and the maxim that equity operates upon the person are two of the principles most active in the originating and molding of Chancery jurisprudence. The king of England, as the fountain of justice at that time, believed that he had the prerogative as the supreme judge of England to do whatever he deemed was right and just between a man and a man, and without reference to laws that were passed by the Parliament or customs or statutes or courts. The king was the king. And so he was prompted, no doubt, by his ecclesiastical chancellors. And he was unwilling to see a wrong done to a subject or to be told that there was no power in the kingdom to right the wrong simply because the common law had furnished no remedy for the wrong. And otherwise, the wrongdoer was superior to the law and mightier than the king. So he couldn't have that. Therefore, the king, deeming this state of facts derogatory to him and to his disparaging to his prerogative and disgraceful actually to the kingdom and a dereliction of his duty under his oath, he took personal cognizance of such matters when he was petitioned to do so. Just a person on the street could file a petition with the king under this type of scenario. Ultimately, these petitions became too numerous for the king to give personal attention to. Otherwise, that's all he'd have been doing. And so he referred those petitions to his ecclesiastical chancellors, who were called the keepers of the king's conscience. And so he gave them authority to do whatever good conscience and good reason are required to be done in a particular case. And this is how the Chancery Court came about and developed, and is why the chancellor is often referred to as the keeper of the king's conscience. Now, judges of the Tennessee Supreme Court appoint their clerks to a term of 6 years, and chancellors also appoint their clerks to hold their offices for 6 years. Other clerks, such as the circuit court clerk, city court clerk, juvenile court clerk, and other similar clerks are elected, and they must run for election in the district in which they operate. So there you have the history of the Chancery Court in a summary. Now, I'm going to close here in just a minute, but I recall You all know I'm retired now, so I'm what they say, coming in late and writing bad checks. Some of my friends, so-called friends, have often said things about me, and I remember one, Tim Crocker actually is his name, that's his initials actually, once said to someone, Chancellor Butler has all of the virtues that I dislike and none of the vices that I admire. He said that he's a modest little person with much to be modest about. And another lawyer trying to compliment me said he has no enemies, but he's intensely disliked by his friends. And he's not only dull himself, but he's the cause of dullness in others. And he loves nature in spite of what it did to him. So to wrap it up, one lawyer said, some cause happiness wherever they go, others whenever they go. So I will now go and cause happiness to all the attendees at the seminar. Have a good day. Andy, back to you.
Great. Thank you so much, Chancellor Butler. And thank you for your service on the bench.
You're welcome.
And we will go ahead and move over to Chancellor Maroney to start his presentation. Chancellor Maroney, you should have the ability to share your screen, unmute, and turn your video on.
Good.
Okay, good morning. Can you hear me?
We can.
Okay, thanks. I usually do this with my iPad and had a little technical problem today, so I'm doing it on the laptop.
Oh no, sorry, Chancellor Maroney, I accidentally cut you off. Let me add you back. That's my fault. I clicked the wrong person. I tried to change Chancellor Butler and accidentally changed Chancellor Maroney. Sorry, you're back going, Chancellor Maroney. You should be able to unmute yourself. That is completely my fault. You can text me and yell at me later.
That's fine. I thought maybe I'd already bombed after just a couple of seconds. So, well, thank you for letting me participate today, and I appreciate the opportunity to speak at the seminar, but also, of course, I just appreciate the opportunity to serve as the Chancellor of the 26th District. I appreciate the opportunity to follow Chancellor Butler today, and I'm learning what a big responsibility and what an honor it is to follow him in all aspects. And he has been very helpful to me throughout this transition, and I really appreciate him. He was poking a little fun at himself there at the end, so I'll throw him some bouquets and say how much I've really appreciated him, and I know all of you do. As I prepared to speak today, I spoke to a few attorneys and said, what are you interested in hearing from me? What would you like me to talk about? And overwhelmingly, what most people said is, and I'm paraphrasing, they said, you're new. We want to know what you like, what you expect from the attorneys, what can help us better help you in your courtroom. As a new judge, those experiences, I may not yet have had a big enough sample size of experiences to give you the full gamut. Maybe a year from now, I'll be able to give you some more suggestions and maybe better suggestions than what I can do today. One of the things that I did when I came into this position in order to better serve was I began to refamiliarize myself with the local rules, which I'm sure all of you have. And Chancellor Butler was quick to point out to me, and I think correctly so, that our local rules are due for some revision. And I think that's a fair point. And in viewing those especially, I've thought that. But it's also a situation where, as you all know, we're also going to have a new circuit judge a year from now, and potentially 2 new circuit judges. And so it's a little premature, perhaps, to investigate a big review of the local rules for the full 26 judicial district. That's something I hope we can look at after the judicial roster is settled a little more a year from now. But in the meantime, and let me just say, in addition to that, a year from now, next fall at least, when we hopefully start looking at that, I would appreciate over the next year any comments anyone has to offer, suggestions with respect to the local rules, thoughts you have that would be helpful to the court, because we want those to be user-friendly. But Chancellor Butler, as he's wont to do, he finds solutions, and as a court of equity should do. And so he created several years ago the chamber rules, and those are effectively some additional local rules of practice for Chancery Court in the 26th Judicial District. And I've been reviewing those chamber rules, and I find them to be very helpful. And I want to encourage everyone to refer to those. And I am not, have not made any wholesale changes to the chamber rules coming in. We've made a few minor tweaks to them, but we've made a few changes, and I'm going to see if I can share my screen and point a couple of those out to you that may be helpful. And I believe those are also in your materials. And of course, anyone can also access those at any time on the Madison Chancery website, which I would encourage you to check out. It's still going through some updates, but the chamber rules are there. So let me see if I can share the screen here, and yeah, let me, bear with me here. This is a new experience for me. All right, I'm pulling up the chamber rules, and most of these are really, as I said, largely the same as I have. They're largely the same as they have been. I'm going to scroll down to a couple of things that we have added, maybe just by way of giving you some clarity.
For some
reason,
your screen is just, at least on my end, just says started screen sharing, but there's nothing there, which I've never seen happen before.
Okay. How's that? Better?
There we go.
Okay, sorry about that.
All I'm seeing is your email. Is that what you're trying to show?
No, I was trying to show you a document. The documents in the materials.
Let's see.
Every time I resume my share, it goes to my email. Let's see. All right, we're going to try. I'll try again. If I can't, and I apologize for my, here you go. I think I got it. Sorry. Is that better?
Yeah, there we go.
Okay, sorry about that. The chamber rules, we go down to, and this is in pretrial matter, section 2C, continuances. And the first part of this is really, it's not a change. It's the court's general policy is that matters should not be continued without permission of the court. But of course, those are, we entertain motions for continuances, and they will be, freely given as justice demands. What I've added here, we've added a sentence or a phrase that says, if the parties are in agreement on a contested matter, we ask that you notify my administrative assistant, Samantha Gibbons. She goes by Sam. Many of you have met her. And what we ask is that you submit an agreed order of continuance, which includes a new date for the matter to be heard. So when you contact Ms. Gibbons and say the parties have a matter that we had set, we think we are in agreement that we need a continuance, go ahead and get some dates from her at that time. Now, she's still going to check with the court to confirm the continuance, but upon the agreement that yes, that's fine, we can continue that matter, we want to make sure that what we want to do is make sure that we don't just let these things get continued and then sort of lay in limbo a little bit. We want to keep things moving along. So what I would ask is that you just submit an agreed order of continuance on the matter with the new date that is agreed upon included in there. And I think some of that is just common sense. I think you understand that. I'm also aware that anytime you have a rule, there are sometimes those abnormal situations where it may not be practical to get a new date. I understand that. We can work through those situations. That's fine. But I think I always go back to, it's not a good idea to make rules based on those extreme situations. We go back to what do we want to be characterized by? And what we want to be characterized by is that when we continue a matter, we have a new date that's to be heard and that we move on at that point. And it just keeps things flowing. It also helps picking up the file and reading it after the fact. I know I've picked up a lot of files, obviously, in the transition. And as a new person coming in, I find myself reading a lot of files to pick up a history of events that occurred without my involvement. And when we see a matter that might have been set and then we don't see a link in the chain connecting it, we sometimes the court has to wonder, what happened there? Did the parties do we need to get that reset? What's going on? So it'll just help us if you do that, and I appreciate your cooperation with that. One of the other things that we mark, I'm scrolling down here under pretrial motion, and I'm looking at my notes as well. In number 1, if you decide that you want, if you're out of county, this is more of an issue for those folks who may be out of county. If we have a Henderson or Chester County case with a motion, and I'm thinking more obviously of the motions that are going to require some lengthy arguments, not necessarily a motion for default or something like that. But I am trying to do my best to be prepared for you. I think you deserve that. And I'm trying to do a good job of reviewing all these files, especially because many of them have a history that predates my involvement here. And so it's easy when it's a Madison County case for me to step over here into the clerk's office and get a copy of the file and review it and familiarize myself with what's going on. But of course, as you know, in Henderson County and Chester County, I can't always do that as easily. And there have been some situations where, I get to those courts early, try to get there early on days we're holding court so that I can review those materials. But if you've got a matter that you filed in Henderson County or Chester County, a motion that's going to be heard, if you could forward a copy of that motion to my office, and it can be sent electronically. It doesn't have to be a hard copy, although we'll accept hard copies. But if you can forward that to my office, it would be very helpful because I am reading everything you send me, which I presume you want me to do. And but it's a lot easier if I can read it without feeling rushed or expedited because I just got to the courthouse and court's in an hour and we're scrambling. We've got a stack of folders that high. And that happens over there in those courts. As most of you know, we go to Chester County 2 Wednesdays a month and Henderson County 3 Thursdays a month as a general rule. So just help me if you can get those over here early when they're not Madison County cases, just so that I have an opportunity to review it and give your case the attention that it deserves. If in some cases this won't always be the case, but if there are any memorandums of law that you've sent or a particular affidavit or deposition transcript or something that you're referencing in your motion that you wanted me to consider, if you will, please, at the same time you submit the motion, submit those as well, and we'll make sure to do that. Obviously, memorandums of law are not required in every case, in every circumstance, but I will tell you when you submit them, I read them. And also, I kind of associated with that, if you in addition to sending them, if you can send them as soon as practical. Obviously, if you only get it ready and submitted at 5 o'clock the night before, that's fine. I'll still read it. But the more time that I have to read it would be helpful. It's helpful to the planning of the court, and hopefully it's makes my work in hearing your case better. Another matter, and I'm going to scroll down to the procedures dealing with injunctive relief. And we started off here, this section H is not new. This is the same provision that's been in the chamber rules for some time. One thing that is new, and this is different. Some of you, we've already discussed this and you've encountered it. I've added a new section I, which references scheduling a hearing on a petition for emergency injunctive relief. When I first started, that's one introduction that I've had to Chancery Court or emergency situations, and Chancellor Butler's been quick to tell me that this is not always a courtroom. It's also an emergency room, and I can appreciate that and understand that. But one thing we're trying to do is add a little, well, I guess a little stability. I don't know if that's the right word or right phrase, but just, what we're trying to avoid is a situation where they're a little bit ad hoc and things are kind of brought in a rush. Again, the nature of emergencies is that they're sometimes they do arise that way, and I understand that. But what we're doing on scheduling hearings on emergency injunctive relief is as follows. When someone contacts the court and says, I've got a petition for some sort of emergency relief that we need, what we're asking you to do is, obviously you're going to file that, but we're asking you to contact Ms. Gibbons, the court's administrative assistant, and schedule a hearing on that. She's going to give you a hearing at the next slot that's available, whether that's 9 o'clock or 1 o'clock. And so that's the way that's going to work. So when you contact her, even if I've got a full court day at 9, whatever, you're going to get on the docket because you're representing to me that this is an emergency type situation and that we need some immediate relief. So you're going to get on the next docket. Now, I understand that the subject matter of some petitions are such that you may feel you can't wait until the next 9 or 1. I will tell you that most of the ones I've heard, even that have come at odd times, they've been worthy of a 9 or a 1 slot. But if you feel your situation is such that you need to be heard earlier, it's got to be heard right away. I understand that, and we will deal with that. The court's coming to life this morning. You can hear the noise behind me, but we will deal with that. But in that circumstance, what I ask you to do is let Ms. Gibbons know what is the nature of the situation, what's going on, why does it need to be heard earlier? And in that circumstance, what she'll do, she'll get with me, and if we need to have a hearing at an odd time, we'll do that. So we're not going to leave a genuine emergency situation hostage to a rule. We're going to get that heard if we need to. But I think, generally speaking, most of the ones that I've heard, even at odd times of day, could have been heard at a 9 or a 1 slot. In the situation where you feel that this emergency matter needs to be heard on an ex parte basis, what we need to do there is, first of all, if there is another attorney in the matter, we ask you to notify the other attorney of the time that you're given by Ms. Gibbons. If she sets you up to come in the next morning at 9 o'clock, we ask you to get the other attorney notified of that you're going to be presenting a motion at that time or a petition. If it's a case, and this happens a lot of times in the divorce matters, if there's a case that has been dormant for a while, but something new has happened, and there was an attorney, we ask you to notify the last known attorney. Now, also, we ask you then when you come to court to note if it remains ex parte, that other attorney doesn't exist, or that other attorney hasn't been able to be notified. What we're asking you to do and is to make us aware of the efforts you've made to make that representation known. These are not really radical changes. These are essentially consistent with what the chamber rules, the local rules, and the rules of civil procedure require. But we're just asking you to follow this procedure for us. And of course, as before, if it's something where you can get the petition to us, I know being an emergency, you might not be able to do that promptly, sometime in advance, but I've even had circumstances where someone said they needed an emergency hearing, but they wouldn't be able to get in for a day or two. And so at least then, get us the petition as soon as you can, and we'll consider it. And then the other thing that maybe is a little bit of a change, some hearings on emergency relief, as I understand, have happened just because of their nature. Sometimes they're in chambers, but we're hearing those in the courtroom. And the reason for that, it's not any ego thing on my part or anything like that. It's just, I feel that when we have those in the courtroom, it just brings a little formality to the process that slows everything down. Sometimes with emergency procedures, we don't want any shortcuts or loopholes because of what may in good faith be felt to be an emergency situation. We need to slow down, consider it, make sure everyone's due process rights are being honored. And so having it in the courtroom, for me, I think just helps make sure that's a smoother process. So I know that part may be a little different than what some have been used to, but I think it will work out. With respect to these, I've had a couple of questions in the short time I've been here. What if I can't, and this is going to obviously be the case where we don't have counsel on the other side. What if I can't get the respondent served prior to the emergency hearing date that is set? So for example, you've come in, I've granted your ex parte petition. We've set a hearing sometime within 15 days, and you just have trouble getting the respondent served within that 15-day period. Well, in that circumstance, what we need a motion for continuance that lays out the grounds. Obviously, lack of service would be the grounds, and you can submit that along with an order of continuance that leaves the time for a new hearing blank. And then in that circumstance, the court will find another date within 15 days. What we don't want to have happen is we want it to be like links in a chain. We don't want that chain to be unbroken where, we didn't get him served and it's been 15 days, but can you just give us another date? No, in that circumstance, then what we need is a new petition filed, because really that emergency relief that's been granted is going to expire within 15 days of its being granted, unless there's an order extending that for good cause. And obviously, failure to get him served or her served would be good cause. But we do need that. We need that for our records to keep the file clear, and also just to comply with due process and what's appropriate. So if you're getting out there and close to the hearing date, we haven't got the other party served, the respondent, just get a short motion and order over to us with a blank. I'll fill it out with a new hearing date. You can get the party served, hopefully, with that new hearing date. It doesn't do any good to get them served after the fact. If your hearing date was set for November 15th and you can't find them till November 20th, it doesn't do them any good to serve them with a piece of paper that tells them they got a November 15th hearing date. We'll get them served with the order of continuance, which reflects the new date. So that's just another little thing.
And sir, we've got a couple of questions about emergency stuff, if you want me to do those while you're on the topic. So Mary Jo Middlebrooks asked, do you want witnesses present in emergency hearings? We've traditionally submitted the motions under oath.
I will hear from witnesses if you like, but when you're having an emergency hearing, I'm satisfied with sworn affidavit. But obviously, if you've got a witness available, that would be accepted.
All right.
In the courtroom, the forum lends itself to that.
Then Jennifer King asked, she said, I just want to make sure I understand the emergency proceeding. Typically, when I'm an attorney and the matter is concluded, I close the matter and many times list that I'm withdrawing as attorney of record within 30 days from the order entered. So even if this occurs, are you requesting on emergency matters that we notify the last known or previous attorney?
I am requesting that you notify the last known attorney. I understand that that attorney has already been properly excused from the case, and that attorney may say, look, I'm not involved in that anymore. But just as often what I'm seeing is that the respondent, as often as not, goes back and retains the former attorney. And so I do want to have the former attorney notified of the proceeding. Obviously, that does not mean that the former attorney is appearing as of record. And if the former attorney is not under any obligation to appear. But I find a lot of times, let's say it's a divorce and now we're 2 years later and someone's filing a motion for some emergency custody. Fairly often I've seen in the short sample that I've been here for a little over 3 months, fairly often in those situations, the former attorney ends up being retained in the end. So I am asking you to notify the former attorney, but I understand that former attorney may not be retained for this particular case, but I just want them to be put on notice.
All right, those were all the questions. I figured you'd want to answer those while you were on the topic.
Sure, thank you. As far as the local rules go, most of their local rules, the rest of those are essentially the same. So I'm going to stop the share and go back here just to the primary screen. But in terms of a few other things, and I've made notes along the way about random things over the last couple of weeks as I've been preparing for this seminar. So these are in no particular order, but things that may be of interest and helpful to you. We have, as you know, a lot of appointments that are made, appointments for guardian ad litems. Sometimes in termination cases, we have representation appointments for parties who are indigent and have requested counsel. If you're interested in those appointments, I know already from files that we have that are active, I can see who some of the attorneys are who frequently get involved in those cases. And I've had attorneys who've contacted me and said, essentially because I was new, and said, I want you to know that I'm interested. If you have any appointed matters, I'm interested in being considered for those. And I appreciate that. And I keep a list of attorneys who've notified me of that, and of attorneys who I've seen from ongoing cases that I've stepped into the middle of, who've already been engaged in that. If you're interested in appointments in those circumstances, please let Ms. Gibbons know, and I will make sure that I'm aware of that. I don't want to, appoint someone for a parental termination case if their practice is at a time when they're just not in a situation to accept that work, and I understand that. And in some of those cases that I know are more complex, I've reached out to attorneys beforehand and said, hey, we've got this matter. Would you be willing to consider? Are you interested in taking appointments? Are you interested in this? Sometimes they've said yes. Sometimes they've said no. And as I've said, others have just contacted me indirectly or outside the courtroom and just said, hey, not on a particular case, and just said, let me know if you have any. So let us know that. And again, you can let Ms. Gibbons know that. You can let me know that if you see me out. But if you let her know, she'll send me an email. And for me, getting things in writing is a lot more helpful than the random conversation I might have in a grocery store or something like that. It will help get it done. Informational point for some of you will know this, in Henderson County, beginning after the first of the year, they're having some construction done there at that courthouse. January through March, the courtroom there is going to be unavailable. So any Henderson County matters from January through March, if the timetable goes as expected, will be heard here in Madison County. I've already made arrangements with Ms. Milam, the clerk in Henderson County, concerning that. We looked at other options in Henderson County, but the other courtroom over there was just not available. And so if you got a Henderson County matter, we're keeping scheduling the same. It'll still be on those Henderson County Thursdays, but those will be heard here in Madison County. And you may already know that, but just want to call that to your attention. One of the things I've also spoken to the clerks here as we prepare for this seminar, one of the things I was asked to remind you from the clerks is that with respect to wage assignments, Nashville, as they advised me, cannot do a wage assignment on a self-employed person, but a wage assignment on such persons can be done through the Chancery Court with the 5% statutory fee added. So if you have that situation and you need a wage assignment through Chancery Court on a self-employed person, if you'll prepare a wage assignment that reflects it's going to be collected through Chancery Court, we can do that. If you've got more questions about that in Madison County, contact Benita Anderson. Most of you dealt with her and know that, but she can be helpful with that. Another thing, if you are submitting a permanent parenting plan that provides for a wage assignment, please be sure and attach the wage assignment with the permanent parenting plan. We've had some situations where that's not done, and again, it just keeps things flowing smoothly here. Generally, and at the request of the clerks, I don't like to sign the parenting plans at the bench. I know sometimes, you're submitted a decree up there, and the parenting plan may have already been submitted. That's now been approved, or you may submit one there. But generally, we don't like to sign the parenting plans at the bench because those need to be processed by the clerks. So when you submit one to us, if it's a situation where you have one that needs to be done in an expedited fashion, while I'm on the bench, then just let me know that, and or let the clerks know, and we'll try to accommodate that. I know sometimes those are needed promptly, but they've cautioned me not to sign those at the bench because sometimes it interferes with the processes they've already got established. And as I said at the beginning, we're trying to keep the trains all running on time here. And my goal is to make sure that the Chancery Court in the 26th District continues to run smoothly and efficiently as it has. And I certainly don't want to be an impediment to that. So that's something they're doing that they've asked me to ask you to remind you about. Also, and I think some of these are obvious, but if you know that if you get a settlement accomplished, which is fantastic, just please let the court know promptly about that. As you know, trial dates are at a premium, and sometimes, depending on when your settlement is accomplished, we might be able to get another matter into that slot. Also, of course, as I mentioned, I'm really trying to be very diligent about reading everything you prepare. Most of that reading is done at night at home, and so if you just settle it the morning of trial at the courthouse, that's fine. But if you settle it the night before or the afternoon before at 3:30, if you'll let us know, because I'm probably going to be reading your file that night, and that will just be a courtesy to the court that will help accommodate time. Give me more time to read some other files. I think, Andy, that is about all I had, and I think I started a little early since Chancellor Butler finished a little early. I appreciate, again, the opportunity to serve as the Chancellor of the 26th Judicial District. It's a real honor. And I thank you for the opportunity to speak with you today.
Great. Thank you so much, Chancellor Maroney. And we will go ahead and move on to our next session. So I'm going to move everybody around. And Nancy, is Sarah on? I'm not seeing her.
We're together, actually.
Together. Perfect.
Hello.
Great. Well, I will go ahead and turn it over to y'all together.
Thank you, Andy. Let me get our PowerPoint going here. Let's see. Just share our screen. Okay,
Okay, are we ready?
we're ready.
Let's go ahead and proceed.
Go ahead.
Okay, all right. Well, thank you so much for inviting us to speak to you today. Sarah and I work in the area of elder law. And as you will know, if you haven't already seen that in your practice, this is a growing area of law. The baby boomers are now in their 60s and their 70s. They're very concerned about asset protection planning, either for themselves, and many times they have already been through some type of long-term care illness with their parents. So they're very sensitive to asset protection. So what we want to do today is to illustrate kind of what they're facing financially when we're looking at long-term care, but also give you some ideas for how those assets can be protected. Divorce is becoming more and more of a viable option in those cases, and you don't normally consider that until you see what a devastating financial effect it can have on the spouses. So we're going to go through that today and encourage you to, if you have questions or anything, just feel free to send it in the chat box and we'll be glad to answer those. So looking at what are we looking at in our senior population? Well, obviously the baby boomers are now aging and they are rapidly expanding. The cost of care can be devastating to a family because it's very expensive. You know, in Madison County, which is pretty conservative, it's about $7,500 per month for a semi-private room. And it's not uncommon for us to even see situations where both spouses are in a nursing home, so they're paying $15,000 a month. We're looking at, from the demographics, we've got 10,000 people in the United States turning 65 each day for the next 16 years. Many people, I have a lot of clients that are living to well over 100 now. So that medical technology is increasing their life expectancy, and society, as well as their family, expects a higher quality of life for those individuals. And so we try to help them, not necessarily thinking solely in terms of what happens if you're in a nursing home, but how do you plan for providing for that potential for long-term care, not in assisted living or at home, what's going to be the best fit for you. So Alzheimer's, it's a huge factor that we're seeing that's affecting long-term care. 6.2 million Americans 65 and older are living with Alzheimer's. That's expected to grow to 13.8 million by, I think, 2030. It's the 6th leading cause of death in the United States and the 5th leading cause of death among Americans ages 65 and older. You know, notably between 2000 and 2019, deaths from stroke, heart disease, HIV decreased, but Alzheimer's disease increased more than 145%. So barring some kind of medical breakthrough, we're looking at this being a continuing illness that's going to plague our senior adults. And sometimes even early, 50s. We're seeing many people now with early onset Alzheimer's. And so it's certainly not something that's unique just to the 60 and up population. Every 70 seconds, someone in America is developing Alzheimer's. And 1 in 8 people now over age 65 have Alzheimer's. So if it's not going to affect you directly, it's going to affect your clients and someone you know. The cost of care we've already talked about is continuing to go up. When you're looking at $7,500 a month for a nursing home, or possibly $15,000 if it's a couple, you know, that's not going to last long. They can't write that check to pay for that private pay. 75% of single individuals will spend their entire savings within that first year, and 50% of couples will spend that entire savings. It's continuing to go up about 3% a year. So we know that that number will continue to grow. We need to help our clients plan for that and how they're going to address that cost. Now, Medicare, this is a common misconception, myth, however you want to say it, on what Medicare pays, because we have many people that come into our office and they say Medicare is going to cover it. And they really use the words Medicare and Medicaid interchangeably, but they're not the same. So I always tell people, think of it like this: Medicare and Tenncare. That's the best way to think of it, because Medicare is not the same thing as Tenncare. Medicare is not the same thing as Medicaid. Okay. If you are in a hospital for 3 days, 3 nights, and you are admitted to a nursing home, then Medicare will cover the first 20 days. After that time, if you're receiving therapy and progressing, they will cover 80% up to 100 days, a total of 100 days of the care. However, important caveat, if you are not progressing with therapy, then you may be discharged and Medicare will stop paying. We have this a lot, on Fridays, we always kind of hold our breath around here because we always get calls because somebody's had a family meeting with the social worker and they're saying, guess what? They're not progressing with therapy. So come Monday morning, you're going to pay $245 a day. Well, that's a pretty expensive hotel bill to pay. And they're not prepared for that. Now, if they have a Medicare supplement, hopefully that's going to cover some of the care, but when Medicare stops paying, the supplement stops paying. So it's not at all an assurance of anything after the first 20 days. After that first 100 days, they're paying 100% of that care. What does Medicaid cover? Tenncare. It covers nursing homes, room board, pharmacy. It covers some in-home care, but it's very limited. It will also help pay for some assisted livings, but again, very limited. It's capped out at, I think it's about $1,200 a month is all that it will pay to help. So for the most part, Medicaid or Tenncare is paying for nursing home care. If that person doesn't have a Medicare supplement and they're in that first 100 days, Medicaid can pay that 20% that Medicare doesn't pay. Part A and Part B deductibles and copays if their income is significantly lower. And then long-term care, nursing home care with no maximum stay limits. So that Medicaid is, I guess, probably the largest provider for any type of long-term care in this country. So what are our clients' goals when they come in to see us? Well, first of all, they want to age with dignity. They don't want their final days to be spent in a nursing home if they can avoid it. They would much prefer to pay for care in their home or in assisted living. They want to access the best care possible. They want to take control over their finances to provide for both spouses. And then finally, they want to leave a legacy and provide for their children. So these are the goals that our clients have when they come into our office that we try to help them accomplish. So I thought it would be helpful to share just a case example of a family we call it in crisis. They're already in the nursing home. So we can't do any pre-planning for them. So this is Frank and Edna, and Frank is in the nursing home. Edna is what we call the community spouse. She is the healthy spouse. And so they come to see us and say, look, what can we do? He's in the nursing home. It doesn't look like he's going to be able to come home. And we're in our 100-day time frame. We need to do some planning. So we go through what their assets are. In this case, they have a home worth about $250,000. That's a typo. We meant to say Edna's IRA, not Mary. But Edna has an IRA with about $100,000, and they have joint investments and savings accounts about $250,000. And then they have 2 vehicles valued at $50,000. So this is kind of a typical client that we see in our office. Okay. So what are they looking at? Well, first of all, we tell them, in looking at getting Frank on Medicaid, one thing they need to understand is that his income is going to be paid to the nursing home. So even if he qualifies, there's still a patient liability that the spouse is going, not the spouse, but the institutionalized person is going to have to pay. If the spouse's income is less than $2,177 a month, then Medicaid will allow part of that to be allocated to the spouse, but the maximum is up to $2,177 a month. So not a whole lot. So they're, first of all, facing losing that first spouse's income. Now, secondly, they look at what their assets are. So this is based on when they enter into the nursing home. What are the assets at that time? And the long and the short is, of the countable assets, they're going to allow the spouse to keep, the community spouse to keep 1/2 of the countable assets up to a cap of $130,380. Okay. Everything else has to be spent down to $2,000. That's going to go up just slightly next year. It's going up. Numbers just came out, I think, yesterday to 137.4, but still not a whole lot for that community spouse to live on for the rest of their lifetime. And then lastly, besides the financial requirements, they've got to meet the medical requirements. So just because Edna says, look, Frank, I can't take care of you, you're going to have to stay in the nursing home, that's not good enough. They actually have to do a test, a medical eligibility test called a PAE. And basically what that means is Frank has got to meet the eligibility for Medicaid. In other words, pretty much bedridden, unable to take care of basic needs, those kinds of things. So it's not a foregone conclusion that they're going to meet that medical eligibility test. So we always counsel our clients, first hurdle you need to overcome is getting your PAE approved. Make sure he meets the medical eligibility before we start any spend down or go into asset protection planning. So in this example, as I said, they have 250,000 accounts. That's a countable asset. Medicaid's policy is if it can be cashed out in 30 days, it is an available asset for care. It doesn't matter whose name it's in. Doesn't matter if it's Frank's name, Edna's name, doesn't matter if they have a prenuptial, they don't care. They are looking at what's your household assets. Okay. IRA, again, an IRA, you can cash that out in 30 days and you can liquidate it. So it's an asset available for care. And then in their case, they had 2 vehicles. Medicaid will only let you have 1 vehicle. Now, the good news is it's 1 vehicle of unlimited value. So that's helpful. So you could trade 2 vehicles in for a nice vehicle. But in their case, their countable assets for calculating how much the spouse can keep and what has to be spent is going to consist of 250,000 in asset in accounts, 100,000 in IRA, and the vehicle, based on whatever it's valued at. We have a lot of folks that come in, and I guess this may be just a West Tennessee thing, but they have this sentimental attachment to cars. And so there will be like cars, which are like yard ornaments or something out in there that they don't run, they're disabled, or maybe a truck that's been in the family for 20 years, they just cannot let go of. And we always try to tell them, you understand when you're doing Medicaid planning, they look at that like money in the bank. You need to sell the car. Because otherwise they're going to count that as an asset and you're going to have to come up with money to cover that. So what are exempt assets? So there are a few exempt assets. The home is one of them. That's probably the largest exempt asset. Most of the time, the spouses own the home in joint names. And for a lifetime, there is no requirement that home has to be sold. And we're going to talk in a minute about what happens when the spouses are deceased. So it's not a full homestead exemption. It's just a lifetime exemption. Okay. And then 1 vehicle. And like I said, they can trade up and get a nice vehicle. I often tell clients, even if neither of you are currently driving, you may want to go ahead and get a nice vehicle, for helpful for transportation, van, that kind of thing. Even if your children are the ones transporting you, but that's something that would be useful. Okay, so the spousal resource allowances, this is what Medicaid allows the community spouse to keep. Now, we've already talked about the absolute max that the community spouse can keep is $130,380. Then they also look at what the community spouse's income is. It's called the minimum monthly maintenance needs allowance. We call it MEMNA. We use a lot of acronyms in this world because if you try to remember what they stand for, it would drive you crazy. But the minimum amount of income the community spouse is entitled to. And like I said, right now, if the community spouse's income is less than $2,177.50, then some of the institutionalized spouse's income can be allocated. But most of the time, the spouse may have income that would be $2,500, $3,000. So in that case, they get nothing. Okay. Now, one nice thing is that there is no cap on the amount that the community spouse can make. We have community spouses that are still working. Maybe they're professionals. They may be making $100,000 a year. That's not touchable by Medicaid. They allow the community spouse to keep their income. So that is a nice thing. But as we said, the other assets that they have accumulated together, they're dividing that in half. And they're only going to be able to keep a certain amount, regardless of whose name it is, regardless if there's children involved, etc. I won't restate that again. Now, we talked about the estate recovery. We talked about the house being an exempt asset. And as I said, it is exempt for life. And currently, on a joint account, a joint house, if the community spouse is a surviving spouse, Medicaid will send a release that says it's conditional, kind of saying we have the right to come back and file a claim against this property at some point. But to my knowledge, I don't think there's anything the Tennessee legislature has passed that allows them to have expanded estate recovery to be able to place a lien on the house or file a claim against the estate. But one thing that they do, and very aggressively, is in the event that the institutionalized spouse is a surviving spouse and they pass away, Medicaid will file a claim against their estate. And, you know, in the past, and I know many of you realize that too, people kind of hung around for about a year and said, well, let's not open the estate for a year and then the state's claim is run. Well, it really doesn't start to run until a personal rep has been appointed. And in addition to that, Medicaid isn't going to wait a year. I can tell you, because I've had this happen over and over and over again, they wait 6 months. And if the family hasn't opened the estate, they're going to open it. They're going to ask that the property be sold to pay the Medicaid bill. So you can't just stick your head in the sand. And that's what we encourage our clients. You need to prepare for that. There are a few limited exceptions to that. Number one is, like we said, the spouse can have that in their name and live there without being forced to sell. If there's been a child who's lived in the home with the parents for 2 years prior to entering the nursing home, and they provided caregiver services, then there's a limited exception for that child to receive that home. But they have to actually provide care. There's got to be a doctor's affidavit that states that because this child provided care, that the parents didn't have to go to the nursing home and prevented them from that. A disabled or minor or blind child residing at the home. So again, they want to make sure that is protected. And I have found in some cases, even when they're not residing at the home, maybe you have a disabled child that may be in a group home, but they will still allow us to transfer that into a trust for that child to use for their benefit without requiring that to be depleted. And then joint ownership with a sibling. So they own something with maybe 2 sisters live together or something like that. So again, limited exceptions. Now, a lot of folks come in and say, no problem. We get these panic calls. Oh, he's going to the nursing home, and they just start this flurry of activity of gifting. And they have this misconception again that we can give $15,000 a year. That's okay, right? And so we can just give to 12 different people and have this knocked out. No, as we said, there is no exclusion. There's no gifting exclusion for Medicaid. I've had them ask me about $500 gifts. I've had them even ask me about $2 charges on a debit card. So there is no exception. In fact, to the contrary, Medicaid takes the position that any transfers are intended to qualify for Medicaid, and they're fraudulent transfers. Now, that's obviously not true, because many people are making gifts on a regular basis to their children. But the burden is on us to prove that to Medicaid, and that's really hard when they're the judge, okay? When we appeal it to the administrative law judge, who is, of course, employed by Tenncare. So you really don't want to go through that whole process if you can avoid it. So we always encourage our clients to understand, don't do any last-minute gifting. There's lots of other options we have available to us that can help protect the assets. In the event they have made gifts, and many times we find that has happened, then we have to look at that, because they could be subject to a penalty period. Now, what does that mean? Well, that means once they've spent down to $2,000, then there is another penalty period attached before they meet Medicaid's eligibility requirements, which means they're going to have to come up with money to pay for the private pay of that care through that penalty time frame. Okay, and there's a formula that they use. Basically, in a nutshell, I don't have that exact amount on their divisor penalty. Let me have to see if I've got that here. They've changed that I don't see where they have, but more or less, it's basically taking the value of the gift and dividing it by approximately $6,000. And that will tell you how long that penalty period is. And their options right now are either give it back, in other words, what we call cure the gift, or pay through the penalty period. Neither are great options, particularly the money's already been spent. So we do want to make sure that the clients understand there is no $15,000 per person exclusion. Do not give gifts. If you have given gifts, you need to let us know about it, and hopefully we can get the money back. So what is the best method? Again, we all know not gifts, right? Spend down. So if it is a transfer for value, that's not a gift. That's a legitimate spend down. So when in a case like this, like we had Frank and Edna, they've got some money they need to spend down. What can they do? Well, they can buy prepaid funeral plans for both of them if they want to. If they have debt, mortgage, credit cards, etc., they can pay for that. Buy a new car. We often advise our clients, why don't you prepay some expenses, because your spouse isn't going to have income to pay all that now. So if you want to prepay some utility bills and insurance and home repairs, etc., let's go ahead and get that taken care of now. Oftentimes, you can't make a gift to the child, but specifically if that child is helping you as a caregiver, maybe you have one in the nursing home and the other one is living at home, but they're still having to have care in the home. Well, you can pay that child as a caregiver. Now you have to have a written caregiver agreement outlining their responsibilities. They got to keep a log sheet of what they're doing, just like a normal sitter would if you hired a third party, but they can be paid the same as a sitter service would be. So right now that's about $25, $26 an hour. So there's ways to transfer money, but it has to be done as a spend down, not as a gift. Medicaid compliant annuities. We're going to get into that in just a minute in a little bit more detail, but that's a very popular option for spend down. So let's say they have $100,000 to spend, and they've spent 50, and then they have another 50, and then what do? We don't have anything else to spend it on. Well, as I said, if it's 50 in the bank, Medicaid says you've got to spend it because you can access it immediately. But if you convert that from a countable asset to an uncountable asset or non-countable asset, then it's protected. How do we do that? Well, you take the 50 and you purchase an annuity for the community spouse. Now, there are some specific requirements for these annuities, because it cannot be just an annuity you purchase and then you can access it anytime. It actually has to be an immediate annuity that is paid out for a term certain, for a certain amount of money. Okay, so it's very specific. A lot of times we have financial advisors call us and say, oh yeah, we'll make that a Medicaid annuity. There's very specific requirements. Make sure that they're consulting with an elder law attorney to make sure that it meets those requirements. If it doesn't, then you're in trouble. You have to cash those annuities out. A lot of times pay surrender charges, and it's very expensive for that client to have to go through that. Pool trust, that is something we've used a lot in the past. That's a special needs trust that is often used when we have maybe a client under 65 and they're in a nursing home, but we're trying to preserve what they have so we don't spend down to $2,000. We transfer those assets into this special needs trust. Often it's called a pool trust because it's pooled with every sums of money from different people, but it's handled, and you have a trustee that can distribute for that beneficiary or for that client for their extra and supplemental needs that aren't being provided for through a nursing home. So we've used that to get private rooms for clients, or for helping with transportation vans, those kind of things, sitters for those clients. So it's a good way to not force that to be spent down to $2,000 and reserve some money for the child, for the client. Now, one big caveat on that is there's a payback at the end. So if any of you seen these Tenncare releases lately, they'll say you need to let us know if they were a beneficiary of a trust, a special needs trust or a pool trust, this kind of thing. Why they want to know that is because they're going to send them a bill. And if there's $10 left in that pool trust, they're going to take it. Okay. So there is a payback. So I always encourage clients, if you're going to do that, be generous on how you spend the money, because you want it to enhance the quality of that person's life. It's not going to be preserved for the beneficiaries. Okay. Court petition, I've done that a few times where we can go to court, and if the assets are such that it's really going to cause an undue hardship on the community spouse, we can ask the court to increase the Community Spousal Resource Assessment or the MEMNA. That's kind of rare. Used to, it was pretty standard to do that kind of thing. Now, Medicaid's much more aggressive. They're going to get in there. They're going to be a party to that suit, and sometimes they're going to object to that. So it's not that it can't be done, but it's a unique set of circumstances. And then lastly, divorce, which again, usually is the last option, but as Sarah's going to expand on that in just a minute, many times that's the most logical option to protect the assets. So Frank and Edna's example, we said they have 350,000 more or less of countable assets. We're going to assume they traded their car in and got a nice car, both cars. And so they have $217,000, a little over that, in spend down. What are they going to do? Well, they bought 2 funerals, they made home improvements, they paid off their credit cards, but they still got $172,000 left. Okay. Well, the IRA, again, we can transfer that into a Medicaid compliant annuity, which is also an IRA for Edna, and that will convert that from being a countable asset to a non-countable asset. And what we're going to do in layman's terms is we're going to take that $100,000 IRA and turn it into a monthly pension for her. That can be a good thing because she's obviously losing Frank's income, right? So if she says, okay, I'm 65 years old, there's a 10-year life expectancy, then we could divide that IRA out over 120 months and 120 equal payments, and that would help offset some of the income she's losing because his income's going to the nursing home. There's a balance, in this case, 72,000. In this particular case, it makes a lot of sense that we may want to go ahead and invest that as well as in a Medicaid compliant annuity for Edna to give her a little extra income that she could have to offset the loss of income from Frank. So it's a good way to do the spend down without having to necessarily write $7,500 a month to the nursing home until it's gone. As I told you before, Medicaid compliant annuities are very, very specific. There's only about a handful, maybe less than 5 companies in the country that do these. So just because they have an annuity doesn't mean that it's Medicaid compliant. Like I said, it has to be an immediate annuity. And what that simply means is if I sit down with Edna and I'll say, okay, Edna, what do we need? What do you need to help make your monthly budget, your bills? And she says, well, I really would like to have $1,000 a month. And we run our numbers and we structure that annuity with an insurance specialist to pay her $1,000 a month. Then that's what it's going to be for the term of that annuity. She can't get any more. She can't get any less. So we do want to make sure that they understand it is irrevocable once you make that decision. You also need to understand that annuities are really good to use between spouses. And that's the whole purpose, is that it provides for that community spouse to still be able to pay their bills and to have a quality of life. It's really not there to provide for the children or for the beneficiaries. Okay, that's really not the purpose of these annuities, because the state of Tennessee has to be named as a beneficiary after the spouse. So if Edna ends up in the nursing home at some point in time, and there's money left on that annuity, that $1,000 a month is going to pay to the nursing home. And then at her death, if there's still 5 years of payments left, then Tenncare is going to have the ability to recoup what they've paid for Edna from that annuity. So remember that annuities are not always for everyone, but in a case where particularly maybe Frank may be 10 years older and Edna may be in her 60s and has a longevity in her family, then that might be a great way to say, okay, she's in good health. Let's do an annuity for 10 years to give her that guaranteed income that she needs. It can be purchased both for the institutionalized spouse and the community spouse. For example, let's say Frank was the one that had the IRA. We can do an annuity for him, and that will, again, pay to the nursing home while he is still living. But if he lives a year and dies and there's 5 years left on that annuity, that will pay to Edna. Okay, so it's a way to kind of preserve his retirement account. So it's provided for her lifetime. So again, good options in that case. Not always working for people, especially if they don't have the liquidity that this couple had. So that's crisis planning. So let me talk to you a little bit about more proactive planning that we do for clients. And I think this is something to be mindful of. Even when your clients come in maybe to talk to you about doing a prenup, talk to them about the options of trust. If you don't feel comfortable with doing a trust, obviously you can call Sarah and I will be glad to help you with it. But whenever a client comes to me and asks for a prenup, we always have a discussion about kind of doing a belt and suspenders approach. Let's get a prenuptial in place. Let's also talk about setting up a trust that will identify what your assets are and who your beneficiaries are, and will clearly set a line of separation between your assets and your prospective spouse's assets. So a trust is just a contractual relationship formed between the grantor, which is the creator of the trust, and the trustee, who's really, as I tell people, officer of the trust, that who holds trust for the benefit, who holds the property for the benefit of the beneficiaries, and a beneficiary. Okay, and the trustee's responsibility is to administer the trust for the benefit of the beneficiaries per the terms of the trust. And a trust has assets. So a trust doesn't help people avoid probate, protect assets, this kind of thing, if it has no assets. So we have to title property in the name of the trust or transfer title to the trust. Okay, the types of trust, lots of different kinds. There are revocable trusts. Those are typically used to avoid probate. We do use those a lot when people are coming in looking at prenuptial agreements, just to identify this is your assets, these are your assets, and who your beneficiaries are. Just helps to really keep things separate. Irrevocable trusts are typically used for asset protection planning. Very different than a revocable trust. A revocable trust, the grantor can be the trustee. Irrevocable trust, the grantor does not need to be the trustee. It needs to be someone other than the grantor. Maybe a child could be in that, serving that role, or an independent trustee. If you're looking at it particularly for asset protection in the event of long-term care, that trust, that irrevocable trust, has to be funded for at least 5 years before applying for Medicaid, because that is a transfer that's subject to a penalty if you apply for Medicaid within that 5-year time frame. I tell clients, think of these types of trusts as a gift trust. It's kind of, you're setting this aside for the benefit of your children or whoever you want your beneficiaries to be. You are not a beneficiary of this trust, except that you can keep the right to live and occupy in the house and have the use and enjoyment of the property. So think, long and hard before you fund that trust, because putting a house in there for most people, that doesn't affect their daily lifestyle. They still live there. They have the full use and enjoyment of that property. Putting money in there is a whole different story. And they may say, I don't want to ask my kid to give me money if I need it. And that's a personal choice, but that's something that we want to make sure the clients understand, that they're giving up some control. And that's really the trade-off on asset protection, is you've got to be willing to give up some control, let someone else be in charge. Special needs trust, we've already talked about that. We use that a lot for clients who are under 65. It's a great way to protect those assets for their lifetime. And then lastly, testamentary trust. This is also very important. We see a lot of clients, and maybe you do have a spouse that is having difficulty, but fortunately they're able to live together and care for each other. But this spouse says, you know what, I know when I'm gone that my wife is not going to be able to care for herself, and but we want to protect that. But we also realize the reality is we're probably going to end up having to have a nursing home at some point, because she needs 24/7 care. How can I protect what we've accumulated for her and for our children from complete depletion? Well, one way that can happen is you can have a will that creates a trust for the surviving spouse. Now, it has to be a special needs trust for that surviving spouse, and it's to be used for her extra and supplemental needs that aren't being provided for through governmental benefits. So, great way for these spouses that are concerned, how is my spouse going to be cared for after I'm gone, to provide for that spouse, to enhance the quality of that spouse's life. There is not a payback for these. So that's a good news too, because they can state that at that spouse's death, whatever remains goes to children, whoever. So lots of good planning options. We always encourage our clients, let's talk about what all of these are. It's not a one size fits all. Depends on your individual circumstance. But when that can be done and incorporated within the estate planning, I think it's critical to having a successful outcome. So trusts, as we've already talked about, serve a lot of different purposes besides just asset protection. Financial management, obviously, that's a big deal. We're seeing more and more seniors that they're still competent, but frankly, their judgment's impaired. They're making crazy decisions. I get calls every week. I get a call. I just got a letter that I had a cousin in England I did not know about, and they have left me a large sum of money. And I would like for you to investigate this and go get this money for me. And I mean, they're so gullible. And so this helps to have a person, maybe a child, to be able to kind of oversee that and making sure that they're not being taken advantage of, and making sure their bills are being paid, protecting them from creditor claims, avoiding probate. That's a big deal because many clients want to maintain their privacy. They don't want to have to go through a probate process. We've already talked about the public benefits qualification piece and the undue influence, making sure that that person who's their best friend is not taking them to the bank and taking all their money. Well, if it's in a trust, it's a lot harder for them to do that, because typically in that case, the client may not be the trustee. So that really helps lock that down to protect that. Federal and estate tax planning. Again, right now we've got a large exemption, $11.7 million a person. So it doesn't affect a lot of folks, but it does affect some. And so this is important to be able to take advantage of that if your clients are in that type of net worth situation. And then finally, succession planning. We use this a lot when we have family businesses that they want to keep in the family, and but yet they want to have some continuity where you have one person in charge instead of multiple people in charge. It's great for succession planning. So lots of great options for trust in the event that you have a client that has a need. All right, I'm going to turn it over to Sarah now, because she's going to talk about the gray divorce, because that's something we're all seeing, and I'm weekly we're seeing this. So I think you're going to see more and more of this in your practice.
Thank you, Nancy.
Mhm.
So yeah, senior divorce is a little bit different than most of the divorce cases that we're familiar with. Like Nancy said, it's really used mostly in crisis planning, which means that, you know, like Frank and Edna, the person is one of the spouses is in a nursing home, and we need to do something kind of quickly to help preserve their assets, and some of the other options might not work. And of course, the main significant factor is health of one of the spouses. And you know, it's a tough situation. Unlike most divorces, they love each other and nobody wants to get divorced. And it's not, but it's a matter of the illness making it difficult for them to stay together. Of course, the long-term care costs are obviously the problem, because as Nancy described, the costs are terrible. And so they will not, the concern is that the healthy spouse will not have money to live on. And so divorce may be the way to preserve a lot of their assets. And then of course, in addition, they won't be able to qualify for Tenncare because of the couple's assets together. And so, you know, sometimes divorce is an option which will allow for the well spouse or the community spouse to preserve something for herself or himself, as well as for the children. And as this is noting, particularly in a second marriage later in life, you know, divorce may be a really good option. And we'll talk about that a little bit. And Nancy's already talked about the different ways to pay for long-term care, so I probably don't need to go back over that. But let's get back to Frank and Edna. So obviously, if instead of the $350,000 liquid assets that they had in our original hypothetical, if we say that they have $100,000 in an IRA and a farm worth $200,000 or more, and so this is the new part, because obviously their house was not a countable asset, but now we have a farm that's worth $200,000 or more and $50,000 of cash. And so in this case, when we're looking at it, divorce may be the better option rather than them being forced to sell the farm or other, you know, real estate and incur the capital gains taxes and et cetera. Right?
Yeah, right.
And so we'll look at that, how that actually plays out for them a little bit more. In terms of how the Medicaid divorce works, it's intended, of course, to protect the assets of the spouses. Usually you wouldn't be looking at a Medicaid divorce unless they had more than $500,000 in assets or something similar to what Frank and Edna have. One thing that's important to note, us divorce lawyers, we think about, okay, that's a marital asset and that's a separate asset. But when Tenncare is looking at it, Tenncare says it doesn't matter whose name this real estate is in, who's owned it, whose family asset it is, where it came from, and they don't care about the prenuptial agreement either. So they're going to look at the couples, everything that they own because they're married.
And that, Sarah, I would say that is one of the things when I have clients that come in and they're, in their 70s and they're going into a new marriage situation, a whole different issue than when they're in their 30s or 40s. And we have that discussion about, do we want to go ahead and set up an asset protection trust now for the family farm,
right,
or something, so that we're not going to have to go through that divorce later. We'll have that already nailed down and at least address as to who's going to provide for care.
right.
Because that is always an issue, because the kids of those spouses come up and say, wait a minute, we're not paying for this lady's care. We've only known her for 2 years.
Right.
So addressing that through the prenup as well as a trust, it will save a lot of problems in the future.
Right. And I think that's something that maybe, when family law lawyers are looking at this, you might not be thinking about Tenncare. And so it's important to note that the prenup is probably not quite enough in certain circumstances. You need to inquire into the health of the people that are coming to see you. And of course, we've already talked about the look back period, and the age is important because you could do some transfers and things into trust. And if it's not within the 5-year period, then Tenncare's not going to look at it. And one thing is just, and Nancy has had many of these difficult conversations, but counseling someone to consider divorce to stave off financial ruin is very difficult. And I've been in conversations with Nancy and someone that we say, look, the only way we can really qualify your husband for Tenncare is that you're going to have to get divorced. It's really difficult, and you have to have a hard conversation, but at some point, because of the financial nature of what we're talking about, they understand that it's just a paper divorce, I guess, not in their hearts.
Right.
So obviously we've talked about this a little bit, but second marriages in particular would be a case where you might have a Medicaid divorce, and they lend themselves to this, and you'll see that when you're doing these divorces, they're essentially uncontested divorces. However, when you're looking at the marital balance sheet and how the court is going to divide the assets, the court still needs to take into account what's fair, particularly when you have a spouse that is in a nursing home, or maybe even does not have the capacity to understand the divorce and approve it. And so second marriages, you have a lot of separate property coming into the marriage beforehand, not marital property. It's very easy to see how the divorce could be divided. And also, if the couple has a lot of retirement assets that we can't deal with the other Medicaid planning strategies, then divorce may be important. Or if there's a big disparity of wealth between the spouses, someone has a lot of inherited property or something like that, then divorce may be a good option for them. So here's just a new couple, Harry and Wanda. They got married late in life, and this was their second marriage, and both had children from prior marriages. And they want their children to inherit from each of them. So they signed a prenup to keep their property separate. So that would certainly protect them, obviously, in the case of divorce or death. But unfortunately, Harry was diagnosed with Alzheimer's. And so his medical bills piled up, his condition was getting worse, and Wanda was no longer able to care for him at home. And he needs to go into a nursing home. And in this particular case, divorce is something that they would probably consider as one of the options that they might have, because both of them want to protect their separate property. And as we said before, when Tenncare looks at it, the Tenncare doesn't care what the prenup says. It doesn't care who brought it to the marriage or how long they've been married, anything like that. So then the question becomes, okay, what if you've got an incapacitated spouse like Harry? In that case, he's got Alzheimer's, and so he cannot participate in the divorce, sign off on the documents that would be needed to do an uncontested divorce. Then what we do and what's necessary is that you need to have a separate attorney for the incapacitated spouse. And in addition, most of the time, there will be a guardian ad litem involved. The judge may appoint one in the divorce case, or you may also need to do a conservatorship, which we will talk about separately. And obviously, we usually the Medicaid divorces are done prior to the application for Tenncare, because when you present the application to Tenncare, you want to have everything from a standpoint that the spouse, the person in the nursing home, their assets are divided and theirs. Is that right?
Right. You want to have a final order.
It's also important to have immediate family members to be informed and on board with the Medicaid divorce, because you certainly could have a problem, especially in blended families, if they saw their stepmom divorcing their dad or something of that nature. So generally, we see that in these cases, there will be a need for conservatorship. Now, if you had a power of attorney, we've dealt with this recently. If there was a power of attorney in place, obviously the power of attorney could not be with the spouse that is divorcing. That I don't think that would work. But most of the powers of attorney that we see have a backup person that can be appointed, and usually it's one of the children or something like that. And so it is possible that you could use the power of attorney, assuming that it had the normal powers, that power of attorney could step in the place of the incapacitated person. That might not necessarily mean that a guardian ad litem wouldn't be appointed by the court, in the divorce, just to make sure that somebody has a neutral person has looked over everything. But if there is no power of attorney, or the power of attorney is only for the spouse, then obviously we're going to need to get a conservatorship. And I'm sure most of you are familiar with how conservatorships work, but you need to show by clear and convincing evidence in the conservatorship that the person is fully or partially disabled and needs assistance from the court. And usually that's done by a medical affidavit. It's a form that the doctors are used to filling out. You file that with your petition if you can get it before then. The court looks at to the best interest of the respondent, which is the person that is incapacitated, and we'll try to impose the least restrictive alternative when determining the type of assistance imposed. And a conservatorship it's basically two different parts. You can have a conservator over the person, or a conservator over over their financial property. And I would say in most of the time in divorce cases, you're going to see just a full conservatorship granted.
Right.
Although, the thing is that the conservator will not be the spouse that is divorcing. So that's something to think about, is who is the conservator going to be, and typically it would be a child, right?
Yes.
So, these are things that when you're thinking about whether a divorce is the thing to do, well, okay, who are we going to get as the conservator? Are the children on board with this? Do they understand it? And do we have a child that could be the conservator? Obviously, the orders are very specific in conservatorships to make sure that the conservator has the proper powers, and that why the conservatorship is needed and who is appointed in that role. More conservatorship requirements, obviously, and there have been some recent changes to the conservatorship requirements, or actually they're going to happen in January. And so it's important to note that, because it is different, and we've all got these forms that we need to update. Obviously, the petition must state if the conservator had any felony or misdemeanor convictions. I don't think that's new, but the part that is new is that you need to include copies of the following, which is a search of the Department of Health's Register of Persons who've been abused or neglected, showing that this conservator does not appear on there, and also a search of the National Sex Offender Registry. And so as of January 1st, 2022, we need to include that as part of our conservatorship documents. And then I talked about the sworn medical report that needs to be conducted within 90 days of the filing of the petition. Sometimes you have an instance where maybe you can't get the person to the doctor, or they just won't cooperate. They have some sort of, disability that doesn't allow them to get to the doctor, or you to take them. And so the court can order them to be submitted to submit to a medical examination. And but normally we would have that sworn medical report as we file the conservatorship. The other requirements are that a guardian ad litem should be appointed unless waived by the court. Here in Madison County, I think that Judge Little pretty much always appoints a guardian ad litem no matter what. And we've got really good guardian ad litems that do an excellent job and provide reports to the court regarding what's going on. I think that when you're talking about a divorce of this nature, the guardian ad litem is important to understand the process and understand why financially this is in the best interest of the respondent.
And the proposed allocation of assets and the marital dissolution agreement obviously needs to be incorporated within that property management plan too, so the court understands how that works. That's one of the things you may be going to comment on that in a minute, is how does that interplay between the conservatorship and the court there and their authority to determine what's approved on property management and the marital dissolution agreement, and that being approved by Chancery Court.
Well, and the guardian, the problem with Tenncare and getting approved is that we've got to get that person down to having only $2,000 in assets.
Right.
And so, it's hard when you're looking at a marital balance sheet or some kind of marital dissolution agreement that all of the assets are going to the well spouse. And how does that fit into what's supposed to happen in a divorce case? And what happens if we take away all their assets and then we can't get them approved for Tenncare? And so these are things that you really need to have. If you have this type of situation, you need somebody who has some knowledge and understanding of how Tenncare is going to work to make sure that we're providing for them. How long is it going to take to get approved by Tenncare? Are we going to be paying the nursing home bills in full while we're waiting for the Tenncare application to be approved? Or is there going to be a penalty period, and therefore we are going to be paying in full during that time? So you've got a lot of different considerations, and they're highly fact-based, financial-based. And so you need the guardian ad litem needs to understand that, the court needs to understand that, and all of the divorce documents need to be out there for everybody just to look at and understand. The conservator could consent to the divorce on behalf of the incapacitated spouse. Obviously, that's why we're doing the conservatorship, is that they take on the role of the incapacitated spouse. And the conservator needs to ensure that the rights of the incapacitated spouse have been protected, but adequate provisions have been made for his or her needs and well-being. We mentioned that pending the eligibility, and there are several different things that you can put into the MDA to do that kind of protection. Some of those relate to, I don't know if we have a slide on any of these, but some of those relate to setting up a trust, or just having the well spouse continue to pay for the nursing home treatment or nursing home costs until the incapacitated spouse gets approved.
That's a very important feature, because we have a lot of kids, we'll talk to them about, will you serve as conservator? And they're saying, so what if Medicaid doesn't get approved? And then we get a call from the nursing home that says, come get your mom, or come get your dad. And I'm not prepared to do that. I don't even live in Tennessee. So they're very concerned. And so, like you said, Sarah, that's something that can be addressed in the marital dissolution agreement, that until Medicaid is approved, that there will be a funding source to pay for that care. And even if Medicaid is, if it's denied, that could take a little bit. So you do want to make sure that's addressed, because you can imagine these conservators, especially the children, are somewhat reluctant because they're afraid they're going to be faced with the financial responsibility for the care of their parents.
Right. And this slide, I think, talks about, the divorce needs to be real, not a sham divorce, in the sense of the equitable nature and the distribution of the assets. And that's why a second marriage really lends itself for this kind of discussion, because you do have a lot of separate assets that would not be considered marital assets. And so it's easy to equitably divide out the separate property. And then, that lends itself for a Medicaid divorce. And obviously the well spouse needs to understand that the settlement must be fair. Even though, they want to protect as much of their assets as possible. One of the problems is that if we just did a divorce, we said, okay, the institutionalized spouse gets $2,000 and the other spouse gets everything else. One of the problems that you would encounter, even if all the family thought this was a great idea, the judge thought it was a great idea, the problem you might have is that Medicaid would think, hey, we see what you're doing. Right. And so that's why you need to have a fair divorce that is an appropriate financial settlement between the parties, because Medicaid, it's no different than transferring all your assets or gifting out everything. And so this really needs to actually make sense, especially, I think that's why it takes us back to that separate property in a second marriage or something, or later in life, like over 70 or something. There are other things that you need to worry about. Divorce can impact the supplemental security income, Social Security, retirement benefits, survivor benefits, veteran benefits. So you should take that into account before you say, okay, well, divorce is the way to go, because it certainly could take that away. We've got you've got other issues. I know that this is sort of a little bit outside the topic, but you've got people that are sometimes in need of a divorce due to health insurance problems. There are all kinds of different things that could lead to something similar in nature to this kind of divorce. Obviously, the marital dissolution agreement is important, and we talked about this a little bit. That as Nancy said, setting up a testamentary trust might be a thing that you would do in the marital dissolution agreement. And you want to speak about how that would work?
Yeah, so like you could have it in the marital dissolution agreement that the spouse, the community spouse, would establish a testamentary trust, a special needs trust for the spouse in their will. And that could just be part of the divorce settlement, that would be established for the benefit of that spouse to provide for their extra and supplemental needs. And that's a great way, because at that point, that spouse is not competent, even if the court allocated assets to them, they're not competent to manage it. So this is a great way to preserve that for them, for their quality of life, and have a trustee to manage that for them. But it does not force that all has to be spent down to $2,000. So we use that a lot with spouses.
And so the testamentary trust would not disqualify them from Tenncare at that point.
That's right.
And I think that's a good way, and the court can see that that's a good way to continue to provide for them, because that's something that everybody wants to do, is to make sure what happens if the spouse dies, or the ex-spouse at that point. Also, income producing assets could be something, because income is treated differently by Tenncare. And so you could have that. And then we talked about this one, alimony, which would be until they qualify for Medicaid. And so, or payment of costs if they do not qualify for Medicaid. And other benefits such as long-term care insurance could also be something that the other spouse could purchase for them.
Right. And one other thing we see, if they're not able to get long-term care insurance at that point, you have life insurance that you could transfer the ownership of that life insurance to the institutionalized spouse. If it's a term policy, then it has no cash value. So it's not an asset as far as Medicaid is concerned. So that's a good way to say, okay, we've got this life insurance. Maybe it's on the healthy spouse or maybe on the unhealthy spouse. It doesn't really matter. But the point of it is, at the time, if it's a term policy, it's not a countable asset, and it can provide a means to replenish costs that have been incurred to make provisions for that unhealthy spouse's children, beneficiaries, that kind of thing. So it's a way to replace the money that's been spent.
Right, and obviously you're saying it, but if you purchased any kind of insurance, life insurance, and it had a cash value,
then that's a problem.
That would be a big problem, and that's something that you're often having to spend down.
Right. That's a great point, because life insurance, people kind of look at that like that's not really an asset because I don't have it in my hand yet. But the reality is, it's countable asset if you can cash it out in 30 days. And if you have a life insurance policy with $20,000 of value in it, you could do that. So therefore, these people who paid their entire lives on a life insurance policy, they get to the end of their lives and they're forced to cash that policy out. So those are really big points that you want to consider. I would encourage you that if you're not comfortable with all the nuances of elder law and Medicaid planning, please, please, please consult with an elder law attorney, because like Sarah said, it can be financially devastating. This is not an easy process. Typically, the application and approval process of Medicaid can take 6 months, sometimes longer. Sometimes we'll have it be a shorter time frame, but particularly when a divorce is involved, there's a lot of assets. You do not want to have a misstep. So,
and obviously, if anybody has any questions, I don't know if any came through Andy, but we're happy to answer them, or you can contact us if you'd like to.
yes, feel free to email us.
There have not been any questions. I'll give it just a minute, see if any come in.
I think it was just because we were so detailed.
That's right, we were thorough.
There are never any questions.
Well, I'm not seeing any questions, so thank you all so much for your presentation. It was great, and we will now move on to our 15-minute break, and we will start back at 10 a.m.
Thank you.
Thank you. One chat.
All right, everybody, we will go ahead and get started with our next presentation. Next up, we have Stephen Christopher, who is the Deputy Chief Disciplinary Counsel at the Board of Professional Responsibility. So Stephen, you can go ahead.
Thank you very much. Let me just take a moment and attempt to share my PowerPoint on the screen. Okay, is the PowerPoint presently on the screen?
It is.
Thank you. So this is my short bio. My present role at the Board of Professional Responsibility is that I supervise and manage the investigations section, and we handle the processing of disciplinary complaints from the initial filing of the complaint until a recommendation is made either to a hearing committee member or to the board, either for the dismissal of the file or some level of disciplinary action. I've been at the board for about 6 years. Prior to that time, I was an attorney at the Legal Aid Society of Middle Tennessee and the Cumberlands for about 12 years. Much of that time was managing one of the offices of the program. So this presentation is going to be an abbreviated version of the 3-hour presentation that we normally do on trust account management practices. So we'll be dealing with the following 4 topics. I'll be talking about some general principles regarding attorney trust accounts, and then providing some suggestions as far as the establishment of trust account management protocols. We'll be dealing specifically with issues regarding attorney fees and client case expenses, as that subject intersects with attorney trust accounts. And then we'll finish up with hypotheticals. Will there be an opportunity for participants to raise questions either through the chat function or otherwise?
Yes, I will monitor the chat function, and I'll bring those up whenever they come in.
Thank you, and feel free to interrupt me at will if there are any questions that come up. I do want this to be as productive a time as possible, and certainly if someone's raising a question, it's probably a question that a number of other participants also have. So the overall focus of this presentation is going to be how to avoid negligent errors in connection with maintaining an attorney trust account. I'll be dealing briefly and referencing the misappropriation of the funds of clients and third parties, but that to a large extent will be outside the scope of the presentation. So to begin with some general principles, the definition of a trust account. A trust account is any bank account maintained incident to a lawyer's law practice where the lawyer holds funds received as a fiduciary on behalf of or belonging to a client or third party. There are 2 particular types of trust accounts, which we'll be getting into in detail a little bit later. When we use the term trust account in common parlance in the practice of law, we're generally referring to one of the 2 major types of trust accounts, and that is an IOLTA account, or interest on lawyer trust accounts. The second type of trust account is just a general trust account that's maintained for a particular individual client. But the principal rule of professional conduct that we'll be traveling under is Rule 1.15. 1.15 generally governs attorneys' obligations whenever they hold possession of any property or funds on behalf of clients and third parties. And comment 1 to Rule 1.15 makes it clear that anytime an attorney holds any property on behalf of a client or a third party, they do so and are required to do so with the care of a fiduciary. So anytime you hold any client property or property of a third party, whether it's funds or otherwise, you are required to do so with the care of a fiduciary. So Rule 1.15 also applies, for example, to the client's file, since the client file is the property of the client. A lawyer is required to have a trust account whenever the lawyer receives funds in a fiduciary capacity in the context of their law practice, and they must have access to the trust account before receiving the funds. There are attorneys, depending upon the nature of the attorney's practice, that are not technically required to have a trust account as part of their law practice. For example, if lawyers in their practice contract with their clients solely using non-refundable fees, as we'll also get into later, are earned upon receipt, then the attorney would be prohibited from placing those funds into a trust account. The lawyer is only required to have a trust account if the lawyer receives funds either from a client or a third party that are not earned by the attorney upon receipt. And these are examples of the types of funds that need to be deposited into a trust account. Number one, principally attorney fees that have not yet been earned. Number two, prepaid discretionary expenses and costs. An attorney is permitted to prepay discretionary expenses and costs to a client. And if a client is indigent, the attorney is actually permitted to, or the firm is permitted to actually pay those discretionary expenses and costs without the client being responsible for those expenses. Number three, any other funds received from clients or third parties that are going to be held on their behalf. And this is the comment that I cited earlier, that a lawyer is required to hold the property of funds of clients or third parties with the care of a professional fiduciary. Trust accounts are also required to prevent commingling. Rule 1.15a provides that anytime a lawyer holds property and funds of clients or third persons, that those funds need to be held separate and apart from the lawyer's own property and funds. This is one of the principal reasons why a lawyer has to have a trust account. Without a trust account, the lawyer would be required to commingle those funds into the firm operating account or other account. It's not required that lawyers who practice in a firm maintain a single trust account. That is the discretion of the lawyer and the discretion of the firm. So multiple trust accounts are permissible. For example, if lawyers practice in a firm and there are 3 lawyers, each lawyer could have their own separate trust account. However, having one single firm account is preferable to individual accounts for good oversight and good internal controls. We run into a number of circumstances here at the board where we have perceived that difficulties have arisen, or there's been overdrafts and other errors made by trust accounts where you have a firm that has separate trust accounts rather than one single trust account. It makes it more difficult, makes it more likely that there are going to be inadvertent bookkeeping errors. Anytime a lawyer receives funds or other property in which a client or third party has an interest, the lawyer is first required to promptly notify the client or the third person, and unless agreed upon otherwise, deliver to the client or third party the funds that the client is entitled to receive. So for example, if a lawyer is handling a personal injury matter on behalf of a client and the settlement funds come in, the lawyer is required to promptly notify the client and any third persons that are entitled to a portion of the proceeds, such as parties or entities with subrogation interests, and unless otherwise agreed upon, promptly deliver those funds. This obligation not only corresponds to Rule 1.15d, but to the extent that the lawyer is acting on behalf of a client, the duty to do so also implicates the lawyer's obligations under Rule 1.3, which is the general duty to provide diligent representation to the client. So if a lawyer settles a personal injury matter and the lawyer delays unreasonably in the transmittal of those funds to the client and to any third parties, the lawyer has not only violated Rule 1.15 subsection D, but Rule 1.3, the duty to provide diligent representation. Now, if there's a dispute in the ownership of those funds, the lawyer is required to maintain those funds in the trust account until such time that the dispute is resolved. But if there's any undisputed portion, that needs to be immediately released. Now, this dispute could involve a dispute between the lawyer and the client, as well as a dispute between the client and a third party or between two third parties. In the event that the lawyer and the client have a dispute, the lawyer is required to seek prompt resolution of that dispute. That also corresponds not only to Rule 1.15, subsection E, but also the lawyer's obligations under Rule 1.3. In the event that the dispute is not resolved informally between the lawyer and the client, or between the lawyer and a third party, or between two third parties, if the lawyer is not able to resolve the dispute, then the last resort, so to speak, is for the lawyer to interplead the funds, and that would require the filing of an interpleader action in a court of record and depositing the funds with the court, and then ultimately it would be the court's decision as far as the disposition of the funds. And in the event that there are third parties, such as creditors that have just claims against trust account funds, the lawyer may have a duty under applicable law to protect such third party claims against wrongful interference by the client. Rule 1.15 subsection F was recently added to Rule 1.15. So this is a recent amendment to Rule 1.15. And 1.15F was added to address a growing circumstance where attorneys were discovering that when they were attempting to reconcile their trust accounts, that there were unidentified funds, that is, funds where the lawyer was unable to locate the owner of the funds. 1.15F does not apply if the owner of the funds is known, but simply can't be located. So in a circumstance, if a lawyer settles a personal injury action and is obviously aware of the client's identity, but the client doesn't respond to the lawyer's phone calls and other notices that the funds are ready to be picked up, this rule 1.15F does not apply. 1.15F only applies if the owner is not known. The most common circumstance where this was arising is the circumstance where a lawyer was in the process of retiring, and as they were finishing up the client matters, they discovered that in reconciliation of their trust account that there were unidentified funds. So in the event that the owner of the funds cannot be identified, the lawyer is required to remit the funds to a state Supreme Court agency called the Tennessee Lawyers Fund for Client Protection. The Lawyers Fund for Client Protection is a Tennessee State Supreme Court agency. We work closely with the Lawyers Fund for Client Protection and act in an agency capacity to administer and process the Lawyers Fund claims. The Lawyers Fund for Client Protection, the purpose of this agency is to monitor a fund that's available to provide remuneration to persons that have been financially harmed by an attorney's dishonest conduct. The Lawyers Fund for Client Protection is governed by State Supreme Court Rule 25. So the standard for recovery is very narrow. You notice that the standard is dishonest conduct. So if a client is financially harmed by an attorney's negligent conduct, it's not going to trigger a Lawyers Fund for Client Protection claim. Generally, we're looking at circumstances where a lawyer has stolen money from the client. And the money that the Lawyers Fund for Client Protection obtains to disperse through their fund, they obtain through a small portion of the money that's available. Not the biggest source of the fund is a small portion of the money that we pay as licensed attorneys for our registration fee to our office, to the board. A small portion of that $170 a year goes to the Lawyers Fund for Client Protection. So under new Rule 1.15F, this will supplement the funds that are available in the Lawyers Fund. As I mentioned, 1.15F does not apply where the owner of the funds is identified but cannot be located. If you are aware of the owner's identity but cannot locate the owner, the lawyer is first required to exhaust reasonable efforts to locate the whereabouts of the owner of the funds. And then only if the whereabouts cannot be located, if you're not able to locate the client or third party, then you're required to proceed under a Tennessee statute governing abandoned property. And this is the citation in the Tennessee Code Annotated. And this is confirmed at comment 14 to Rule 1.15, the need to proceed pursuant to this statute. These are the two principal types of lawyer trust accounts. As I mentioned, when we use the term trust account in the practice of law, we're generally referring to the second type, and that is IOLTA, the acronym for Interest on Lawyers' Trust Accounts. The second type of trust account is simply an individual account that's created for a specific client. And the key distinction between an individual trust account and the attorney's IOLTA account is that in the event that funds are obtained from a client that are going to need to be kept in trust for a significant amount of time and or are of such a significant value that they're going to likely draw a significant amount of money for the client, then the lawyer is required to establish an individual trust account for that client. If the funds are only nominal in amount and or are only going to be held for a brief period of time, then they must be deposited into what's referred to as an IOLTA account. We'll be talking more about IOLTA in a few minutes. Rule 1.15b concerns or governs the requirements for both types of trust accounts. Either type of trust account must be maintained in a financial institution, the deposits of which are insured by the FDIC or NCUA, having a deposit accepting office in the state where the lawyer's office is situated. Any trust account shall be maintained only in financial institutions approved by our office. And this is stated at Rule 9, Section 35.1. Rule 9 of the State Supreme Court rules generally governs disciplinary enforcement by our office. Our website maintains a list of approved financial institutions in the event that you are shopping around for a new trust account. And the financial institution where the trust account is maintained must participate in what's called the overdraft notification program. And the overdraft notification program provides that the financial institution agrees that as a condition of maintaining trust accounts in accordance with Rule 9 of the State Supreme Court rules, that they will send notice to our office anytime there's an overdraft or insufficient funds notice. And additionally, the attorney under Section 35.01 contractually agrees as a condition to establishing that account, agrees that that notice will be sent to our office. So anytime there's ever an overdraft or an insufficient funds notice on your trust account, either an individual trust account or your IOLTA account, notice is automatically sent to our office. We will initially do a review of the circumstances of that overdraft or insufficient funds notice. I do the initial review of those notices and determine whether or not to open an investigative file. And if an investigative file is opened, it will be assigned to disciplinary counsel in my section, who will look at whether or not Rule 1.15 or of the rules of professional conduct or other rules were violated in connection with that overdraft. In other words, we'll be looking at whether or not the attorney and or their office was negligent in the handling of funds that led to the overdraft or insufficient funds notice. As I mentioned, the attorneys will be deemed to have consented to the overdraft notification program. And as I also mentioned, that can potentially lead to investigation. If an attorney establishes any trust account, the account must be unequivocally identified as a trust or escrow account in the title of the account and on all the checks. And the attorney must take all steps necessary to inform the depository institution of the purpose and identity of the accounts. This is a relatively recent change to Rule 1.15 as well. And that is under the prior rule, attorneys were able to deposit a certain amount of funds into their IOLTA account, into their trust account, to ensure that there was not an overdraft. That is not the case anymore. The attorney is able to purchase, and in fact, it's encouraged that attorneys purchase overdraft protection with their financial institution. However, the attorney is not able to maintain a certain amount of funds in the IOLTA account to prevent an overdraft. The only exception to the general rule that the attorney's own funds may not be deposited into the account is that the lawyer may deposit funds to pay financial institution service charges or fees. So the lawyer is required to confirm the amount of those administrative charges that are going to be charged by the financial institution and only deposit those funds and not additional funds. Rule 1.15b also requires that a complete set of records on any trust account shall be kept by the lawyer and preserved for a period of 5 years after termination of the representation. Those records may be preserved in digital form only. It's not required that they be preserved in tangible or paper form. So an individual trust account should be established only if the funds at issue are of an amount or expected to remain for such a duration that it's going to earn the client money. And that interest that's earned shall belong to the clients or third persons, and the lawyer is not able to claim any right to any interest that's drawn. Now, most attorneys who handle funds of clients or third parties will only be required to establish an IOLTA account. Most attorneys in their practice who have to maintain a trust account will simply never be in a circumstance where they will obtain funds from a client that are of such an amount or are going to be maintained for such an amount of time that it would be prudent to establish an individual trust account. This is particularly the case because if an individual trust account is established and the funds are going to be invested to draw money, then the attorney can certainly charge whatever reasonable fee that the attorney needs to charge to maintain that, to facilitate that account, as well as the services of a financial professional. An IOLTA account is referred to as a pooled trust account. So anytime that the lawyer does not establish an individual trust account, which, as I mentioned, most attorneys who hold client funds will only be dealing with IOLTA accounts. In such case, the lawyer is required to deposit all funds of clients and third persons into their IOLTA account. In the significant difference is that the interest cannot accrue to the benefit of the client or the third party, and certainly not the lawyer. IOLTA accounts are governed by Rule 1.15b, subsection 2, as well as by State Supreme Court Rule 43. And these are, again, the primary factors that are going to determine if the funds are going to be deposited into an individual or IOLTA account. The comments to Rule 1.15 do indicate that no disciplinary action is going to arise if the lawyer makes a good faith determination, for example, that funds should simply be deposited into their IOLTA account rather than an individual trust account. That's something that's going to be left to the attorney's discretion. The Tennessee Bar Foundation acts as the administrator of the IOLTA program, and the Bar Foundation determines whether a financial institution is an eligible institution that meets the requirements of Rule 43. So again, our office has discretion to determine what financial institutions generally may provide trust accounts, but only the Tennessee Bar Foundation can determine whether a financial institution is an eligible institution that meets the requirements of Rule 43 and states and the Rule of Professional Conduct 1.15, subsection B, subsection 2. There's a list of eligible financial institutions on their website in the event that you are looking for a new bank. So unless the attorney is exempt, an attorney admitted to practice is required to certify their IOLTA compliance in their annual registration statement, disclosing the financial institutions where any IOLTA funds are held. And this remains confidential. An attorney may be administratively suspended for non-compliance with their IOLTA reporting requirement in the same manner that an attorney may be administratively suspended for other reasons, for example, for non-compliance with their ongoing registration requirement and payment of their registration fee, for non-compliance with CLE requirements, etc. The interest that's drawn from attorneys' IOLTA accounts cannot accrue to the benefit of the client, third party, or the lawyer. Instead, it's distributed by the Tennessee Bar Foundation for the following purposes. Number one, to provide legal assistance to the poor. The LSC grantees are one of the main beneficiaries of IOLTA funds, also to provide student loans, grants, scholarships, etc., to deserving law students, and to overall improve the administration of justice. Are there any questions so far before we proceed? Okay. We'll move on to some general suggestions for trust account management practices. Rule 1.15 generally requires that the attorney or their firm establish and maintain effective trust account management practices, internal controls to prevent negligent bookkeeping errors and to prevent misappropriation of funds. Attorneys may be subject to discipline for violation of 1.15 and other disciplinary rules, even if bookkeeping errors arise only negligently rather than through intentional misappropriation. And this also implicates the disciplinary action for breach of a lawyer's managerial responsibilities. Lawyers with managerial authority over a law practice, and this is most commonly thought to apply to large and mid-sized firms, but it also applies to a solo practice. If you're a solo practitioner, then you're required in the same way as a mid-size or a large firm to establish and maintain protocols to ensure that your office complies with all of the rules of professional conduct, and that certainly includes trust account management. A lawyer may delegate duties to support staff that do not constitute the practice of law. However, under Rule 5.3a, the lawyer is going to be vicariously liable for the conduct of support staff to the extent that the lawyer directs the conduct, ratifies the conduct, or fails to take proper remedial action. And also under Rule 5.1c, the lawyer is similarly vicariously responsible if the support staff or a subordinate attorney violates the rules of professional conduct, and that arises out of a failure to create and maintain proper internal protocols, and that certainly applies to trust accounting. Rule 1.15 of the Rules of Professional Conduct and Rule 43 do not create any or do not necessitate the creation of specific types of trust account management systems. For example, even though it's the growing norm for an attorney, a law firm to use an online software program, there's nothing in the rules that prohibits an attorney from still using a conventional written ledger system, as long as the attorney has established and maintains protocols to ensure that the good bookkeeping practices are maintained. This is a formal ethics opinion that contains a summary of best practices. This does go back over 30 years, so it reflects a pre-internet world. However, the suggestions that are made are still very sound. Whatever system is chosen, the lawyer must understand how the system works, how records are going to be maintained. So that means that if online software is going to be used rather than a conventional management system, the lawyer must understand how the system works and how records are going to be maintained. This may require consultation with an IT professional, only to the extent that the lawyer can be sure that the software that's chosen is going to facilitate good bookkeeping. The cardinal rule in avoiding theft or misappropriation of funds is to divide the monetary functions in a law office and in the regular reconciliation by a lawyer or an additional staff person and or an independent auditor on a monthly basis. So an employee at the law office, other than someone who regularly handles trust account funds, should regularly review those online. The bank statement should be delivered unopened or directly by electronic transmission. So these central suggestions reflect the fact that many of the errors that occur either negligently or certainly this applies to misappropriation of funds occurs when there's only one person with access to the trust account. If there's only one person with access to the trust account, that can often facilitate circumstances where there's misappropriation of funds. And regarding the suggestion that bank statements should be delivered unopened or directly by electronic transmission, there actually have been circumstances where a lawyer will review the bank statements when they arrive through regular mail, but there were circumstances where a support staff person was actually forging those bank statements and then providing the forged statements to the lawyer while misappropriating funds. So some additional suggestions. Certainly complete appropriate vetting of all new hires and provide effective training and supervision. Take disciplinary action when appropriate. Certainly if there's a circumstance where there is a support staff person who makes a single bookkeeping error and that results in an overdraft, certainly mistakes are going to be made, whether they're made by an attorney or a support staff person. One single mistake is not going to necessitate disciplinary action, but that would require follow-up training. And then if there are recurring errors made by that support staff person, that may create the need for disciplinary action. So for example, if there was an investigative file opened by our office and it turns out that there was a support staff person who had made repeated errors and no effort was made to provide additional training and supervision to that support staff person, that could lead to vicarious discipline against the attorney or attorneys with managerial oversight over that office. The management system has to facilitate good communication between lawyers and support staff. That's crucial to any good system. And these are some additional suggestions, and these come from the formal ethics opinion that I cited. Lawyers should take particular care to review the trust account bank's procedures and practices, including the imposition of charges. We do see some overdrafts and insufficient funds notices that arise, for example, from something so prosaic as a lawyer who opens a new account not knowing whether, for example, the first initial order of checks is going to be deducted automatically by the bank against the trust account balance, or whether that has to affirmatively be paid by the lawyer. Those are the kinds of details that the lawyer with managerial authority has to make sure that they're aware of to avoid overdrafts. And certainly the ultimate risk control mechanism is insurance. If there are occasional inadvertent errors that do not result in harm to clients or third parties, typically this is not going to result in disciplinary action. It's understood that lawyers who maintain a law practice, there's going to be occasional errors that are made, both in trust account bookkeeping, as well as errors in ongoing case management, errors in decision-making with regard to cases and otherwise. So certainly, particularly if there are firms that maintain a very high volume of transactions in their trust account, such as real estate closing firms, personal injury firms, occasionally there are going to be inadvertent errors that are going to result in overdraft notices. As long as it's established through investigation that it was an inadvertent isolated error, there's not going to be disciplinary action. However, if there are repeated errors, or if there is one single error and investigation reveals inadequate bookkeeping, that could be construed to breach the attorney's duties and result in a violation of Rule of Professional Conduct 1.15 and or Rule 5.1. Now, intentional misappropriation of trust account funds by other lawyers or support staff may result in discipline for violation of 1.15 and 5.1. Now this would not, we're not speaking right now about the lawyer's own conduct, but the lawyer's vicarious responsibility for the conduct of other lawyers or support staff. And that would result in a higher level of discipline if it's established that the conduct arose out of inadequate internal controls or the failure to take proper remedial action. If the lawyer herself or himself engages in intentional misappropriation, then that's going to very likely lead to a petition for temporary suspension being filed with the Tennessee Supreme Court by our office, as well as the filing of formal disciplinary charges. And there are several rules of professional conduct that's going to implicate. It certainly will implicate Rule 1.15, but it's also going to implicate Rule 8.4b. Rule 8.4b provides that it is professional misconduct for an attorney to engage in criminal conduct that raises a substantial issue as to the lawyer's honesty, trustworthiness, or fitness as a lawyer. If the lawyer misappropriates funds, then that is criminally actionable, and it's going to implicate Rule 8.4b. 8.4c prohibits a lawyer from engaging in conduct involving deceit or dishonesty. In addition to a petition for temporary suspension, and that's governed by Section 12.3 of Rule 9. One of the grounds for the temporary suspension of a lawyer's license is misappropriation of funds for the attorney's own use. A petition for temporary suspension, if that's granted by the state Supreme Court, will result in the suspension of the lawyer's license while the investigation and subsequent likely formal disciplinary charges are pending. On our website, there is a trust account handbook that's available for free for PDF download, and that contains a number of additional suggestions as far as trust account management. So I encourage you to take a look at this publication and download it for your own use. Before we move on to fees, are there any questions at this point? So we'll discuss now some specific issues regarding attorney fees and client case expenses as those matters are implicated by the or implicated by the topic of maintaining a trust account. So only unearned fees may be deposited into a trust account, And once fees are earned, the funds must be promptly withdrawn from the trust account, and timely notice of withdrawal of funds should be provided. So attorney fees may only be deposited into your IOLTA account if they are not yet earned. Tennessee does permit non-refundable fees. Some jurisdictions do not permit non-refundable fees, but Tennessee expressly does, and that is stated in Rule of Professional Conduct 1.5, subsection F, and is clarified by comment 4A. However, if an attorney is going to charge a non-refundable fee, the attorney must obtain a fee agreement signed by the client, and the fee agreement must expressly state that the fee is non-refundable. The fee also must be objectively reasonable, even if it's even if the client does sign a fee agreement stating that the fee is non-refundable. There are a set of factors at Rule of Professional Conduct 1.5A that are used to determine if a fee is objectively reasonable or not. So at the commencement of the representation, the lawyer, if the lawyer is going to charge a non-refundable fee, the lawyer can only charge that fee if it represents an approximation of the work that that lawyer is going to do on the case, as well as the other factors at Rule 1.5A. For example, one of the factors that can be used to determine whether a fee is reasonable is if the lawyer, by accepting the representation, if that's going to obviate the possibility of the lawyer taking on other cases. That is a factor that can be put into the amount of the fee being in that reasonableness calculus. There are two types of fee arrangements, a flat fee and a retainer. A flat fee is or refers to an arrangement where the lawyer agrees to do a specific legal task for an agreed upon total fee rather than billing their time. So for example, if a lawyer agrees to handle a contested custody matter for a client for $3,500, with that to cover representation through successful settlement or bench trial, that's a flat fee. So no matter how much work the lawyer does or how little work, the lawyer is going to only charge $3,500. If a flat fee is charged, and unless the client signs a fee agreement specifying that the fee is non-refundable, the fees are not earned upon receipt and must be deposited into the trust account. So this is a common mistake that's made by lawyers, and we see this in a lot of investigative matters, as well as calls that we get from attorneys seeking an informal ethics opinion. If an attorney charges a flat fee and the fee agreement is verbal, it's not reduced to writing, and or if there's a written fee agreement that doesn't state that the flat fee is non-refundable, that flat fee is refundable, and that means none of the fee is earned until all of the work has been completed. So going back to the example of a contested custody matter, if the lawyer agrees to handle a contested custody matter through settlement or bench trial for $3,500, and no fee agreement is signed stating that that fee is non-refundable, the entire $3,500 must be deposited into the attorney's trust account, and the entire $3,500 must be maintained in the trust account until the representation is concluded. The lawyer, let's assume that the lawyer normally bills at $200 an hour. The lawyer is not able to remove a portion of that $3,500 reflecting work done on the case. The lawyer has to keep that entire flat fee in the trust account until the work is completed. So this is one of the areas where attorneys can run into problems in connection with Rule of Professional Conduct 1.5. If a refundable flat fee is charged, now the attorney may designate specific stages of the representation where a specified portion of the fee is earned. So for example, if the lawyer agrees to representation for the client in a contested custody matter, the lawyer can say, I'm going to charge a $3,500 fee. The first $1,000 of that fee is the pleading stage, and then the next $1,000 is written discovery, and the lawyer specifies either verbally or in writing that the lawyer can remove that portion of the fee upon completion of that work, then that's entirely appropriate. However, otherwise, the entire fee must remain in the trust account. Another problem that we see recurring is where the lawyer charges a refundable flat fee, either in writing or verbally, but does not specify the scope of representation. One of a lawyer's obligations, and this is defined at Rule of Professional Conduct 1.5 subsection B, is that the lawyer must define the scope of representation, the specific work that's going to be completed at the commencement of the representation or a short time thereafter. A typical circumstance where the lawyer does not do that is, for example, in a divorce case, the lawyer should clarify that the representation includes work only through bench trial or entry of a divorce settlement. It does not include, for example, post-divorce work, or if there's a qualified domestic relations order that has to be drafted, the lawyer would want to clarify with the client that that's not included in the original fee agreement. Now, there's nothing wrong with the attorney having a flat fee agreement, either agreeing to or not agreeing to handle post-divorce work like quadros or other work that has to be done. It just has to be clarified with the client. So the fee agreement doesn't have to be in writing unless the fee is going to be non-refundable. However, in order for the attorney to comply with their obligations under Rule 1.5B and to avoid later problems, it's very highly recommended that refundable flat fee agreements be in writing as well. There's actually only 3 circumstances where a fee agreement must be reduced to writing. The first is if the lawyer is going to charge a non-refundable fee. The second is if the lawyer is going to take the case on a contingent fee agreement. And the third circumstance is if the lawyer is going to share the fee with another lawyer who is not in the lawyer's firm. The second type of fee is a retainer. And this type of fee arrangement applies where the attorney is going to bill time and the lawyer accepts a sum of money that's prepaid by the client to provide security to the attorney for payment of the fee. Just like a flat fee, the lawyer can charge a retainer that's either refundable or non-refundable. However, if it's going to be non-refundable, just like a flat fee under Rule 1.5 subsection F, the lawyer must have a written agreement stating that the fee is non-refundable. Otherwise, the funds must be deposited into the trust account. Prepaid court costs and case expenses received from a client are also required to be deposited into your trust account, since at this point, any prepaid court costs and case expenses are client funds. They belong to the client. They don't belong to the lawyer. Therefore, the lawyer cannot deposit these into the lawyer's operating account. That would constitute commingling in violation of Rule 1.15. Therefore, the lawyer must deposit those into the trust account to be used or promptly returned to the client when the representation is concluded. As I mentioned, the contingency fee agreements must be in writing, signed by the client, and must specify the percentage of the settlement or judgment. The contingency fee agreement also has to specify any prepaid case expenses for which the lawyer is later going to be reimbursed. And this also is at Rule 1.5 subsection C. If a lawyer takes a case on a contingency, then the lawyer is required to prepare a settlement sheet itemizing how the funds will be allocated and then promptly release those funds. Now, there's nothing improper with the lawyer releasing the undisputed portion of the funds to the client as well as the attorney's fee, and then negotiate the portion of the fees that are owed to third parties, such as entities holding subrogation interests. However, and this is another issue that we see recurring both in investigations and calls that we get from attorneys requesting ethics opinions. If you're going to handle contingency fee generating cases like personal injury cases, you need to notify the clients prior to settlement about how subrogation claims are going to impact recovery. Unless a client is very legally sophisticated or they have been through the process of a personal injury suit before, they're not going to have any idea what subrogation claims are and how that impacts their recovery. And you're required to diligently pursue the negotiation or resolution of subrogation claims. In the event that the lawyer or when the lawyer completes the representation, in any circumstance, if there's any unearned fees, prepaid costs, and case expenses, they must be returned promptly to the client. And if there is a dispute, then the disputed portion of the fee needs to remain in trust. This is another common error that's made. Many times attorneys are of the opinion that if the lawyer is discharged or withdraws and there's still a fee that's owed by the client, that the lawyer believes that they have a general lien against the client file. That is, they can withhold the client file until the client pays the fee. And that's actually not the case. Under Rule 1.16, 1.16 subsection D, I believe it's subsections 4 to 5, it provides a very narrow circumstance where the lawyer may hold on to work product prepared, but only to the extent that the lawyer has not been paid their fee for that work product, and only if there's not going to be a materially adverse impact on the client. Only in that circumstance can the lawyer not give the fee to the client. Okay, we have a few minutes left for our hypotheticals. Before we move to the hypotheticals, are there any questions? So the hypothetical number 1, and what I'll do is read the hypothetical, and then I will provide a little bit of time for our participants to submit their answers. And if those answers could be posted in chat, and if I could kind of be told or summarized what the responses are, and then we'll move on to the next hypothetical. So hypothetical number 1, a lawyer agrees to represent a client for a $2,500 flat fee for representation in defense of criminal charges. No written agreement is signed. Is the lawyer required to deposit the entire fee into their trust account? And then second question, let's assume the lawyer is terminated by the client while the criminal charges remain pending prior to trial. What portion of the fee, if any, is the lawyer required to refund to the client? So I'll give just a little bit of time for participants to post their responses. Okay, have we received any responses?
Yes, there are a few. There's a few, let's see, yeses. There's one that needs to say non-refundable, refunded a reasonable portion based on the work. The other two are yes, the whole amount should be returned.
Okay, so in the first part of the question, no written agreement is signed. Therefore, the flat fee would be refundable. in which case the lawyer would be required to deposit the entire fee into their trust account. Now, the second part of the question is a little bit tricky, and there's several ways that this could be interpreted under the rules. So let's assume the lawyer is terminated while the criminal charges remain pending. What portion of the fee should be refunded? Our office has taken the position that let's assume that the lawyer can reasonably say that half of the work has been completed in the representation, that there would not be anything wrong with the lawyer proposing to the client a reasonable resolution of the fee issue, to say to the client, I believe I've done about half of the work. What I'm proposing is to refund $1,250. Now, that our office would take the position that that would not violate Rule 1.15 or other rules of professional conduct. The client would actually have an argument to make that the entire flat fee should be refunded, on the argument being that the lawyer agreed to handle the representation. But here, particularly because the lawyer has been terminated by the client, I think that just looking at this from the standpoint of the rules of professional conduct, it would not be a violation of the rules for the lawyer to reach a reasonable resolution of the dispute. In the same manner that if the lawyer took the client to court in resolution of the fee dispute, very likely a reviewing court in a civil proceeding looking at this matter within the context of the law of contracts would very likely give the lawyer some measure of recovery. So we'll move on to hypothetical number 2. Lawyer agrees to represent a client in pursuing a personal injury claim. Case is settled for policy limits. What are the lawyer's obligations at the commencement of the representation with regard to the fee agreement and following settlement with regard to the funds received and disbursement? And now let's assume that after settlement, a dispute arises between the lawyer and the client over the applicable portion of the client's settlement proceeds. What are the lawyer's obligations under 1.15? I'll give our participants a little bit of time to post the responses to this hypothetical. Have we received any responses?
We just got the first one saying, be clear about the obligations to be safe, get a signed contract, and a second one, fee arrangement should be spelled out right from the beginning of the representation.
Okay. So very briefly, concerning the first question, because the lawyer is taking the case on a contingency fee basis, it has to be reduced to writing and signed by the client. And under Rule 1.5 subsection C, the lawyer is required to clarify the percentage of the lawyer's recovery and all of the case expenses for which the lawyer will be able to be reimbursed. So for example, it's common practice in the personal injury bar for attorneys to be reimbursed for incidental expenses like copying and postage. No problem with that. It just has to be specified in the agreement. Now, after the settlement is reached, if there's a dispute between the lawyer and the client, then under Rule 1.15, the lawyer is required to hold the disputed funds in the trust account until there's a resolution of that dispute. If there's not a resolution of the dispute, then the lawyer's only option is to file an interpleader action to interplead the funds and resolve the dispute in that manner. I think we might have time for one more. A lawyer accepts a $25,000 non-refundable fee to represent a client in pursuing a pending boundary line dispute. The lawyer's billing rate is $300 an hour, and the lawyer anticipates spending at least 50 to 100 hours on the case. A week later, the client discharges the lawyer. What portion of the fee, if any, must be refunded? Now, let's assume that the lawyer spends 25 hours on the case and then discovers a conflict of interest. the lawyer obtains leave to withdraw, what portion of the fee must be refunded? It'll take about a little bit of time to post your responses.
All right, we got a response. One, ethically can retain full amount, probably should retain the hourly charge and refund balance. Two, refund all. Then one, if the client agrees to waive the conflict, then keep the reasonable portion based on the amount of work done.
Okay. And I think and I generally agree with that. What's tricky about non-refundable fees is, and there's no question that this non-refundable fee is objectively reasonable at the outset of the representation, given the lawyer's billing rate and the expectation of how much time is going to be spent. However, under this circumstance, this would clearly result in a windfall recovery for the attorney. And the comments to Rule 1.5 clearly indicate that the fee must be objectively reasonable both at the commencement of the representation and at the conclusion of the representation. So the lawyer can charge the non-refundable fee and claim that fee as earned, not deposited into trust. However, at the conclusion of the representation, the lawyer must then engage in that same objective analysis under Rule 1.5, and a reasonable portion of the fee, in this case, most of the fee, should be refunded. Now, in the second question, the lawyer spends 25 hours on the case and then discovers a conflict exists, particularly if the lawyer failed to discern the conflict due to negligence at the commencement of the representation, then the lawyer should factor that in determining the amount of the fee that should be refunded. I think a significant portion should be refunded. It looks like we're not going to be able to have time for the remaining two hypotheticals. Are there any final questions?
I have not seen any in the chat. I'll give it another minute for anybody to put anything in there. Not seeing anything else. So Stephen, thank you so much for your presentation.
Thank you.
It's very informative. And then we will go ahead and move on to our next session.
Thank you very much.
And next up, we have Judge Karma McGee. Judge McGee, you should have the ability to share your screen, turn your video on, and unmute yourself and do all that fun stuff.
Andy, you may have to give me a pointer here as to how to.
You should be able to go over to view on the top.
Okay.
Nope, I'm sorry. Slideshow. There we go, from the beginning.
Okay. Did that get it?
It looks like it's loading. Maybe not. Well, I apologize. Apparently I was wrong. There we go. Let's see. Swap. There we go. Now it's up.
Okay.
Yes.
All right. Good morning. Thank you for having me here this morning. Sorry that we can't be all in person and be able to see each other, but this is, I guess, our best option for the current situation we're in. Today's topic is recent case law update. This will be covering cases from this year. Now, let me say before we go into this is not an exhaustive list of all cases. These are cases that we have pulled that are just some of the more common issues applicable, hopefully, to the largest number of people who are attending the seminar and watching the seminar. The topics that we're going to be going over, we're going to look at cases in a variety of areas, all of which, of course, apply to the domestic arena and the practice of domestic law. We've got a lot of cases to cover, so we're going to jump right in. And I think there's a mechanism in place for asking questions. I'm not sure that I can see those, but Andy, is that something?
Yeah, any question that comes in the chat, I will bring up to you.
Okay, great. Thank you. All right, well, we will jump right in then, and we will start with alimony. First thing we're going to talk about a little bit about is the modification of alimony. Now, the Himes case here is a modification case that deals with retirement. There are a lot of other things dealt with in this case, some issues on ability to pay, things of that nature that may be applicable as well if you're researching particular topics. However, this was a situation where the parties had divorced and the wife was awarded alimony in the amount of $1,500 per month. Husband later filed an action to terminate that alimony because he was going to retire. Wife wanted, of course, to keep her alimony as it was. The trial court, and the wife also filed to increase the alimony. The trial court here awarded wife a retroactive increase, and also, even after husband retired, left his alimony set at $1,500 per month. So just a case you may want to look at if you have a situation coming up where you've got parties maybe who have an alimony currently being paid, and you have the obligor contemplating retirement. And this case also, one other thing that the case did talk about was the wife tried to claim that certain proceeds that were achieved by the husband from the sale of the marital residence should be calculated in as far as his income for alimony. And so the court talked a little bit about that. But again, just a good case on modification and retirement, especially. Looking at the Smith case, is about the alimony and solido attorney fee award. Here in this case, there were some issues. Husband was claiming that wife basically shouldn't have an interest in certain property that he claimed was separate, and that the court had not properly divided the marital property. The trial court held in favor of the wife on both the arguments, but she got no attorney's fees. And that was affirmed by the Court of Appeals. And the Court of Appeals held that the evidence did not preponderate against the trial court's finding that husband lacked the ability to pay wife's attorney's fees. So just a reminder that when you're asking for fees and you're looking at it in a situation of alimony and solido, there's still got to be an ability to pay there. Even if in this case, wife was victorious on her arguments, she still didn't get her fees paid because there was no ability there on the part of the husband. We'll jump over to child support now. Several cases on child support. We'll start with talking about a couple of private school cases. These seem to be becoming a little bit more common, and probably depending, of course, on what part of the state you live in. Some places it's a big issue, some places it's not really applicable. The Bastogne case, the parties in this case had a permanent parenting plan that had agreed upon joint decision-making on all educational decisions. And mother made $16,000 a year. Father made approximately $115,000 a year. And mother decided she wanted to enroll one of their children at Baylor, which is a pretty expensive private school in the Chattanooga area. The trial court found specifically that mother had made this decision on her own. It was not a joint decision, and that father had objected for it. However, the trial court went on to find that it was in the child's best interest to attend Baylor, and ended up assessing father with up to 50% of the tuition at the school. Of course, father appealed that. The Court of Appeals affirmed that case and said that the permanent parenting plan did not specifically exclude or prohibit private school enrollment. And this was more of a child support question than an educational question. The trial court and the Court of Appeals both left in place the joint decision-making for educational decisions. However, they did view this, as I said, more from a child support issue. And they affirmed, the Court of Appeals affirmed the trial court's ruling that father, well, let me back up. There were two younger children involved that were not the subject of this actual action. The older child was the one who was going to Baylor, Baylor being a school in Chattanooga, not the university. But the trial court had ruled that father would not be responsible for tuition costs for the parties' two younger children for the time being, and the Court of Appeals did affirm that. Another private school case, the Roberts versus Crafton case. This is a case where the children were already in private school at the time that the permanent parenting plan was executed. And the parties had a very detailed statement in their permanent parenting plan. And I'm just going to quote part of that to you. The parties agree that in lieu of the payment of child support, the father will share equally in the cost of the private school. Now, the children were currently at one private school called Christ Methodist School that apparently only went to a certain grade. The parties agreed that when they were no longer able to go to Christ Methodist School, that the children would attend a private school chosen by mother. And at that time, father's obligation to pay his share of private school would cease. And at that time, then father was going to pay child support, but any child support obligation would be limited to the amount of support pursuant to the guidelines without consideration of the tuition amount paid by mother. So after that got to the point where they were no longer at Christ Methodist, father would start paying child support, mother was going to cover private school. And so they had this agreement in place. The trial court found that father was obligated to pay a portion of the private school chosen by mother. Of course, father appealed that. And the Court of Appeals held that payment of private school is a child support obligation that is modifiable by the court when the original circumstances change. So something you need to really take away from this case and look at as you're consulting with clients in this type of potential situation is that, according to the Court of Appeals holding, an agreement between the parties that private school will be the responsibility of one party or another in the future is not enforceable under Tennessee law, but rather may be modified by the court. Looking at it from a child support perspective and looking at that expense being looked at in the context of child support. The McGrath case, we have a case here of a deceased obligor. The party's permanent parenting plan called for both parties to maintain $300,000 of life insurance with the other parent named as trustee for the children as beneficiary. Father dies, he was remarried. Y'all can guess what happened next. He left the entirety of a $500,000 policy that he had to his new wife. So he didn't leave anything for the benefit of his children. So the mother goes and sues the new wife, and the trial court granted summary judgment to mother. But the trial court only awarded mother, for the benefit of the children, an amount equal to the balance of child support that was owed to them under the existing plan. So they figured it as the amount of child support that would have been owed until the children all had aged out. The Court of Appeals reversed that and held that the agreement was clear from the beginning that the children were to receive the entire $300,000. That was the parties' agreement. Just as a side note here, mother had failed to maintain her own insurance policy during this time. The Court of Appeals found that her failure to do that was immaterial in the context of this case. Court of Appeals also found that mother was not entitled to attorney fees in the litigation against the new wife, either from a contractual standpoint or a discretionary one. So just in case you would want to look at if you have a situation with a potential deceased obligor and an insurance coverage. Continuing in child support, voluntary underemployment. This first case is just a reminder of the burden of proof and ultimately resulted in a waiver. This was a case where the father is a former professional basketball player, and I'm not sure who he was or who he played for. I mean, I don't know many of the professional basketball players. I guess I should have asked my teenage son for clarification on that before I presented this, but father was a former pro basketball player, and mother claimed that after father's retirement that he, for the purposes of child support, was voluntarily underemployed. But she did not raise this argument until she got to the appeals court. So ultimately, the Court of Appeals said, well, the issue's waived. You didn't raise it in the trial court, but also took the opportunity to remind everyone that the mother is the one here with the burden of proof, because that was an issue in the trial court. But the mother is the one here with the burden of proving that father was voluntarily underemployed, rather than putting father in a position to have to present evidence to disprove that. The trial court also and the Court of Appeals shot down several other issues that were raised by the mother on appeal, and ultimately assessed mother with about $14,000 of the father's attorney fees at trial as the prevailing party. So little instruction there on burdens of proof, a case that might be relevant to you if you're looking at a voluntary underemployment. And also, you know, it's something you need to keep in mind, the waiver argument, because if you intend to waive it on, if you intend to raise it on appeal, then you got to raise it in the trial court first. The Baker case, I think there in your handout is a typo. I think it says decision of retirement assets on your handout. It's actually division of retirement assets as child support. This was a case where the Court of Appeals affirmed the trial court. The trial court found, father tried to claim that mother's share of his military pension should count as income to her to offset his child support obligation. The trial court and the Court of Appeals both found that her share of father's military pension was a division of marital property, not income to be considered for the calculation of child support. They also did cite a statute there that you don't see a lot unless you're dealing with some of the military retirement pay and things of that nature. TCA 364121, the court explained the applicability of that. And the fact that assets which are distributed as marital property are not considered as income for child support, except to the extent that they were going to create additional income after the property is already actually divided. Modification of child support. The Tiger case, this is a case about modification and contempt. The trial court originally modified father's child support, but on re-examination under a Rule 59 motion, they reversed themselves, and then the case went up on appeal and the Court of Appeals affirmed it. The Court of Appeals also vacated the dismissal of a contempt charge by the trial court and remanded that part for a new hearing. The Court of Appeals did in that case as well note that even if father was not held in contempt, mother should be awarded attorney fees if it was reasonably necessary for her to institute the proceedings under the provisions of the party's MDA. So just a reminder there on the fees and the collectability of the fees. All right, moving from child support, we next jump to everyone's favorite topic, civil procedure. I'm not going to talk a lot about Adkins. It's a Rule 10 recusal. It's definitely something you need to look at if you're dealing with a recusal issue. That's extremely common. But if you're dealing with a recusal, take a look at the Adkins case. This is the third appeal of this case. I will just note, and the court, in conjunction with this, in this case, the Court of Appeals found not only that wife's appeal was frivolous and ruled it a frivolous appeal, but also found that there was little doubt that it was an attempt to manipulate Rule 10B to delay or prevent the payment of the judgments that were in existence from the trial court at that time against the wife. Rule 59, looking at this case, the Shannon case, the parties entered into an MDA. The trial court approved the agreement, entered a final decree of divorce. Then wife filed a motion to alter or amend, and it was based upon that the agreement failed to provide wife with an interest in the husband's military retirement. The trial court determined that it should be modified, and they modified the final decree. Husband appealed, saying there was no basis for setting aside the MDA, as there was no evidence of fraud or duress. The Court of Appeals rejected husband's argument and found that the trial court itself, in issuing its subsequent order, stated that it had not complied with TCA 364103, which requires the court to make a finding that the parties have made an adequate and sufficient provision for the equitable settlement of their property rights. So the court acknowledged that it failed to, in its final decree, comply with the statute and use that as a basis to modify the final decree, and that was affirmed. The Couts case is a Rule 60 case. This was a case where the parties were divorced in 2012, and throughout, they apparently kept in contact. And through post-divorce communications, wife claimed that husband had told her that he had assets that he did not disclose at the time of the divorce. So in 2016, wife filed an action to modify the divorce decree. The trial court found that the husband had not hidden assets from the wife, and that essentially he was just trying to act out of malice towards the wife. Basically, he was trying to antagonize her, and he was telling her that, oh, well, when we got divorced, you didn't know it, but I had all these other assets out here, and I never told you about them, so you didn't get any of them. So the trial court did not modify the agreement, but did order husband to pay wife's attorney's fees. Husband appealed, and the Court of Appeals found that there was no vehicle here to make a modification without a finding under Rule 60, and that there was no reversible error. The Court of Appeals declined to award attorney's fees to either party because, as the opinion pointed out, neither party identified this request as a distinct issue. They simply asked for attorney fees in their brief's conclusion, almost in passing. So a takeaway from this is, if you want attorney's fees, and if you're requesting attorney's fees, and if you think you have a right to attorney's fees, then remember to make that an issue on appeal, and not just in your closing paragraph say that you think you're entitled to fees, because just as the Couts case says, that's not going to work. More civil procedure. The Baker case, it's on a 59.04 motion. This case is a divorce action, which the matter in controversy included or concerned an attorney's fee lien and an abstract of suit recorded by a wife's former attorney following the entry of the divorce decree. Subsequently, then some things transpired. Husband died. There was property. Attorney, of course, wanted to get paid. This is a very fact-specific and fact-intensive case, so it's worth reading if you have a question about Rule 59.04. And it is also something you might want to look at if you have a situation about trying to collect attorney's fees through an attorney's fees lien. The court ultimately held that the trial court did not abuse its discretion in denying the motion filed by the administrator of the husband's estate, because the motion was not based on a change in controlling law, previously unavailable evidence, or a clear error of law. So it did not fit the qualifications of a 59.04 motion, as far as they didn't meet the standards and the requirements. So again, a limited case there, if you have something along those lines. Another fees case, the Bachelor case, just basically reminds us of the holding in Eberbach. In this case, the trial court refused to award fees to a former wife based on the breach of the MDA, finding that husband's actions were not willful. Obviously the parties had an MDA which had a fee provision in it. Wife appealed. The Court of Appeals reversed and found that the husband's argument that he was in substantial compliance was non-availing because the award of fees in the case clearly carries out the party's stated intent in the MDA, which specifically stated that the defaulting party should be required to pay the fees. And they quoted the specific provisions of the MDA there. The court also awarded attorney fees to the wife on appeal. The Polster case, this is a case where having to do with Rule 59 and MDAs, husband in this case essentially agreed to a divorce, entered into an MDA, had it signed. The day of the final hearing, he sent a letter to the court stating, quote, "If she wants a divorce, she can have it, but I want the court to order 3 months of marital counseling." The trial court entered a divorce decree without a requirement of divorce for 3 months of marital counseling. Husband sought to set it aside under Rule 59, claiming duress. The trial court denied his relief. The Court of Appeals affirmed that and found that because husband had signed the MDA, the letter did not, that he had signed it, he did not prove duress. The Court of Appeals cited case law that defines duress, that he didn't prove any duress. And furthermore, the letter that he sent to the court did not say that he was revoking his consent to the divorce. It just said, "I want you to order some counseling." Quick mention of McCartney. Remember to brief your issues on appeal if you want to raise them. This case was a divorce that went on for years and years. And by the time it got to the Court of Appeals, the husband raised a number of issues, and 5 of those were dismissed for failure to brief those issues. Lots of things were covered by the court, but they did not. There's plenty of other things that were covered, I guess I should say, but the 5 issues were completely waived because they were not briefed. They were dismissed. The Felker case. This is an interesting situation. I was on the panel on this case, and this is something that doesn't come up very often, but it does occasionally, I suppose. The parties were divorced in 2005, and the divorce decree, they had an agreement, required husband to provide wife by October 2005 proof of life insurance, naming their son as the beneficiary for $150,000 policy. Wife sued husband in 2019 for failure to maintain the insurance. The trial court found that the breach occurred in 2016. And so they granted wife a judgment for attorney's fees and ordered husband to procure the life insurance policy. Court of Appeals reversed that and found that the cause of action had actually accrued in 2005 when husband failed to provide wife a copy of the insurance. That was required that he get that insurance by October 2005. He did not do that at that time. So the court ruled that the 6-year statute of limitations on breach of contracts had expired. That expired in 2011. So wife had no claim for relief here against the husband. So just something you need to keep in mind, your statutes of limitations on what these parties are ordered to do in their MDA or in their decree. Well, in their MDA, excuse me, because of the contractual nature of that. We go to evidence next. The first one, sexually transmitted disease litigation. This is just a kind of an interesting case from a standpoint of health records. The plaintiff tested positive for sexually transmitted disease after her relationship with the defendant had ended. She filed a complaint against him, claiming he was liable. The defendant had blood tests after being served, and he was negative for the diseases that plaintiff alleged that she had received from him. Court granted summary judgment, and which was ultimately affirmed by the Court of Appeals. The trial court did, and this case kind of goes into what type of evidence was sufficient for the trial court to base that summary judgment on. Psychological records are in the Lucas case, even though it's the case that arose out of juvenile court. It's a case between parents. In this case, a juvenile court order and a circuit court order, it was appealed at circuit, required mother to release her psychological records to the father. The father wanted those, the guardian ad litem, there's a guardian ad litem appointed in this case, guardian ad litem wanted those too. And the Court of Appeals reversed both of those orders. And there was an argument that the records should be available for disclosure under TCA 37-1411. The Court of Appeals rejected that argument. And then the father and guardian ad litem also tried to maintain that the original petition by the father should suffice as a report of harm under 37-1403. The Court of Appeals said no, the requirements of that statute are very specific and you did not meet those. So no psychological records to be disclosed. A good case to look at if you do have a situation, a parenting issue, and you do have psychological records that may be pertinent that in relation to one parent or the other. The In re Sitten case, this case, you know, some cases you just shake your head at, and this is one of them. This is a lesson for attorneys. You got to watch your Facebook post and your comments. And this case is almost unbelievable. Basically what happened was an attorney's Facebook friend posted a public inquiry about carrying a gun in her possession because of a tumultuous relationship. The attorney commented on the post about the escalating use of force. He stated essentially that if she wanted to kill her ex-boyfriend, she could lure him into her home, claim he broke in with the intent to do her harm, and claim she feared for her life. The attorney emphasized that his advice was given as a lawyer, and she should delete the entire comment thread because premeditation could be used against her at trial if she was actually serious. This is where I wish we were at a live seminar so I could really just see the faces of everyone. The Supreme Court, this went in a disciplinary proceedings, it went up to the Supreme Court, and Supreme Court noted that his social media post, this attorney's social media post, fostered a public perception that a lawyer's role is to manufacture false defenses, and they projected a public image of corruption of the judicial process. The BPR recommended suspension of this attorney's law license for 60 days. However, the Supreme Court modified the panel's judgment to impose a 4-year suspension from the practice of law, with 1 year to be served on active suspension and the remainder on probation. So everybody be careful out there in the social media world and use good judgment. The contempt case, we've got an order protection case here that we stuck here because there wasn't really anywhere else, I guess, any more appropriate to put it. Just a reminder that you don't have to have a intimate relationship for an order of protection to be granted. In this case, the wife took out an order of protection on her husband's former girlfriend because she was stalking them and making threats of physical violence through a series of videos. The trial court granted that, and the Court of Appeals affirmed it, the grant of the order of protection. The issue of whether contempt is willful is covered in the Murray versus Godsey case. In that case, this was a post-divorce contempt action. The wife had filed contempt on her former husband, for failing to pay her the retirement benefits, which she was entitled to when he retired. Obviously, the divorce had taken place some years before the retirement. The trial court found husband in contempt and awarded wife attorney's fees. However, the Court of Appeals reversed it and emphasized that even though most of the elements for contempt were met, there was not proof to support the contention that husband was willfully in contempt of court. There was some proof and some question as to whether husband had actually acted willfully in this case. And the court reminded the parties that the burden was on the wife to prove that the husband had willfully disregarded an order and that she failed to meet that burden. So a good case, again, another one here to look at if you're dealing with a retirement and a possible payout upon an obligor's retirement. Switching gears here and moving to the division of the marital estate. First one, the Haltom case, the significance of that basically is it deals with some transmutation issues. Wife had some property prior to the marriage. She sold it, and the proceeds were used to purchase another piece of property during the marriage, which was put in joint names. I mean, y'all know how often this happens. The trial court found and the Court of Appeals affirmed that the placing the new property in joint names evidenced an intent that the equity from the original property became marital rather than remaining separate. So again, just an issue of transmutation there. The Green case is a reminder to attorneys that the court must make findings of fact as to the division of the marital property. And in this court, the court divided the marital estate without determining the value of the assets and without determining which assets were separate and which were marital. Of course, it was reversed and remanded. And the Court of Appeals emphasized that it was unable to determine if the property distribution was equitable because there was no determination of the value of any of the property that the parties had. And there was no way to determine which pieces of property the court had deemed to be marital and which were deemed to be separate. So attorneys, if you get an order and it doesn't have findings of fact, and you might be sitting there thinking, well, there's nothing I can do about that. Judge has to do that. Well, attorneys, if you get an order in a situation like this and it doesn't have findings of fact, and especially if it's one you intend to appeal possibly, then you need to be requesting those findings of fact and those essential element determinations. But even before that, you need to be making sure that you put on the proof that is required to do so. I've tried divorces, and I'm sure there's lots of judges out there that have tried divorces where the parties didn't put on their proof the way they should have. They didn't know how much anything was worth. They didn't value it correctly. And it starts with providing the correct proof and building your record that way. And so you've got to provide the proof that the court needs to determine the value of these assets. The Wiggins case is just a reminder that fault is a consideration in alimony. The long-term marriage here, the trial court ordered quite a bit of alimony to the wife. Husband appealed saying wife didn't need some of that alimony, and he said that the reason the court did it was because it was punitive toward him because of his affairs during the marriage. Well, the Court of Appeals upheld and completely affirmed the trial court's awards of alimony in futuro, transitional alimony, and alimony in solito, and emphasized that although the primary focus in the alimony considerations, the primary focuses are need and ability to pay, fault is a consideration under 36.5.121. And the testimony here had established, the record was clear, the wife did not want the divorce, was willing to forgive husband for his acts of infidelity, but he refused to attend counseling at the wife's request. And the Court of Appeals also went back and mentioned the Olinger case, which was from a few years ago. And in that case, the Court of Appeals had affirmed award of attorney's fees to wife because the reasoning was if the husband had not committed the infidelities, there would probably not have been a divorce and therefore no attorney's fees to have been paid. And that's what the record in that case bore out. So just a reminder there that fault does play into an alimony award.
Judge McGee, we've got a couple of questions that have been related to the past couple of slides that I thought I would throw out there. The first one is about the orders of protection and said, I thought the statute about OPs specified who the statute applied to. How does the husband's new wife qualify under the statute?
In that case, the court found, it was my understanding that it qualified as a stalking victim.
Okay. And then this second question we have is, it says, can you avoid transmutation of separate property if you include details in a prenuptial agreement to maintain the value of the original property prior to the improvements made jointly after the marriage?
That's a good question. I don't know that I've ever had anybody, I've never had a case where I've had anybody attempt to do that. So I would have to say, I don't know.
All right.
Maybe we'll see it in the future.
All right. Well, those are the questions that have come in so far.
Okay. Okay, we'll continue with the division of marital estate and the Gaza Strip marital property. This case was packed full of stuff. I was on the panel of this one. And basically what happened here was the wife sued the husband, but also sued the husband's brother and sister-in-law under a theory of civil conspiracy. And the wife alleged that the husband and his family were in a conspiracy where they were attempting to liquidate some property in the Gaza Strip that they owned that was worth approximately 1.3, almost $1.4 million. So the court, first of all, the court exercised jurisdiction over the property. And that was one of the issues on appeal. But the court did exercise jurisdiction over the property and then went on to equitably divide and distribute the proceeds from the sale of the property between the parties. They also, there was an issue about exercising jurisdiction over the brother and the sister-in-law. And this, again, this is one of these cases that we could talk about it for a long, long time, but it's relevant as far as if you have a situation where, number one, you have people who own property in a foreign country, especially in a foreign country where they are, where the access to, marketability of, or appraisal of that property may be difficult. The second thing that this is really important for is the issue of a family conspiracy to dissipate marital assets, because that was what the trial court found. The Court of Appeals did note in its decision that the Supreme Court has held that Tennessee courts can exercise conspiracy theory personal jurisdiction over non-residents. Now, this case, petition for cert has been filed in this case, and I don't think it's been acted on yet. So there, we may be seeing another chapter to this case, but it has some really interesting things if you, and some hopefully helpful and instructive things if you have either one of these type of fact patterns in your case. The long case, independent deliberations, that's just a case where the court didn't rule at the end of the case. They told each party to submit their proposed findings of fact, conclusions of law and order. The court then chose between one of them and signed the husband's, I believe, final order with no modifications. The order contained statements that the order was the product of the trial court's independent deliberation and decisions. The wife appealed, saying that it was that was not proper under the standards of Smith versus UHS of Lakeside. The Court of Appeals rejected the wife's appeal and exercised jurisdiction, or exercised the discretion to go ahead and address the parties' deliberations, or excuse me, to address the parties' request, and that the matter not be remanded for entry of judgment to that more clearly reflected the trial court's independent deliberations based upon the sake of judicial economy and finality. So again, the Court of Appeals exercised discretion to consider the merits of the appeal in the interest of providing the parties with a final resolution rather than vacating and remanding it. And with court, of course, put the language in there that they may not choose to do that again. We finished this section with one other case that also went to the Supreme Court. This is a case where I think the wife raised 9 issues on appeal, and the Court of Appeals granted relief to her on one of those, and that was the division of marital assets. The Court of Appeals affirmed the trial court on every other issue. The one thing that was could be instructive here, if you have this situation, the Court of Appeals found that the trial court placed too much emphasis on the age of the parties and too little emphasis on their respective incomes. And the Court of Appeals remanded the case to the trial court with instructions to divide the marital estate as close to 50-50 as possible. Well, the Supreme Court reversed that, and the Supreme Court said that the Court of Appeals failed to give proper deference to the discretion of the trial court on the issue and remanded the case back to the Court of Appeals. The Court of Appeals then entered a new order, which no longer contained the 50-50 instructions. So just some language there that may be beneficial to you in the process of appeals. We now move to mediation, and only one mediation case this year. In the Lee case, the parties mediated their case, and they reached a mediated agreement as to some issues, but not all of them. And then husband tried to rescind. The Court of Appeals held that settlement agreements are enforceable as contracts. They are. The Court of Appeals in this opinion reminded everyone of the mistake requirements, of what's required to prove a mistake, and that husband failed to prove that there was a mutual mistake. Therefore, the request to rescind the mediated agreement was rejected. Moving on to parenting issues, sex abuse allegations, the Hop case, sad case, mother made repeated false sex abuse allegations against the father. Over the years, this is an ongoing case for years and years and years, as most of those are. Mother repeatedly lost parenting time, went to counseling, promised to do better, got part of her parenting time back, showed progress. Her current therapist said she was showing progress. The therapist recommended continued counseling between the mother and the child. They're on a petition for modification of the parenting plan to increase mother's time. Trial court found no material change in circumstances, but they ordered that therapy between the mother and the child continue. Well, the Court of Appeals affirmed everything except the court ordered therapy between the mother and the child, because they found that this was not requested by either party, and therefore the trial court did not have the authority to order that. So if you have a situation where you want a child to continue counseling, you need to be sure that you plead that you ask for that, and that you make a request for that. The Culver case is just something that trial judges hate. I hated it when I was a trial judge. Children in chambers. Children in chambers, it's just bad all the way around. It's a no-win situation. But in this case, the judge interviewed the parties' 6 children in chambers, without the parties, without a court reporter, without an attorney. Then again interviewed the oldest child, again without any of those other people present. But apparently the parties had agreed to allow that to take place. Court entered an order reducing father's parenting time with the children. Father appealed, saying the court didn't state with any degree of specificity why it did that. The Court of Appeals reversed it and said that, and agreed with the father, finding that the failure to comply with 52.01 was fatal. And the statement of evidence from the court regarding the in-chambers interviews with the children was more of a statement of the case without reference to facts or testimony used in those interviews. So if the court's going to do that, they've got to make some type of findings that are more than just a statement of meeting with the children. And so that's something important for your record if you're trying a case such as that. The Ponce case involved a same-sex marriage with in vitro fertilization that resulted in the birth of twins. The parties later divorced. Again, this is another one that's very fact-specific. If you have this situation, parties divorced, set up a parenting plan. Both parties had access to the children. Then several months later, the plaintiff, who was the biological parent, filed an action under 6002, saying the trial court did not have jurisdiction to give parenting time to the non-biological parent. The trial court found that the defendant was a parent under 362403, and the Court of Appeals affirmed that. So again, just a fact-specific case. If you have that situation, you need to make sure and read that case. Year on, year off parenting, another fact specific. We're not going to spend a lot of time on that. Parties had a year on, year off. One lived in Delaware and one lived in Tennessee. Yes, those plans are out there. The parties both agreed the plan was not workable, and so the court built a new plan, and the Court of Appeals affirmed. The Morrish versus Maynard case, that is our annual installment on grandparent visitation. I was on this panel and wrote a dissent on this one. The majority opinion stated that the father did not allege in his petition that mother opposed his visitation with the child or that his visitation was severely reduced. That was the majority opinion. Dissent did not agree with that. So I'll just leave it at that. You can read that one if you're interested in the grandparent visitation field, and I encourage you to read it. If you have a grandparent visitation case, you can never read too much about grandparent visitation if you're trying to fall under the relief, or trying to claim relief under that statute. Honey versus Honey is an alienation case. Just a reminder here that it's possible to prove alienation. This case, mother had there were documented, it was a post-divorce custody case. Mother had reported the father to DCS 15 to 18 times. None of them were substantiated over a period of time. The Court of Appeals or the trial court changed the primary residential parent from mother to father based on mother's conduct since the divorce. Court of Appeals affirmed that and went on to talk about the trial court's concern that the early signs of parental alienation by mother that had been noted at the time of the divorce had blossomed since the divorce. So these actions can continue to build. You may not get the alienation the first time, but that doesn't mean that those actions can't build to be revisited at a later time. Maximizing parenting time, the Powers case, it seems like we have one case every year that has to say this. Maximum time is not equal time. That's not what it means. So that's enough to say about that child or about that case. The Lillard case, support for a disabled child. This is the first time I think that I've really run across one of these, and this is very specific, fact specific again. There's a child who parties had a disabled child. They were divorced. Father had been ordered to provide support past the age of majority for this child. A big consideration here is the issue of the disabled child's income. And I don't think I've ever run across a case really like that before, but this case addresses the breadth of relief available for a parent in caring with a disabled but active child. I believe this girl was about 21, 22 years old, and she did have a job, I believe, at Lowe's watering plants. And so the trial court determined that the daughter had an ability to earn an income, and the Court of Appeals affirmed that finding and ultimately affirmed the child support that was awarded. Presumptive fathers, the Otters case, child was born during the marriage. The parties subsequently divorced. Mother said husband is not the father. Trial court finds that husband's not the father. Father admits he's not the father, has a DNA test done, but then files a Rule 60 motion and wants to get time with the child that has been born during the marriage and been in his household. Trial court denied that, and the Court of Appeals affirmed. The court agreed with the trial court that the presumption of parentage had been sufficiently overcome with the DNA testing, and emphasized that the appellant conceded in his Rule 60 motion that he was not the biological father. Court also pointed out, and just something to notice, and this happens a lot, that husband's motion was styled a Rule 60 motion, but it should have been a Rule 59 motion because it was filed 30 days of the entry of the order. Canzoneri, lots of stuff in Canzoneri, but basically results in a no material change of circumstance finding. This is the case that I authored. The parties had a permanent parenting plan. This was post-divorce. Mother was involved with another man who had a domestic violence incident. Stepfather, or it was actually her husband, the stepfather threatened to harm the children. He was arrested. Mother asked father to retain custody of the children for an unspecified amount of time while she get things in order. Father agreed, and then father files a petition to modify the parenting plan. The trial court granted the ex parte restraining order, turned it into a temporary injunction, but then mother moved out, filed for divorce, basically got stable everything stabilized in her household, and the court then ordered the parties to resume the parenting schedule and found that there had not been a material change of circumstances to justify changing the parenting schedule. However, even though the court found that there was not a material change of circumstances, the trial court went on to modify the parenting in a few different ways, and also found father to be voluntarily underemployed. Court of Appeals reversed the trial court's holding because there's no material change of circumstances. The trial court's decision to modify the decision-making provisions of the parenting plan, the court didn't have the authority to do that. The court didn't have the authority to make modifications if there was no change of circumstances. The appellate court also vacated trial court's finding the father was voluntarily underemployed because it was not proven. And the court had applied an incorrect legal standard. So look at that if you have a situation where you've got a post-divorce issue, maybe with some domestic violence in one of the parents' homes, or also for the issue of voluntary underemployment. We then go to prenups. This was a case where even though, well, it was a case where wife was claimed that the prenup should not be enforced. The trial court held that the prenup was valid and that wife was not pressured or coerced into signing it. Court of Appeals upheld that decision and found that the record showed that the wife was well aware that husband wanted a prenup, that she could have obtained counsel, but she did not. So we're about out of time. Our final topic, relocation, Payne versus Payne. This is the case where the parties entered into a permanent parenting plan, and then mother tried to claim a basis to modify that for a relocation because she had recently moved to the Johnson City School District. However, the court found, and the Court of Appeals upheld, that there was no material change in circumstances that had occurred since the entry of the permanent parenting plan. Mother lived in Johnson City before the current parenting plan was executed by the parties, and therefore the move was not post parenting plan and was not a material change of circumstances. The Chambers case is important for one reason. Well, there may be other things, but the main reason it's important is because the Court of Appeals makes clear that the relocation statute distance is based on radial distance, not travel distance. So it's a 50-mile radius. So sit down and draw it out on a map, and it doesn't matter, for example, if you're going from here to Lexington, it doesn't matter if you can take Interstate 40, you can take 412, you can take some other ways that would wind around and get there. But whatever the radial distance is on a map is still the distance for the purposes of determining whether the relocation statute applies. So I know I've covered a lot of ground very quickly. So does anybody have any questions?
There's not any questions in the comments, but we'll see if any come in here. So far there's not any. So other than the two that I already asked.
Okay. Well, thank you all. I appreciate the opportunity to be with you today, and hope I can be with you next year, and hope that the situation is different and we can all be together.
Great. Thank you so much. We will now go into our lunch break. So we'll see everybody back at 12:30. Thank you. Hey, everybody, we will go ahead and get back started with the program. Next up, we have Terica Smith, who is an assistant district attorney here in Madison County. Terica, for some reason, there's a big picture on your video that just shows a camera with a line through it.
I see that, and I am not sure why.
I was gonna say, I have never seen that before.
I have not either. Let me see. Goodness. I have no clue what is going on. Let's see, hold on. Well, so Andy, what I'm gonna do is I'm gonna leave and come back. Let me see if that helps, okay?
All right, sounds good.
All right.
Oh, you were there there you are. You're muted still.
All right.
There we go.
Okay, great. All right. So I disconnected my monitor, so I'm not even sure if that helped.
I apologize, everyone. Hopefully we can get this figured out. All right, we can see you now. So let's see if it works this time.
I'm not sure what is happening. Okay, let me share my screen and hopefully I don't get kicked out. Oops. Okay, can you see my screen?
I can.
Okay, and you're seeing the PowerPoint, correct?
Yes, ma'am.
Okay, great. All right, so let's see. Okay, so today we're going to talk about microaggressions, and I'm having more trouble than I want to have right now. Okay. All right, here we go. So today's goal is for us to increase our conscious competence on matters of microaggressions, their effects, and how to combat them. So what I ask is that today everyone keep an open mind and ask questions, make comments as we are talking about this topic. So what is a microaggression? This term was coined by psychiatrist and Harvard University professor Chester M. Pierce in 1970 to describe insults and dismissals which he regularly witnessed non-African Americans inflict on African Americans. Let's see. Okay. Dr. Pierce was a senior advisor on the creation of Sesame Street. He recognized the racist messaging in television in the 1960s and felt that presenting an integrated society where everyone was friends and was treated with respect was important for children to see. As time progressed, the term microaggression began to apply to all socially marginalized groups. So what is a microaggression? Microaggressions are everyday verbal, nonverbal, and environmental slights, snubs, or insults, whether intentional or unintentional, which communicate hostile, derogatory, or negative messages to target persons based solely on their marginalized group membership. In many cases, these hidden messages may invalidate the group identity or experiential reality of targeted persons, demean them on a personal or group level, communicate they are lesser human beings, suggest they do not belong with the majority group, threaten and intimidate or relegate them to inferior status or treatment. This definition was created by Dr. Daryl Wing Sue, a professor of counseling and psychology at Columbia University. So here's a more simplified definition. Microaggressions are the everyday slights, indignities, put downs, and insults members of marginalized groups experience in their everyday interactions with individuals who are often unaware that they are engaged in an offensive or demeaning way. Out of the term microaggressions, there have been several sub-definitions or identified other types of microaggressions identified. So one is a microassault. These are explicit derogations and purposeful discriminatory actions, usually assault or obvious, like shouting of racial slurs. Those are more in your face. Micro insults are what we're gonna really discuss today. These are behavioral verbal remarks that convey rudeness, insensitivity, or demeans a person's heritage or identity. A lot of times the perpetrators are not aware that they are doing something that's offensive, but it has a hidden message to the recipient. Micro invalidations occur when the behavior or the comments exclude, negate, or nullify the person's feelings. These are also, sometimes they're unintentional. So statements such as racism doesn't exist in today's society would be considered a micro invalidation, or a teacher ignoring or disregarding minority students in the classroom. So how do microaggressions look? Here are a few examples. The statement, "Where are you from?" or "Where were you born?" On its face, it is a benign question. But if this question is posed to an Asian American or a Latino American, it sends the message that you are a foreigner or not American. The next example is a statement, "You are so articulate," or "You don't sound Black." By making this statement to an African American, you're assigning intelligence to a person of color on the basis of their race. It sends the message that people of color are generally not as intelligent as Caucasians, or it is unusual for someone of your race to be so intelligent. The next statement is, the next question is, how did you get into that school? Again, benign on its face, but if it's said to a minority or someone in what would be considered a socially marginalized group, it sends the message that you do not belong in that educational institution based on your gender or your race. The last one, assuming a young woman is not an attorney, maybe asking her, are you the secretary? Are you the court reporter? Are you the assistant, the paralegal? That sends the message that because of her perceived age and gender, there's no possible way that she could be an attorney. That has happened to me numerous times, and I'm pretty sure many of our female colleagues can attest to that has happened to them as well. So here are a few examples of microaggressions that can come up in our everyday practice of our profession. These are examples that I have had first-hand experience with, especially when I was working as an attorney at West Tennessee Legal Services. One question is, who pays your rent? You or welfare? That statement makes the assumption that a person receiving public benefits is not entitled to them, or they are misusing their benefits. Similarly, the next statement, that person is using the SNAP or food stamp benefits for soda and junk food. Again, that statement sends a hidden message that the person is not entitled to these benefits. The next one has happened to be quite often. I don't know if I still qualify as a young attorney anymore, but I call it the mark of the young attorney. So how it has come up here's an example. In a mediation or settlement conference, an attorney from a small law firm, or maybe even, like I said, legal services, who's been out of law school for a couple of years, is negotiating a settlement for their client. The opposing counsel is older, let's say maybe 20 years older, and opposing counsel repeatedly refers to the junior attorney as young man, interrupts him, asks, when he got out of law school, and continuously references his inexperience. He makes statements like, when you've been an attorney as long as I have, or has tried as many cases as I have, you will understand. That behavior is very dismissive and disrespectful to the young attorney's experience. And and it can create a hostile environment for that attorney who's trying to advocate on behalf of their client. Here's another example. A female attorney is labeled as pushy, bossy, diva, difficult to get along with, and even the B word. While her male counterpart, who exhibits the same qualities, is described as forceful, or someone who sets high standards, or a really great attorney. Most, if not all, of our female colleagues have had to deal with this. There are times that we're not heard. When we've worked to be heard, we are labeled with less desirable terms. We all graduated from the same law schools and passed the same bar exam as everyone else, and we just want to be respected as such. Another way this comes up in the example of he can't possibly be the attorney. Here's an anecdote. You are an attorney of Caucasian descent, and your African-American colleague have been preparing for a criminal trial for weeks. On the first day of trial, you and your colleague enter the courtroom, both dressed in your best suits, and the judge assumes that your colleague is the defendant and directs him to the defendant's seat at the table. I haven't been considered, this has happened to me numerous times, not that I've been considered the defendant, but I've gone into courtrooms across West Tennessee, and despite being in the suit, holding a file, walking in and sitting where other attorneys sit, I've been told that only attorneys sit in front of the bar and that I would need to move. And, you know, when that happened to me, even as a new attorney, a young attorney who was already nervous about just what I was there for, my case, having that, you know, happen to me just kind of would throw me off my game, make it uncomfortable. It would send the message that I didn't belong. And while the person or the people that have said similar things to me may not have intended to try to hurt my feelings, it did. So that's how microaggressions can come up, and what they look like and how they present themselves in our profession. So what are some ways that we can combat microaggressions and bias? So as attorneys, we all know that words matter. Words can be harmful, even if that's not their intent. We should always speak words that build people up and make them feel included. So talking about microaggressions is important because words matter. So the first is make the invisible visible. Address it directly. If you hear someone making a statement that could be considered a microaggression, address it directly. Oftentimes the perpetrator is not aware that they've engaged in demeaning or offensive comments, so sometimes you have to make it visible to them. I would say, you know, this next point about educating the perpetrator, you know, shift the focus of what they said, or what the person intended to say, to the impact of what they said. When you turn to a person who engages in a microaggression and you point it out to them, the response is usually, that wasn't my intention. But focusing on the impact gives the perpetrator a greater understanding of what happened and how they may have caused the pain. You lose the argument, or you're not as effective when you focus on their intention, because you can't always improve a person's intent. I say in these situations, I have taken the stance of gently educating the perpetrator, pulling them to the side, not doing it in front of others in a large group setting, maybe even, you know, later letting them know that what they said was offensive. I think that's how you bring awareness to that person's behavior. Like to me before, people have said to me that I don't sound Black, whatever that means. And I'll say, my response is usually, I know you meant that as a compliment, but that kind of perpetuates the history of being surprised that African-American people can speak well. You know, I'm not sure what the difference in how Black people sound versus white people sound, but that is a real thing. And that's a comment that's made to me often. Next, disarm the microaggression, steering the conversation away from the problematic remark or joke to communicate that it is offensive. If someone tells you that a remark you made was harmful, be open to criticism. Thank you for bringing it up and apologize for it. Know that that person is definitely not trying to shame you, but that correction is coming from a place of encouragement. receive it with gratitude. Ask questions so you can understand where you went wrong. And as attorneys, we have to remember our duty of civility. Lawyers should always be courteous and civil in all professional dealings. Lawyers should act in a civil manner, regardless of the ill feelings that they or their clients may have towards others. Again, as attorneys, we know words matter. Words can be harmful, even if that is not our intent. So as you move through your day-to-day life, just be aware of the questions that you may ask, that you may not intend to be offensive, but that's how they come across. So I moved through that a whole lot faster than I planned. So are there any questions or comments? I think I see something in the chat.
There are a few comments in the chat.
Okay, let's see. I think I see them. Hold on. Okay, Dr. Reed Onyenwu. He noted some questions that he's received. How long have you lived in America? How often do you go back, I guess, to Africa? Do you like it here? Do you plan to go back? Are these questions part of microaggressions? I think they can. I think you have to kind of definitely, I think those questions, depending on well, let's see. Do you like it here? Plan to go back? I think some of those, though, Dr. B, could be a little less microaggressions because they seem to, those questions come across as very much have more of a curiosity base about how long you lived in America and things like that. But I think depending on how that conversation goes, it can easily move towards microaggressions. But I'm pretty sure that you've had some of those in your experience. Daphne, hey Daphne, you made a comment earlier in your practice. You were often asked if you were the court reporter. I think a lot of women have experienced that in our profession. It's just one of those things, as if people don't expect to see us there. Let's see. Those are all the questions I had in the chat.
Those are all I've seen. If anybody's got any other questions, definitely feel free to put them in there, or other experiences you've had.
Okay.
Not seeing any more come in, so we've got a couple minutes left.
We do, and I don't necessarily have to hold anybody hostage. So
I say Daphne is actually, let's see, Daphne is up next. So oh, let's see, Chelsea said, thank you for highlighting the young attorney issue. Bias by other attorneys has been the most difficult parts of my practice.
And, I will comment on that. Early on in when I started out at Legal Services, goodness gracious, that was one of the issues and that I had. I even had once, I don't know if Jane Jarvis is on here, but there was one, I guess one time I really went to, I believe it was Benton County, and I advocated for my client. I mean, I think I was probably the best attorney in Tennessee on that day, because that attorney actually called Jane Jarvis and asked her where they got me from, because I guess he wasn't expecting this young African-American girl to come to Benton County and fight so hard. But it was one of those things that I just kind of had to deal with early on in my practice. Dr. Beadon, would ask, what is the difference between a microaggression and racism? I think they are, I don't want to say they're synonymous, but I do believe microaggressions occur, they are a lot more subtle than overt racism. So like I said, on their face, microaggressions are benign kind of questions, but who the question is directed to makes it a microaggression. So like I said, asking an Asian American where they're from, or are they really from here, or are you really from America, sends a different signal than if it was asked to their Caucasian counterpart. Does that answer your question, Dr. Bede? Thank you.
All right, we'll give it a few more seconds, see if anybody else has anything they want to add. If not, we'll go ahead and jump over to Daphne. But I want to leave it open for just a second and see.
Well, thank you for having me. I'm glad. I want to thank Mary Jo for asking me to present on this topic, and hope everyone has a great weekend.
Great, thank you so much.
Bye.
All right. We will go ahead and move on. Our next presenter is Daphne Davidson. She is the Senior Associate Counsel at the Department of Human Services.
Hello, Andy. How are you?
Good. How are you?
Wonderful. Thanks, Terica. That was awesome. I'm not sure if you're still on the call. I can't see you right now. But that was awesome. I love that presentation. I may reach out to you at some point in the future and get you to present that again, if you would, for another organization. Okay, everybody, let's get started. Oops, here we go. So I've got a kind of a twofold presentation here today. I have first I'm going to jump into guidelines, child support guidelines, some of the new things that have come out, but then also do some case law update. I watched Judge's presentation at 11. She had some great cases on there. A lot of cases that I did not have. It was one of the reasons I really wanted to make sure I watched her presentation to make sure I didn't double dip on these cases and bore you to death after she had already presented on them. There were a couple of cases she had though that I'm thinking I'm going to go into a little bit more detail about on maybe some different issues that came up in the case that I saw. So if you'll indulge me there. So let's get started with guidelines first, because I want to make sure that we get through all of this. If I can get my PowerPoint to come up. Here it comes. Okay, let's see. Give me just a moment. I'm going to share my screen. And I also need to make sure, let's see, which screen are you seeing? Are you all seeing? I think you're seeing it.
Right now, I'm just seeing your desktop background. See your
You're just
dog.
seeing my dogs. Hang on, let's change that. Okay. Let me, hang on, I'm sorry. Let me change. Thought I clicked on the right screen. Let me try that again. All right. Okay, so are you seeing the screen with the PowerPoint,
Yes,
but not in slideshow version yet, right?
Right.
All righty. Let's go to slideshow version. Oh, now it's the notepad. Oh gosh. Okay. Hang on. I've got like 3 monitors up, so it's like, okay, which one do I do? All right, let me do this. There we go. Now, are you seeing the proper screen there?
Yes, I am.
Yay, success. All right, let's jump in here. Okay, guys, thank you so much for asking me back to present at this annual CLE. I really appreciate the invite. I always look forward to this one. I hope that we can do this in person next year, maybe. That would be awesome. So first, we're going to get into guidelines and some legislative updates. There is my contact information, my email address. I can give you my phone number too. Phone is fine to reach me by, but I tell you what, email is like the best way, because I check email even when I am in Disney World. And if you all, any of you who actually know me, know that Disney is something that I am passionate about. So if I'm checking work email when I'm in Disney, you know, I'm going to check it. Anyway, here we go. Let's jump in here. All right. So as many of you all of you should know, I'm sure, we had the big change in our child support guidelines back last year, effective May 10, 2020. That was the biggest change that we have had since the income shares came into play January 18, 2005. So we went through, it took us, gosh, 2 or 3 years to go through the process, actually, because it was so intense and so detailed, so involved in doing that big guideline change. And all of that was, not all of it, but the background of that, what prompted that big change was as a result of some federal requirements. So we ended up doing a full overhaul for that. And I know that last year I presented some information on that, so I'm not going to go into all those details, but I do want to mention to you about some changes that we've had since then. So as you know, with that date, May 10, 2020, that was through the beginning of the pandemic. The pandemic first started, we had our big, everything was locked down at that point, or most everything was in May still, a lot of things. So during that time, the legislative sessions and the GovOps, the government operations committees, they were not meeting. So they had a delay as a result of the pandemic. So they did not get an opportunity prior to those guidelines, those revisions going into effect. They did not have an opportunity to review them. So it was after that fact, after they reconvened and after our guidelines went into effect, that they had an opportunity, and they had a few things they wanted to discuss further. They had a few issues with them, and so they asked us to kind of go back to the drawing board on a couple of things, not the complete drawing board, thank goodness, because I said it took a long time. But we ended up forming a smaller committee consisting of some different magistrates and judges and the ALC representative, and also DHS, some representatives at DHS, which is where I am at DHS. So we did that, and the primary thing that was changed was dealing with the self-support reserve, the SSR, another acronym, we love our acronyms, SSR, and the resulting child support obligation. So we ended up changing a little bit with the worksheets with that. Basically, on the front end, on the face of it, you won't really, or you probably have not seen any real changes on the face of that worksheet. With the changes that went into play October 1, 2021. But because the changes kind of came back as a result of the formulas behind the scenes. So, and then if you looked at the schedules, now those you would see some changes on that, because that's where it derives from. So after we worked with that, with the GovOps and going back and forth with them a few times, having a few different meetings, we ended up making a change in that SSR. So we refiled after reaching some decisions on that, we refiled the rulemaking hearing with Secretary of State back in the spring, and then we had the hearing virtually. No comments were made during this, unlike the first time we went through the big change, because we had so many different changes and so much involved. We had a lot of comments as a result of that. Plus, we had really put the word out about our changes before. We really advertised it like, hey, we want your input. Please give us your input. So this time we really didn't have any changes, because like I said, it was only dealing with that one issue, the SSR. So then we refiled the rules, and they became effective. Technically, they would have become effective September 30th, but we did a stay for 1 day, so they would be effective on the first day of the month to make it a little easier for everyone as far as calculations and such. So let's talk about a little bit more detail rather than just the background of how that came about. Basically, the changes on that, as you know, the self-support reserve, what that is the minimum amount of income required to meet the basic subsistence needs of a parent. And here's the section that it refers to in the guidelines, the 1240, that's part of the SSR there. So the SSR is part of the basic child support obligation, or the determination. The SSR is, that comes into play with the worksheet prior to adding any other expenses, such as health insurance or daycare, etc. So the final obligation, it actually could be more than the SSR amount, but not less than a minimum order, unless there are certain situations that are exceptions. And we will talk about that in just a moment. So here, based upon the previous, Based upon the other time that we had to work the guideline changes, the law that was in effect May 10, 2020 through the end of September, that had an SSR based upon a minimum, maintaining a minimum standard of living based on 110% of the 2018 federal poverty level. That came out to 1,000 is based on net income too, $1,113 net income per month. The reason that was 2018, because remember I said that those guidelines, those rule changes took a long time to go and to finally be implemented because we had so many changes and so many meetings and so many things to do with that. So that was based upon, that was the most recent time. We filed those in 2019, so that was based upon 2018. All right, so the SSR with that was in the schedule based upon if income reached that amount or was at that low amount at $1,113, then the SSR could be triggered. So then we have our most recent law change. And this is in dealing with effective October 1, 2021. And in this, the new schedule developed, you'll see a few changes, like I said, on the face of it, but you would see some changes behind the scene. So if you look at this one is based upon, instead of 110%, we went to 90% of the 2020. So remember, this was done in 2020. So it was based upon, and federal poverty level comes out usually January of every year. So sometimes it usually changes by just a little bit. So federal poverty level 2020, 90% of that federal poverty level, and this time it was based on gross income, $957 gross income per month. That's what 90% of the federal poverty level for 2020 would represent. So if a person's income fell within that range, then SSR would be applied. And I know this probably makes absolutely no sense right now until you actually see a worksheet. And hopefully you all have already been playing with those worksheets and implementing those worksheets since we are now a couple months after this became effective. All right, so here's the schedule. Again, this is the previous schedule. This is the one based from May 10, 2020 through September. So if you look at this 1,500 here, for example, wherever you see that blue shaded area, that's where the SSR is applied. So 1,500 would be one child 310. If you look at like minimum wage, for example, 1,300, 170 would be for one child. Now let's look at the next worksheet, next schedule, excuse me. This is based upon the current schedule, okay, based upon the 90% of the federal poverty level for 2020. So if you look at the same number of 1,300, which they round up, it's rounded up. So if you think about a person making minimum wage, which at 40 hours a week, that would be $1,256.67 a month. That would be rounded up to 1,300. So the difference here is that would be $275 now. Okay, remember before 1,300 was 170. So now it's a little bit more. The support will end up being a little bit more than what it was using the same income, a little bit more than what it was with the previous new rule changes. Okay. So now you're going to see support orders a little bit higher than what they were last year. Okay, or up until October 1 of this year. If you look at a lot of cases that we've had, you do have to look at what person's actual income, unless you have imputation of income and that sort of thing. But a lot of times I would see cases that the support was set based upon both parties earning minimum wage, for example. If you looked at that under the old guidelines, I'm talking about prior to May 2020, then for one child, that was before SSR was implemented, support would have been $259 a month. Okay, if no other additions were added in there, such as healthcare, Now, and then when we had the changes last year, it would have been lower because it would have fallen within the SSR. Now, with it only being representative of 90% of the federal poverty level, if you look at that same number, it's not actually 275, but if you look, because this is based upon one person, if it falls within the schedule in the shaded area. But if you actually do the worksheet and with both parties earning minimum wage, it would actually come out to $259, which is actually what it was before the guideline changes. So there are still a lot of other changes that are very, very important and are very much needed based upon the federal law. You know, the federal law that came down was really, they want people to be able, these 8 cases to be right sized. They want them to be based upon a person's true potential to earn and pay support. Support is based upon a person's true ability and what they can do, and they're set realistically. The person is more likely to pay their support on a regular and ongoing basis. So that's where that comes from. All right, let's see. Scenarios. One sec. Let me go back 1 second here. I'm gonna stop. I'm gonna stop sharing for just a quick second. Stop share. Give me a moment. And give me a second. Should have had this pulled up, and I did not. So while I'm doing this, while I'm pulling this up, does anyone have any questions right now about the SSR? Anyone? Anyone? Now's a great time. Give you a moment. No questions? Andy, do you see any questions in the?
There's not any questions.
Sorry about this. I thought I had everything pulled up the way it should have been, and apparently I did not. It's my fault. Now, all right, I was going to try to pull this real quick. Okay, I'll tell you what, I am going to bypass that part and go straight into the next part of the next screen there. Let's see. Okay. There we go. Ooh, again, wrong thing. Okay. Okay, so now are you seeing my non-note?
Yes.
Right, okay, thank you. Sorry about that. I was going to go over a couple little scenarios there, but one of them I did mention to you was with the minimum wage. I was going to compare those two based upon the old worksheet and then the new, and I would just hands on that really quick. I don't want to take up time doing that. So if anyone has any questions about the worksheets, or if you have any issues with the worksheets that you have seen or that you come across in the future, please email me and let me know, and we will talk through that, work through that. If we need to make tweaks, we will. Again, that is all formula based and behind the scenes. I am not the person that created the formulas because I do not know those formulas. We have some great people up central office that knows how to do that, and we will pass that information on to them if you have any issues with those worksheets. So let's jump on into this really quick about the legislative update. This is one thing that came out in effective July 1, 2021. It is TCA 365101. Yeah, I know that's like our all catch-all TCA for family law, right? But go to Part 5. And in this, it's when the Department of Human Services, when DHS becomes aware of a change in circumstances by either party to a 4D case, the department may review and seek an adjustment of the support obligation that's pursuant to the guidelines. So what does that mean? Well, as you know, the law prior to this was basically a party had to request a review. If they wanted their child support to be reviewed to see if it needed to be increased or decreased or whatever the situation was based upon the change of circumstances of income, number of children, parenting time, any reasons, then they had to make that request. Now we would, in cases where parties were on state assistance, we would automatically review those every 3 years to see if anything changes need to take place. However, a party needed to make a request for us to look at it and see if it needed to be reviewed for changes. Now, however, if we become aware, if the EHS becomes aware in 40 cases that there has been a change, we can go ahead and kick off that review. Doesn't mean it's automatically going to be changed, but we have to review it and see what are the circumstances, what's the current income, what's going on. Situations where I see this is very helpful is, number one, when we have a person that's incarcerated, because as many of you know or should know by now, after being with the new guidelines, the changes since for about a year and a half now, over a year and a half, is that incarceration can no longer be, a person can no longer be found to be voluntarily underemployed or unemployed as a result of incarceration. So now we need to look at their actual income. So if we learn that a person is incarcerated for more than, not 180 days, but more than 180 days, and more than that 6-month period, then we look at their actual income. What does their support need to be changed? Should it continue to click away at $700 a month? Probably not. So let's look at what their actual income is and kick off a review in that situation. Another situation is maybe they are, and this can come into play with the minimum order as well. Maybe they are in rehab, inpatient rehab, and need to have a review, become aware of that, and they don't actually make the request. Another situation I see it a lot in is when a person has applied for disability, Social Security disability. Those cases they can take a long time to go through the whole process, sometimes 2 to 3 years very easily. And if the person does not have a petition to modify pending for the court cannot go back and retroactively modify a support obligation. They can only go back as far as the petition was filed. And that is not a requirement. And you will see in one of the cases coming up on the case law update, that is not a requirement that the court will go back to the date the petition was filed. But nevertheless, when they do go back, they can't go back before the petition was filed, regardless of that. So if a person has a Social Security case going on for a long time, let's get at least a petition pending on that, and then we'll see what's going to come of that. Another situation is when a child is emancipated, and maybe there are additional minor children of the parties. May or may not affect the child support. It kind of depends on how long it's been since its court was set or last modified, but it can change it. So we need to look at that. So now the department can go ahead and kick that off so that we don't have orders that are not right sized and are just continuing to accumulate astronomical arrears when they shouldn't, as a possibility. All right, any questions on that? No. Now here is my direct phone number. I had that in there somewhere. And again, my email address. So please feel free to contact me at any time you have any questions or comments or ideas. I tell you another thing that, we have to review the guidelines. Tennessee is required to review them every 3 years. And we do that. It's just not usually an intense review every time unless we have some major changes to make, like we did that last big time. Federal law is every 4 years, but Tennessee law requires us to do it every 3 years. So what I do in between these reviews is I keep an ongoing little file folder on my computer, and anything comes up that I think we really need to look at that. I had an issue come up the other day. Somebody was asking about self-employment. Person that was self-employed has self-employed income, and it was an issue that really probably need to look at a little further when we have the next review. Another thing is like the overtime. I had a parent that called and said, or emailed us and said, right now during the pandemic, I'm working. She was a nurse. She's a nurse. And she's like, I'm working. I think she was a custodial parent, but it was still affect, but the income shares affect the support. She was working like astronomical number of hours. She was working her regular full-time job, but she was also during her days off and when she didn't have parenting time, with her children, she was helping out her coworkers and she was working all these extra hours. And she was like, I just know he's going to file a petition to modify, and that's my income. I mean, right now, but it's not going to continue forever, but I'm doing it because of the circumstances that we're in right now. So I was like, no, right now we look at all income, but would that be equitable in that situation? I don't know. Maybe yes, maybe no, but it's something I just put over in my little file folder to look at the next time we come around. So keep that in mind. Send me your ideas if you have things for our next review. All right. Any questions, Andy, in the chat box?
There has not been any ask.
All right. Let's see. Let me jump right on into the case law. And let's see, we are at 120 now. I think I flew through that other thing there. We're at 120 now. So typically it takes about an hour and a half, 2 hours to go through this case law. So I'm going to be skipping a few of these. Plus I won't go into all the ones that there were about 4, I think, on the previous case law update that you all had a little bit ago with the judge that are also on mine, but I'm not going to include those. So except for a couple of them I mentioned, I'm going to have just a couple of tidbits on there. So let's see. Let's see. You're seeing my screen. Let's do a slideshow. Then I'm going to have to switch that again. Slideshow from the beginning. Display settings. There we go. Okay. Again, my contact information. All right. Let's see if this first case. Yes, Baker, B. Baker. I'm going to go over that one here just a few moments. This case is out of Montgomery County. This one involved mom and dad who were married in 2004. 2004, and they have 2 children, 2 minor daughters. They were living in Germany at the time of their divorce. The marriage obviously deteriorated and they filed for divorce. Prior to the divorce being filed though, mom with the daughters, with the 2 girls, left Germany and moved to the United States, moved to Tennessee. So dad filed an action under the Hague Convention in federal court in Nashville, wanting the child to be returned to Germany. Mom then, he did that in June of 2016, and then mom filed for divorce in June of 2016. It took about a year or so, about a year, I guess, for the federal court to rule on that petition regarding the Hague Convention and the return of the children. But they did determine, federal court did determine that the children should remain in Tennessee. And then the final decree, it took a couple more years, 2.5 years, for the divorce to be final. So I point this case out to you just in case you were to have a situation where you have children in another country and you have to deal with the Hague Convention. So this is a good one to refer to there. In this case, mom was named the primary residential parent, the PRP, and dad was ordered to pay $1,064 a month in support. He was also ordered to pay alimony to mom, $1,300 a month until she started receiving his retirement benefits. So at that time, he wasn't eligible for the retirement pay. So in the interim, she was going to be receiving alimony from the dad or husband. Now, one of the things about this case is the court found that the dad had dissipated a lot of the property, the marital property, like about $159,000 worth. So in this case, dad appealed, and he said one of the issues was whether the trial court erred in establishing gross income for child support calculation purposes, and whether or not, because the dad did not believe that he had been fully credited with any monies paid out for alimony, et cetera, et cetera. One of the things, I think the way I read this opinion, he thought that he should have gotten some credit for the retirement benefits. But the thing is, remember, he wasn't receiving those retirement benefits yet, or that mom should have been assessed income based upon that. At the time, though, that was just alimony, and she would not have been assessed, should not, and was not assessed income based upon the alimony within that case. If it had been a situation where she received alimony from another previous marriage, yes, that would have been included as alimony or income for her. So the trial court did not err in failing to give dad credit for the alimony or health care. With respect to the retirement benefits, the trial court did properly decline to give him credit for retirement awarded to mom as part of the property division. He said that if later on, years later, when, if those retirement benefits appreciate greatly in value, maybe he could look at that again. That could be looked at again and re-examine it. So the Court of Appeals did end up affirming the decision of the trial court in this case. All right, so let me see. This is one I wanted to run through as well. Okay, in this case, Abney v. Pace out of Rutherford County. Divorce was in 2018. There was one child born of the marriage. Mom was named PRP. Dad, parents had like 216 days with mom, 149 with dad. Mom's income, dad's was a little more than double that of mom's at the time of the divorce. So mom's was just a little over 2,000. Dad's was close to 5,000. There was also the issue of child care, not the issue of, but there was also the inclusion of child care in the worksheet. So as you know, when child care is included, that can really bump up the child support obligation. So in this case, it was about $700 a month on the child care. So dad was ordered to pay $1,006 per month in support. Dad was also ordered to provide the health insurance for the child. So the action that came before the Court of Appeals is based upon a post-divorce action, and that was when dad had filed a petition to modify his child support obligation. Mom also filed a petition for civil contempt against dad for failure to pay child support. In dad's petition, he was claiming, mom claimed against dad that he was voluntarily underemployed because he was changing jobs and he was going to lower paying jobs and that sort of thing. She didn't prove her case on that, but she also wanted the court to give her credit for covering and maintaining the health insurance for the child. Now remember, dad was under the order to provide the health insurance, and even though he had changed jobs, he never failed to maintain the health insurance for the child. So the child was never without the health insurance. So the trial court ended up declining giving her credit for the health insurance because it wasn't a reasonable. I think at different points it was very high, maybe based on COBRA, maybe a change that she had COBRA insurance or different amounts. And what the court found was that the trial court found that the evidence supports that the father continuously provided the health insurance for the child, and that it was mother's decision to provide the additional coverage, and the court declined to give her that credit. They found that it was not a reasonable amount as well. I have seen a lot of courts that will, even, if both parents have the insurance, they'll give credit for both parents for the insurance. But in this case, the court did not, and the Court of Appeals upheld that. So another issue was about the 15% variance, whether the trial court erred in finding that there was a 15% variance. And the court said, requiring that the child support be modified. The Court of Appeals said no. It was determined that the trial court did not abuse its discretion to decline the credit, and also that there was no dispute that a 15% variance existed. So remember I said the support was set at $1,006 and their income was quite different, with his being more than double. Well, mom's income increased quite a bit by the time that petition modification came into play. Her income was closer to $4,000 by the time that this came out, and her income was $3,658.33. Dad's income, it increased a little bit, but not by much. His increased to maybe another $500, a little over $5,000 during that time. So during the course of that modification, dad's support was reduced down to $840 based upon those changes. But before all this was said and done, the child started preschool, and mom no longer had that $700 a month child care expense. So dad's support was actually reduced down to just under $400, or $396 a month. So another issue, and this was all found to be, affirmed by the trial court. They were correctly made these determinations. Another issue that, remember Mom said Mom filed a civil contempt against Dad for failure to pay child support. Well, Court of Appeals, so she brought that issue up for the Court of Appeals. Did the trial court err in not finding him in civil contempt? So they did not. And the Court of Appeals said, nope, they were acted correctly there because, remember, it's civil contempt, not criminal contempt. The punishment in civil contempt actions is designed to coerce compliance with the court's orders. Father's overpayments, because he started, yeah, he missed some payments early on, but he was making payments overpaid during this time. So his overpayments during the course of these proceedings essentially had purged his contempt. So the trial court of Appeals affirmed all of the trial court's judgments. All right. So let's rock on along here. Oops. Apparently I didn't go on further. Sorry about that. All right, this next case you see on the screen is not one I'm going to cover because this is one that Judge covered earlier today, and I don't have any other issues I want to point out with this. I don't think. Let me double check. I don't think I did. No, I think that was thoroughly. So I'm going to skip this one. Okay, so here's church. Let me see about this one. Do we want to cover that? I know I can't get to all the cases that I have in this case law update, but you all will receive, or if you haven't already, receive all these cases if you need to refer to them, but I won't be able to cover them all in this presentation today. All right, let's see. Let's look at the Church v. Jones case. This one is out Hamilton County. The issue on appeal, the action on appeal, was a petition to modify the support that Dad filed in 2015. So in this case, parties were divorced 5 years earlier. They were divorced in 2010. 2 children born in the marriage. Mom was named the PRP, Dad the ARP. He was ordered to pay $856 a month in support at the time of the divorce. Over the course of the years, parties had gone back and forth to court quite a bit, and the support had been modified a few different times. In 2014, prior to this petition being filed, 2014, the court had increased Dad's income, child support obligation to $1,755 a month. Now, remember this petition was filed in 2015 that we have before the court right now. So let me go a little bit further here. Well, hang on just a second, I went too fast. So he filed this in 2015. This case drug out forever, it seemed like. It had numerous hearings. It actually, the final hearing was over a course of a couple of years. First hearing, it began in February 2017. Final hearing was not on the same petition, was not until September 2019. So the court ended up reducing Dad's support down to $552 a month. The court also declined to give him a modification back to the date he filed his petition 4 years earlier, because of all the litigation that was going on throughout this, and a couple other issues, and I'll talk about those in just a second. So that was a big thing for Dad, was, his support was reduced quite a bit, but the court declined to give him that reduction back to 2015. So that was his real big beef with the court, and he actually filed a motion to appeal, which the court ended up treating that as like a motion to alter or amend. A couple of things he brought up. One was, of course, he wanted the support to modification to go back to the day the petition was filed. But second, he said that the court miscalculated Mom's income. And the trial court did say, yeah, you're right about the income. We did miscalculate that. So based upon the corrected calculations, his support should have been $500 a month rather than $552. So they did do that. However, they declined to give him credit or give him the modification back to the date the petition was filed. And then Dad appealed that. He appealed that issue up to the Court of Appeals. He said, you know what, court, you should have this was really a deviation. This is what the dad said. Okay, the court, he said, this is a deviation, and you ruled incorrectly here because you did not put any findings, any detailed information about why you deviated from the guidelines. Well, trial court and court of appeals said, no, 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 this is not a deviation. This is not a deviation. The trial court used the formula in the worksheets, and the obligation based upon that formula and all the information it plugged into the worksheets was $500 a month. Not more, not less than the presumptive amount. So that's not a deviation. So he lost on that argument. And another issue, of course, is did the trial court abuse its discretion in ordering the child support modification to be effective the last day of the modification hearing rather than the date the petition was filed? The Court of Appeals said no, trial court has the discretion to order the modification effective as of the date of the modification petition, the date it was filed, the date of the hearing, or any other appropriate date in between. So they have a lot of discretion there. Now, in this case, I will say the trial court did a really good job of going into detail, which really highly recommend all of you doing this in every order you do that has any kind of big issues in it. They went into a lot of detail as to why they declined to go back to the date the petition was filed. So they actually detailed 6 reasons why. Let me see if I can. Okay, 6 reasons why they did not go back. Dad had had numerous attorneys. There were times that he represented himself and his lack of understanding in the law, and he was overly aggressive in his, inappropriately aggressive in his representing himself that really caused problems. When he did have an attorney representing him, things went a little smoother, as you, of course. He was just very litigious. I mean, his litigiousness, I can't even say that, resulted in excessive delays. The court's file included 5 files and several buckets thick, a multitude of pleadings. So this was very voluminous. The pleadings were in this case as a result of all the filings. He also, in this case, mom had an adult son from a previous marriage, and I think the adult son had something going on, but it had no effect whatsoever on the daughters, the children of this case. However, dad made it an issue, and he was attacking her son basically inappropriately, and so that and causing more hearings to take place. And so that, again, delayed the modification hearing. Also, he just kept repeatedly violating the court's orders with respect to medical decision-making. He had, this is kind of crazy right here. He also filed numerous pleadings and displayed knee-jerk reactions, such as calling the police when mom was 2 minutes late. Yeah, 2 minutes late. How many times have we had that happen? 2 minutes late for parenting time, pickup or delivery or whatever it was in that situation. So that just caused more litigation, needless litigation. So while father's income did decrease, he still also had the higher earning capacity or potential than mom. Now, when I say that, dad, when the court made that finding, dad misinterpreted that finding. Dad thought that the court was saying that he was voluntarily underemployed, and that was not the case. So what they were saying was that he had the ability basically to handle just starting the modification effective the date of the last hearing, as opposed to going back 4 years. He was better financially able to handle that than mom, looking at their earning capacity, their ability to earn. He had a much larger earning potential than mom did. So if they had gone back to the day the petition had been filed, there would have been this huge overpayment, and then mom would have had a judgment against her, etc. And she could not handle that as well as he could. And he's the cause of all this. I mean, I think that was the bottom line, really, was he was the cause of all this going on for as long as it had been. You know, he made it go on an extra 4 years. So the court declined to do that. The Court of Appeals did affirm the trial court's decision on all counts. So, all right. I know I'm jumping through here. I'm sorry. I'm not keeping up with my slides on everything I'm talking about as I talk about them. I apologize. All right, so let's look at now the Lillard case. I know that Judge, she talked about this one earlier and did a great job talking about that. I just want to go into a little bit more detail with it because, you know, I've had this comes up quite a bit, actually. I'll say quite a bit. It comes up at least a few times a year in what I see from across the state with our child support cases. So I do want to go into a little bit more detail with it in some of the background, some of the facts associated with this. I think Judge mentioned that what she thought was unusual in this case is that the court included income for the child. And that is unusual. It's very unusual. And that was one of the issues that the dad brought up as a problem, that the court did not impute enough income to the child. Well, there were some other things, you know, you're dealing with in this case, the difference in a child being severely disabled and just disabled, but I'm disabled where support would go to the age of 21, or severely disabled where support would go past the age of 21. So that was a big part of this case right here. In this, the parties had, parties married in 95, child born in 97, divorce in 99. So a pretty quick turnaround there, just early on in the child's life. 2015 is when mom filed that petition to modify and wanted the child to be declared severely disabled. Well, dad agreed that the child was disabled. What he didn't agree to was the fact that she was severely disabled. So they did do some mediation. They reached a partial agreement that support would go until the age of 21, but they would leave it up to the trial judge to determine whether or not to make the ruling as to whether or not the child was severely disabled pursuant to the ADA. So that was the remaining issue for the trial court to determine. So let's talk a little bit about the details with this child, because this is something that you may need to, I mean, if you have this issue, you need to be aware of and know what you need to prove and some things to look for. You know, dad said, well, you know what? She's really not severely disabled because she graduated from high school. She graduated, I think, in 2018, 17, I believe it was, something like that. Fairly, you know, but the reason she was able to graduate, she graduated 2017 at the age of 18. She was able to do that because with the help of the Brentwood Learning Center. They were a very big part of that. But, you know, she had difficulty in school. She was in special ed classes. That doesn't necessarily in and of itself, or the ADHD, that doesn't in and of itself say she was severely disabled. But there were a lot of factors that went together that I think is what the court ended up saying, yes, she is severely disabled. In this case, she had, at the time, earlier on, she had an IQ of 51. I mean, very, very low IQ. Later on, it was 68, but still very, very low IQ. You know, she had always, you know, been living with mom. She could not work full time. As the judge mentioned earlier, she was working at Lowe's. She was a seasonal employee at Lowe's. What she did was she would help water the flowers. She would help people load things into their cars. That was basically the extent of her responsibilities and all that she could handle. Mom had some great witnesses in the case. She, including the daughter's employer or supervisor at Lowe's, who said that's really all the responsibility she can handle. She can't handle more than that. Daughter had other jobs over the course of those few years there, like such as working, I think, at one of the clothing stores. She did have, one of the things Dad brought up is that, you know, she also, even though she graduated from high school, but in addition to that, she received a certificate at Nashville Tech, or TCAT, one or the other, in being a helper at a child care. Well, she tried that. She wasn't able to do it. I mean, she was fired from that job. She just couldn't do that work. Even though she had that certificate, she still couldn't do the work. Another thing about like when she was working at the retail, one of the things about this daughter is that she couldn't tell the difference between a nickel and a quarter. You know, her mom had to take care of all of her transportation. The daughter failed her driver's test, and then she just wasn't able to do it, wasn't able to accomplish that. She couldn't take public transportation because, you know, she wouldn't look both ways. She didn't know, she just couldn't look both ways before crossing the street. Something as basic as that, she just couldn't do that. So it was very dangerous. She was also scared to death of strangers. I mean, she just had a lot of things going on. So mom, of course, was required to, she had to take care of her transportation. The daughter couldn't take care of her basic needs either without reminder. Like she didn't know to brush her teeth without being reminded. I mean, it was just a lot of things that this daughter could not support herself, basically. So it went, the opinion really went into a lot of great details with all of that. Dad, he barely testified. He testified basically that just to a little bit, because he hadn't seen the daughter in several years. So he really didn't have any direct knowledge of what she could or could not do. And the same thing with his family. They testified, I think his mom or the aunt or something testified a little bit, but they hadn't had a whole lot of, you know, dealings with the daughter either. So her witnesses were really great in it. And so the child was found to be severely disabled. The court did find that, you know, using the worksheets, using the child support guidelines really is not going to help here. So they needed to, the court looked at the income and expense statements for both parties and did look at the daughter's income. She was able to earn about $300 a month. The court assessed, I think, about $176 a month for the daughter as income for contributing to the household expenses. You know, she was able to pay her cell phone bill. She was able to pay, I think, the water bill in the household, something like that. Dad appealed it saying, oh, court, you should have been, she had ability to earn a lot more money than that. Why didn't you assess greater amount of money to her? So anyway, trial court's opinion was affirmed on all counts by the Court of Appeals. So there we go. This one went to go a little bit more with that one. Let's see. Okay. Judge went over the Potts case as well, and I don't think there was anything I wanted to necessarily add with that one. That was the one was dealing with the in vitro fertilization. One of the things about it was a same-sex parents. They had, they married, but they married in July of 2015 when the Oberfeld case came out. The twins were born 2014. Prior to them marrying, they had gone through at least 2 different civil ceremonies attempting to marry, even though, it wasn't legal in Tennessee, but they'd gone through that process. They had apparently a very ironclad contract they had entered into with the in vitro, the reproductive clinic in Georgia, to become prospective parents of any children born based upon their in vitro fertilization procedure. So, they did enter into an agreement and a parenting plan initially. And then bio mom basically had to change her heart. And she was like, no, you know what, court? The court lacks subject matter jurisdiction to enter into to allow this. So the trial court and the Court of Appeals said, nope, she's a parent. Both parents are parents here based upon the facts presented. They did mention about the part about the statute. Let me get to the statute here. Where is it? There is a statute, and I've got it in my information here, that when the parties attempt to marry, here it is, 362304 provides that a man, even though it says man, but there's also the statutes that say that you should use gender neutral terms or apply gender neutral terms unless something the opposite was meant to be, the intention was contrary. So in this case, the statute actually says a man is rebuttably presumed to be the father of a child if before the child's birth, the man and the mother have attempted to marry each other in compliance with the law, although the attempted marriage is or could be declared illegal, void, or voidable. So it was undisputed that the parties did participate in the 2 civil ceremonies prior to the children's birth. So this case did mention that, how our modern advancements in reproductive technology have created problems for the courts in applying the rigidity of the black letter of the law in determining the actual legal parents of a child. The advances and the changes in social mores have outpaced legislation designed to deal with these unique circumstances. Lives of minor children cannot be put on hold for the law to catch up and properly deal with these issues. So trial court was affirmed on all counts here as well. And I will say that that is an issue that I have brought up with DHS, with my office, because we deal with, legislative changes and things that we want to submit, and try to get approved, and changes in our statute, that we need our statutes to try to catch up with the law. Basically, some of the statutes, the way the words are written. Now, again, there is the statute that says that gender neutral should be applied if it's not meant to be otherwise. All right, let's rock on along here. Here's the pots, gosh, a lot of pots. Okay, I want to go into this case. How am I on time, Andy? Let's see. Oh, only have 9 minutes. Oh my gosh, see, never have time to go on this. All right, let's see. Let me find another one that's maybe a fun one here. I tell you what, let me tell you this one. This one is kind of a fun, and probably something, not even something you really have to have, but I just wanted to throw this one in there. And this one, sorry, making you dizzy. Donald Wright. This case, this is from a divorce. Now the appeal was in 2021, but this is from a divorce in 1947. I just had to throw this in for good measure. In this case, I just thought it was interesting because it kind of is telling of the time, in how things were handled way back when we didn't have DNA, we didn't have this and that. And in this case, the child was born in 1946. Divorce was in 1947. The pertinent fact in the divorce is the claim of adultery on the part of the wife and the denial of paternity by the husband of the child born to the wife. And this is the quote. I just like this this is just so antiquated. It appears to the full satisfaction of the court from all the testimony presented that the defendant is guilty of adultery and that said child is not the child of the complainant, Ernest Wright, and the facts alleged in the bill are true and sustained by proof that complainant has not been guilty of like acts and has not condoned the same. So he didn't condone his wife committing adultery. So anyway, no DNA, nothing like that was done back then. So this child, when he was 67 years old, filed an action actually out in California, filed a petition of determination of entitlement of an estate and request a copy of the trust, blah, blah, blah. So he wanted to inherit from his dad, basically. His dad had died a few years or 11 years earlier. So there were a couple of different actions that he filed. One was dismissed. One, the court did make a tweak or two of the final, of an order from previous. Then later an action was filed in Tennessee. There were 2 different docket numbers. It's like he appealed one, but didn't appeal the other. So it ended up everything being dismissed. But I just thought it was a fun case to talk about just because of the year. And believe it or not, we actually do have cases that come back many years later. I've had this a few times actually over the recent years, and one this past year where the divorce was in 1971 and the parties, it was a divorce out of North Carolina, parties moved to Tennessee, and Tennessee enforcing the final decree, or the mom was trying to enforce the final decree. It was based upon a temporary support order that had later been approved with the final decree in 71. The divorce order, the separation order was 1969. So both parties had gone through a lot of litigation in the 70s up to the Court of Appeals and back and forth. Nothing ever really happened though. I never, in all the pleadings I reviewed, which was like 500 pages worth, because I was trying to see, was there ever a judgment that was done after we no longer have the statute of limitation? You know, the statute of limitations used to be 10 years, and then you would have to renew that judgment. And then our statute of limitations no longer for child support. So I had to go over and review all those documents. But anyway, it was interesting that nothing had happened in that case since the 70s. And now all of a sudden in 2021, mom is like, I want my child support and I want my alimony. Like, I'm not sure what all happened over the years, but unfortunately, she wasn't able to do it because statute of limitations had run. Okay, let me see. I've got 5 minutes. Tykert case, I have that one, but I'm not going to go over that one because Judge went over that as well. Let me see if there were. Let's see, the Moody v. Roker case, that is another one out of out of Shelby County. In that case, the father was incarcerated. This is a UFSA out of Georgia. Mom and child lived in Georgia, and dad was incarcerated, had been incarcerated since 2016. And the Georgia sent a UFSA to Shelby County, Tennessee, to establish paternity for the child and to set child support. DNA came back, 99.99%, support was set, blah, 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 retro support was done, etc. Dad, though, he was incarcerated this whole time, all this was going on as far as the petition pending. He filed numerous pleadings, and actually his pleadings, I'm remembering the right case here, his pleadings were a lot better than some of the attorney's pleadings I have seen over the years. I guess he had a lot of time on his hands to be the jailhouse lawyer. I don't know, but he did it. He was doing a pretty good job representing himself, quite frankly. And he was asking for credit for retro, for money that he had paid for retro support. He filed. He wanted the court to bring him to court for the hearing. That was declined. One of the problems with this case, however, was that there were so many motions that were pending that the trial court did not rule on those prior to doing the final order. So they kind of ruled on them after the fact, or at least some of them. So they should have ruled on all those pending motions prior to, instead of waiting until after the fact. They also, another big problem with this case is, dad, of course, is incarcerated. Mom is in Georgia. They did not present any kind of proof whatsoever of income. They used minimum wage for both. And, I don't believe, from what I read on it and what I've researched on it, they didn't present the affidavit, the information that you can present on UFSA cases to show any kind of income information. So basically, it was the 4D attorney giving information to the court. And what the court said, or appeals said, unless such facts are admitted or stipulated, they must be proven by documents, affidavits, oral testimony, or other competent evidence. Mere statements of counsel are not evidence or substitution for testimony. So the Court of Appeals ended up remanding that back for a new trial. And dad ended up testifying by phone from court. And so they moved forward from there. But under find the statute for this, under 36.5.2316B, an affidavit or document substantially complying with federally mandated forms or document incorporated by reference of any of them, which would not be excluded under the hearsay rule if given in person, is admissible in evidence if given under penalty or perjury by a party or witness residing outside the state. So from what I could tell, that was not done in this case, and it should have been, and that would have been very helpful in it. So there we go. I think I am 2 minutes to spare. So any questions for anybody?
There haven't been any questions in the chat so far, but we'll give everybody a minute or so to get any last minute questions in.
I probably just put everybody to sleep, right? Because
you and Terica had the unfortunate situation of being right after lunch.
Yes, right after lunch, and at least hers was exciting. Hers was interesting and a topic that I had not, I think I hadn't heard that presentation before, so I like that. That was very interesting. Mine, now I love case law because I'm a nerd and I can read case law. I love it. But a lot of people find it boring. I just happen to like it. So, questions, anyone? Come on now, you got 1 minute. I guess I shouldn't have skipped all those cases that I skipped in there.
Well, if there's not any questions going to come in, thank you so much for presenting. It was a great presentation. And
Thanks for having me.
absolutely. Well, now we will go ahead and move on to our next presentation.
Bye, everybody.
And next up, we have Heather Grew, who'll be talking about the UCCJA. Heather, you should now have the ability to unmute yourself, share your screen, start your video, whatever you need.
Hello, everyone. My name is Heather Grew. I am an associate attorney at Crocker Carter Hall, and I'm here today to talk about the UCCJA and how wonderfully fun it is. I hope that y'all can stick with me and follow along. It is a circus, but it's always going to be our monkeys. So let's just dive right in. A little history about the UCCJA. It was initially wrote by the legislature in the 60s, and it was created as just one law to govern all interstate custody disputes, to try to, streamline all of the state laws that were confusing all of the custody disputes when people started to move and become a mobile society. They didn't really write it very well. They had a lot of holes in it. The legislature came back and wrote a few more federal laws trying to fix the issues, which only complicated it more. So in the 90s, they decided to revamp it. And that's where we have the UCCJA that we have now. It was created in 1997 to try to sweep away the enormous body of conflicting decisions that had been created by the original UCCJA and all of the other laws created, and just kind of create a simplified structure of jurisdictional rules that we could apply when trying to do a child custody determination regarding multiple states. The problem, though, that we continue to run into is each fact pattern with a interstate custody matter is unique, and sometimes the state interpretations of the UCCJA and the court interpretations itself can easily make a UCCJA matter pretty nightmarish and chaotic. So the UCCJA can be applied to multiple types of jurisdiction. There is initial, or what's known as original jurisdiction, when you're creating the first pleading the first time this child custody matter has ever been heard in any state. There is continuing jurisdiction. There is enforcement jurisdiction. And then there is contempt jurisdiction, which is different than enforcement jurisdiction. And then there is emergency jurisdiction that throws out all the other rules that were created for the last 4 jurisdictions. We will start with what was supposed to be the easiest part of the newest version of the law, which is original jurisdiction. There are 4 ways to have initial custody jurisdiction in a state. The first one is to create a home state analysis. We will not go into that right now. We'll do it next. It gets a little complicated. The next is that no other state can currently have jurisdiction. So there can't be an initial custody matter started anywhere else. The third is that another state has declined jurisdiction. So it could be in another state, but that court has decided for multiple reasons, it not being the convenient form or whatever, that they don't want jurisdiction. Or fourth, no other state could have jurisdiction. So in a home state analysis, there are two ways that you can create a home state analysis. The first one is supposed to be a very simple 6-month rule, where the child lived for the 6 months prior to the commencement of the action. That's where the state should have jurisdiction. The other way is the significant connection analysis. And that's where the state where the child did have a home state, yet no longer lives in that state, but one of the child's parents or legal guardians is still domiciled in the state. So when we talk about 6 months equals a home state for a child, that's true sometimes. A child that's an infant, less than 6 months old, the way that you analyze it, it's where the child has lived since being born, alive, outside of the pregnant mother's body. That is the child's home state. A period of temporary absence is part of that period. Remember that sentence. We will come back to it, and it is important. The way that you do not calculate 6 months is where the pregnant mother was domiciled or her intentions prior to the child being born. Some states have tried to use this as a 6-month analysis for the home state, and it doesn't work. We don't play that here. It shouldn't be played anywhere. If you hear it in a fact pattern, absolutely argue against it. It is where the alive outside of the womb child is. Another way we don't count where the jurisdiction for the home state is through surrogacy contracts. I know that seems pretty rare, but it has tended to come up in other states' case law when I was doing research. Do not fall into this trap. We will cover forum selection clauses regarding jurisdiction for child custody. Just know right now, we're not doing surrogacy contracts for jurisdictional analysis. Not going to work. So let's talk about temporary absences. This is what makes the 6-month analysis not really 6 months. A temporary absence is when a parent or a person legally acting as such takes the child outside of the alleged home state. This is usually when you've got a client that comes in and they say, I've been getting along with my child's parent and we've been trying to work it out without the courts and it's been working well, but the other parent took the child to see their grandmother in Texas and now they're not coming back. This is forum shopping. This is what the UCCJEA was created to prevent, but people do it every day. They try to take the child to another state and keep them there for 6 months so that they can make that state the home state. That state can handle the child custody matter. And if you argue properly, the absence from the home state will pause the consecutive 6-month home state analysis clock. You can toll it. And the way that you do that is you use the inconvenient forum analysis and factors provided in the statute to explain to the court why the absence should toll the home state calculation. The new state should not be the forum that's used, and this state should keep jurisdiction. And some of the factors that are used, you have to remember, us family law attorneys want to go straight to best interest factors. I'm talking about jurisdiction, and best interest factors are not considered in this. Some of the factors the court needs to hear are the familiarity of the court with the issues involved, where the experts, doctors, child's teachers are, which state they're in, the length of time the child has been in the state, the financial circumstances of each party, if they can afford to travel to a court outside of this state. If the parties have an agreement, which we will come back to in a minute, the nature and location of the evidence regarding the case, including the testimony of a child, If there's domestic violence involved or any other pending issues between the parties, and which state could protect the child better from things of that nature. So the UCCJEA and the Tennessee version of such defines the temporary absence as a person acting as a parent that has physical custody of the child for a period of 6 consecutive months, including any temporary absence within 1 year immediately before the commencement of a child custody proceeding. So remember, I just talked about the client that comes in and says, we've just been trying to work it out. When you hear that, your brain needs to start calculating, how long have they been working it out? How long has the child been gone? Because once you hit that 1 year mark, you've got a problem. You are doing it 1 year prior to the commencement of the action. So you need to say, hey, we need to go ahead and file. Hey, you really need to push this. Hey, look, man, we really got to get going on this. And when you apply this to the court, you really need to argue to the court that it was the intent of the parent that stayed here to never let the child have another home state. They didn't know why the child was really going. They would have never agreed to the child moving essentially to another state. They only agreed to a short-term vacation or visit. So you just have to argue that the inconvenient factors, use that forum analysis, and that the parent that's here still has a significant connection here to the state. So one easy part about jurisdiction for the UCCJEA is continuing jurisdiction. If a court has created initial jurisdiction, they get to keep it as long as one parent still has a substantial connection with the state, which means they still live here, and there is substantial evidence proving that, and you would use the inconvenient forum factors to prove the substantial connection. Back to the forum selection clauses that we talked about earlier. There were the surrogacy contracts. So the UCCJEA says an agreement of the parties to confer jurisdiction on a court that would not otherwise have it is ineffective. It's clear. It says you can't agree to it. You cannot ever, under any circumstances, not going to happen. But the Tennessee version of the UCCJEA created a caveat. It says when a party that is engaged in unjustifiable conduct in an attempt to make Tennessee the home state of the child, the court shall decline jurisdiction, not may, shall, unless all parties agree to Tennessee exercising jurisdiction. So if the parties agree, then they can choose for this state to have jurisdiction. When arguing against this, remember that unjustifiable conduct can really be used as for the temporary absence argument if the facts are there. So you can use it to toll the home state analysis that we just talked about. So keep that in mind as well. So some examples of how we are not going to use forum selection clauses is split jurisdiction. I'd read some case law regarding split jurisdiction from other states. And last night I was thinking, how could I relate this to Tennessee? And I remembered our relocation statute. It states that if a party decides they want to relocate and the court does not grant their relocation request, the court has to fashion a backup plan, a backup parenting plan. And in case the party still relocates, well, that can be a problem. And you need to keep this in mind if you run into this issue where you're going to have a court fashion a backup parenting plan, you need to keep this split jurisdiction issue in mind. And there is a case that I came across that I didn't have in my presentation, and I will send you the site if you would like. just email me. It's a case out in Nevada, and it's where a couple had filed for divorce and they had 3 minor children. The couple agreed that they may want to move in the future after the divorce. So the court put in the final order regarding the move some certain stipulations, and this should have never happened. If you have a client that says, hey, I want to move out of this state in a little bit after this is over, and so does my future ex-spouse that I'm co-parenting with, and I want you to put it in, no, you stop them there and you say, let's handle what we're dealing with right now. We'll address the move later. Don't try to confer jurisdiction. Don't create a forum selection clause. So in this case, the court said that the mom could move to Idaho with the children and then to California if she wished. If the mom moved to Idaho, she would remain the primary parent. If the mom moved to California and the dad found work in California, not necessarily had to live there, mom and dad would share joint physical custody. The court also stated Nevada would always remain the children's home state. Obviously, that's not allowed. And as you guessed, this didn't work out. Nevada could not retain jurisdiction because no parent lived there. Mom moved with the children to California, and dad had been visiting California a lot, but had not found work there yet. So there was really no court. Nevada couldn't keep it, and they couldn't enforce the order that they had because of the way it was written. So the bottom line is, just please do not fashion a backup parenting plan that allows for all parties to leave the state and expect for Tennessee to retain jurisdiction. It's just not allowed. So back to the surrogacy contract. There was a case out of Texas that I ran across. It was from 2011, where some same-sex couple was married. They got a surrogate out of California, and they created this contract with the surrogate in California and got an order put down in California that included that where the child would be born, that the surrogate parents would lose all rights, who would be on the birth certificate, where the child would live, and instructions for the hospital to follow. So that was entered in California, and a few days after the baby was born, they moved back to Texas with the child. A few years later, one of the parties filed for divorce. The other party tried to argue that the California order meant that California had child custody had jurisdiction over the child because of what was written in the surrogacy contract. If you have a fact pattern that comes to you that involves someone arguing jurisdiction through a surrogacy contract, not going to work. Remember, it's where the baby, the home state is where an alive child has lived for the 6 months. It's not where the child was or where you put in a contract the child should live or where the home state should be. Surrogacy contracts just should strictly be for who's going to be the parent of the children, who's going to love them, things of that nature. I don't try to practice surrogacy law, adoption, anything like that. And I'm not even going to step into that. I'm just saying, as family law attorneys, if you see something like this come across your desk, surrogacy contracts, form selection clauses, it's not okay. You can't use it to figure out jurisdiction. So let's talk about if you would like to register an out-of-state order, also known as a foreign order. You can register an out-of-state custody order without a request to enforce it. Usually, if that happened, you would just be doing it so that you could have it on file in case something went wrong, in case the other parent tried to snatch the child or something. I would say it's a good practice tip that if you register it, you should probably try to always enforce it. But there are certain rules on how to register it. You must first send a letter or a pleading, please be a pleading, to the court you would like to enforce it, and include 2 copies of the foreign decree. At least one of them must be certified. An affidavit of the person seeking registration with language affirming the order has not been modified, vacated, or stayed. The name and address of the person that signed the affidavit. The name and address of any person that has been awarded custody or visitation with the child or children, and request that the court register or file the foreign judgment. Then the court must mail a copy of the letter to the people at the addresses provided, along with notice that the foreign order is enforceable upon the date of registration, and the party has 20 days from the date of service to request a hearing contesting the validity of the order. 20 days. I don't know where they came up with 20 days, but it's 20 days. And they can fight the validity of this order. And this is kind of like having a second bite at the apple. If someone lost in the issuing court in another state, they can fight it one more time here through this. So be prepared for that. And there is a caveat here. Orders of protections, they do not have to be registered in the state to be enforceable by law enforcement. So you don't have to go through that process if you have an emergency. Just keep that in mind. So modifying the foreign order that you just registered, that's not allowed. It's not allowed unless you have established that this court of this state should have jurisdiction, except for there is a caveat, because the UCCJEA doesn't make anything easy. The caveat is, if an out-of-state custody order is not clear about a visitation schedule or does not provide a specific visitation schedule, a Tennessee court can issue a temporary order modifying the out-of-state custody order without having jurisdiction. As long as they specify in the order a certain period the order is valid, or that it remains in effect until another court changes it, until further orders of the court. So if you have a client that comes in and they have an out-of-state custody order that's very vague, or it just doesn't do what they want, you can use this statute to step right in and add some specifications to modify it without establishing jurisdiction, because why not? So say you want to petition for jurisdiction. You want to bring in an out-of-state custody case, and you want to make it Tennessee's. There are different requirements to be able to do that. And things you must have in your petitions for jurisdiction are a verification, an oath page. Absolutely. I know that that's standard, but some attorneys still miss it. A certified copy of the last known custody order attached, but a copy of the certified copy will work. Language regarding how the last court determined that they had jurisdiction. Language regarding if the last custody order had been modified, vacated, or stayed. The physical address of the child and who they have resided with. The physical address of the respondent. If you are seeking help of law enforcement, you have to specifically state the relief sought and the specific request for law enforcement assistance. So we can't use the normal, there is irreparable harm, or the TRO language that we're used to. You have to specifically state, I want the court to do this, and I want the police to do this to get what I need. You have to say that. You must also, if you use law enforcement, you have to request a hearing on the next judicial day. I don't know how they came out with the next judicial day, even in a DNN. I think we have 72 or maybe 84 hours, but no, it is the next judicial day. And don't ask me about service because I don't know. Language, you must also include language explaining if the foreign order has been registered, and if so, where, when, and the case style of the foreign order. And most importantly, you must argue how the court should have jurisdiction. So regarding the law enforcement assistant request, to recap, it must be included as a specific request in your petition. You do not have to register a foreign order to petition. You just have to say if it's been registered. But if you are going to request the assistance of law enforcement, you must register the petition. So in practice, if you're going to do this, I would just make your pleading heading, a petition to register foreign judgment and for jurisdiction to be established for modification. Just roll it all into one and get it all handled. You can ask the court for law enforcement assistance for an order for a party to appear before the court with or without the child. You can request for an order for immediate custody of the child. And you can request to the court to issue a warrant to take physical custody of the child to avoid suffering serious physical harm or being removed from the state. Don't forget, you have to set a next judicial day hearing if you request this. And also, an affirmative defense that the defendant can use is if the petitioner made the request without registering the foreign order. So don't miss that. You will be in trouble. Next, we have contempt jurisdiction. This is very complicated because the UCCJEA is very complicated. The UCCJEA about contempt states that a court of this state may utilize any remedy available under other law of this state to enforce a child custody determination made by a court of another state. The Tennessee version of the UCCJEA says that you can use any relief to enforce a registered child custody determination. Make sure it is registered. You would think in theory you would have to do that, but the UCCJEA said that you didn't. For contempt, the jurisdiction is kind of weird. So you can register a foreign order, bring it in, and Tennessee can enforce it, make someone follow the order. But if another state took jurisdiction from Tennessee regarding a child custody matter, but never modified the Tennessee order, Tennessee can still enforce it for contempt matters here, even though they've lost jurisdiction. That's where it can get complicated. There was a case in 2015, Blake. It was about some parties that were divorced in Tennessee, and they had 2 minor children. In 2010, the mother moved to Nevada with one of the children. And the other child stayed in Tennessee with the father. The parties entered an agreed parenting plan stating that the mother was the primary parent of one child and the father was the primary parent of the other. Shortly after that order went down, the son, which lived with the father, aged out. So the mother filed for modification in Nevada. Tennessee declined jurisdiction to the modification, and Nevada accepted jurisdiction and entered an order saying that they had jurisdiction. But Nevada never modified that parenting plan. 3 years later, the mother filed contempt in Tennessee regarding the MDA and parenting plan issues. And the ruling was that Tennessee had proper contempt jurisdiction since Nevada never modified the parenting plan. So some of the things that she had filed for, you would think were considered a child custody issue, but the Tennessee courts were very clear were not. So I wanted to talk about how they could be contempt matters that we still retain jurisdiction over. And it was the failure to take a parenting course, failure to maintain health insurance on the child, failure to provide proof of income and taxes. And they stated, although contained in the parenting plan, none of these issues directly related to custody or child support. So I guess now you can stay here to handle everything except visitation and money. You can use our jurisdiction here to handle it. Another way that you can get jurisdiction is through temporary emergency jurisdiction. And this part of the code throws out everything I just told you. You don't need to worry about any way to get jurisdiction, any analysis, any home state, anything. It's all done, out. Don't worry about it. Doesn't matter. Because Tennessee can assert emergency jurisdiction over a child custody matter without meeting any of the jurisdictional requirements if the child is in this state and abandoned, or jurisdiction is necessary to protect the child because the child or sibling of the child or parent of the child are subjected to or threatened with mistreatment or abuse. Any emergency, you can snatch that case from another state court and you can work on it here. And I mean, depending on how you argue it, you could probably argue it, keep it here for a long time. And note, there was some case law that I ran across that some parents through termination cases had tried to use the UCCJEA to say that the original DNN didn't fall under the temporary emergency jurisdiction of the UCCJEA, and it did. So anything like that will always run under that umbrella. A few other things that I would like to cover, and I just realized I'm going very fast and I'm very sorry, y'all. Child support is not included at all in the UCCJEA, no matter what. It has no authority. It doesn't matter. Visitation does not equal child support. Child support does not equal visitation. Child custody matters, UCCJEA, not child support. The UFSA controls the establishment, enforcement, and modification of child support orders across state lines. And the state that issues a support order has continuing exclusive jurisdiction. So this is especially true if the obligor still lives in the issuing state and has not filed for written consent for another state to have jurisdiction over child support. We can enforce a child support order, but we cannot modify under the UCCJEA. Another issue that I've seen recently pop up is people using the UCCJEA to get grandparent rights in. Now, I'm sure that most family law attorneys remember Moorcroft, but just to recap Moorcroft, I think some parties were getting divorced in Tennessee and had a few children. One of the parties' mothers, I think may have been an attorney, she got a grandparent visitation order out of Kentucky. And she registered it here and tried to enforce it during the divorce. And neither party, I think, wanted her to be a part of the children's lives or something like that. So the court said that the UCCJEA nor the Tennessee version provided adequate constitutional protection to citizens that are parents. And due to such, courts are not to follow the UCCJEA jurisdictional analysis for any request of grandparent visitation. They are to follow the jurisdictional rules in the grandparent statute. The grandparent statute has a substantial risk of harm analysis, and it has its own jurisdictional rules. And the Tennessee legislature, I think, foresaw that this could have been an issue. So they went ahead and wrote a much stricter version of how to get grandparent rights or visitation in this state. And also, foreign orders for grandparent visitation are not to be enforced by Tennessee courts. They are not a child custody determination under the UCCJEA. The court is supposed to follow the substantial risk of harm analysis in a grandparent statute. And gosh, I went super fast, y'all. I'm sorry. Attorney's fees, when you're doing any sort of UCCJEA action, know that there is code for all attorney's fees, so put them in your prayers for relief. You can request an expedited hearing under our version of the statute, and that should get you in quicker, but make sure you're not making your buddies mad by moving the trial that they've had set for a whole year off the docket. Don't do that. And lastly, the conference call request in your prayer for relief. Because there's multiple states involved, the judges are supposed to have a conference call with the other states' judges regarding who should have jurisdiction. And the rule is that attorneys and parties are supposed to be able to either be a part of this conference call and make arguments, or they should at least be able to have an opportunity to put on arguments through briefs and evidence and exhibits. Since this is a mini trial that could determine your whole case, you kind of have to be a part of it and push for it. There was some case law that said submitting legal arguments, even just through email, was just not sufficient. There needed to be participation by the attorneys and parties. If they weren't allowed in the call needed to be recorded, hopefully with a court reporter. And when the judge made the ruling, it needed to reference the content of the conference call and what made them, that content, how it made them rule and why. So make sure that you put in your request for relief this conference call and that you get to be a party to it and whatever specifics you would like to that, so that the judge is aware that they need to be prepared for, sort of a mini trial before you may even have a trial set. And I'm really sorry, y'all, but I have ran through my whole hour-long presentation in 37 minutes. So I guess maybe y'all would like to ask some questions. If not, take a restroom break.
If you got any questions, put them in the chat and we'll see if we can make this go a little longer.
I'm sorry.
Give it a few minutes. Nope, I am not seeing any questions come in. Next up is our break, so we can just make that break a little longer. There's a comment saying, great job, very informative.
Thank you.
So we can just extend that break a little bit, get a little more room to move around. So we will be back, if there's not any questions, we will be back at 3:15. Thanks, Heather.
Thank you.
You're gonna have to put them in the back.
All right, everybody, we will go ahead and get started with our next presentation. Next up, we have Deborah Owen. And Deborah, you should be able to turn everything on and share your screen if you need to. Oh,
Good afternoon.
all right, I couldn't hear you at first, but there we go.
Okay. I'm going to share the screen. You all give me just a second. Good afternoon, everybody. Thank you for letting me be with you today. I would like to be able to see your faces, but I can't. So I named this presentation Schools, Parents, and the Best Interest of the Child. I did that on purpose. Hopefully, the schools and the parents have that as their goal, and hopefully they'll be able to make decisions about the best interests of the child together. But that's what I want to talk to you about a little bit today. When Mary Jo first asked me to talk for the seminar, I thought, well, there is one thing I would like to say to lawyers in your field, but I didn't think I could make an hour out of it, to tell you the truth. So Mary Jo started telling me some of the comments she hears from her clients and some of the questions she gets from her clients. And I thought, well, you know, maybe I can say a few things that would be helpful to you. And so I certainly hope that I will do that. And hopefully I will fill the time that is allotted for this. Andy is monitoring the chat box. And so if you have a question, he is welcome to interrupt me, and we will address those questions as we go along. I understand that you have a copy of the PowerPoint, but I'm going to show it nonetheless. The first thing I like to do is kind of set the stage for what we're talking about today. You've probably heard this story, but bear with me if you have. A minister is preaching his sermon or her sermon, and about Romans 3:23, for those of you who might not recognize that, that is the scripture that says, for all have sinned and come short of the glory of God. And the minister says to the congregation, if you know anyone who is perfect, please stand up. And much to his surprise, an elderly gentleman in the congregation stood up. And the minister, taken aback a little bit, said, well, who is perfect? And the elderly gentleman said very convincingly, according to my wife, her deceased husband. I tell that story because I wanted to use it as an introduction to our clients are not perfect. Yours aren't perfect and mine aren't perfect. I know that mine aren't perfect when I get a phone call from a superintendent that says there's something on social media showing a teacher dragging a child down the hall by the ankles, or when a director calls about having to submit a teacher to the state board for possible suspension or revocation of a license because of an inappropriate relationship with a student or some other egregious misconduct. Or maybe just when our clients don't exactly follow board policies the way that they're supposed to, or follow state and federal law the way they're supposed to. So my clients are not perfect. Your clients are not perfect either. And I'm going to start by sharing with you some information about my own family. My youngest uncle, just slightly older than I was, married when, as did many people of his age, about the age of 20, and he and his wife gave me 3 lovely cousins. Eventually they divorced and he remarried. That's not the point. The point is that on their, what would have been their 50th wedding anniversary, my uncle sent his ex-wife a dozen roses. And I mentioned my uncle and his ex-wife because these are the kinds of parents that hopefully the schools get to deal with, because they are on the same page when it comes to their children. Then I'll tell you about my brother, who was married 3 times. And this is hearsay, but I believe it to be true. His second wife allegedly called his other 2 ex-wives when he died and said, let's all show up at the funeral and spit on his grave. My brother had children with 2 of his ex-wives, and needless to say, those children were more like footballs after their divorces. And I cannot even begin to imagine the trauma that they went through because of the conflict between their parents. I'm also going to mention, and you won't be able to see it, that's intentional, getting more into what really happens. I have in front of me a letter. It is on an elementary school letterhead. I'm just going to read you a little bit of it. It's signed by a school principal, and it says, "This letter and calendar are a result of a dispute between 2 guardian parents, Mr. X and Ms. Y, concerning who had visitation rights following the Christmas break." I'm going to skip most of the letter and read the last, next to the last paragraph. "The school is aware that this should not normally fall into our wheelhouse of responsibilities, but our main concern is for both boys. We do not wish any public disagreement to occur on our site in the future." Now, what that tells us is that there had already been a public dispute on school system property prior to this letter going out. The principal in this letter is exactly right. That is not the responsibility of the schools to settle disputes between parents. But it is amazing how often that happens, and our clients are called upon to try to figure out what to do particularly between divorced parents. I'm going to tell you that what I'm going to speak to you about today is generally the law. There are approximately 150 school districts in the state of Tennessee. We represent several of those, but certainly there are a lot of other attorneys who represent school districts. And what those boards adopt as their policies and what their attorneys tell them might be slightly different from what Steve and I tell our clients. Nevertheless, there are some generalities that I will talk about. And as I said, you're welcome to ask questions. I'll answer them to the best of my ability. If I can't answer it, you can send an email and I will be happy to try to get you an answer to that. We start from a very simple baseline, and that is something that you know, both in federal and state law. The Constitution protects the right of parents to raise their own children. And of course, as long as their decisions don't substantially, and when I say substantially, that's the way the case law works out, substantially endanger the welfare of their children. So with that baseline, let me go to the first question that I want to talk about a little bit, and that is, what school does the child attend? Who gets to make the decision about where the child is going to school? We know that even though parents have the right to make decisions about how their children are raised, there are some restrictions on that. And one of the ones is in Tennessee law, as in all the other states, and that is that the parents must cause their child or children to attend school. Doesn't matter if it's public school or non-public school, but they must cause their children to attend school. I'm talking primarily about public schools today. Non-public schools have a little bit more latitude, particularly if they don't receive federal funds or state funds to make decisions that might be contrary to what I'm talking about today. So I'm primarily talking about public. There is a statute that says any parent or guardian who fraudulently enrolls a student, uses an improper address, is actually responsible for or liable for the per pupil expenditure to repay that to the district in which they were fraudulently enrolled. I don't think that's enforced very often. What is going to typically happen is that the school district, if they find out that a student is fraudulently enrolled in the school district, is they're going to tell you they're no longer enrolled, tell the parent, they're no longer enrolled in that school district, and the child will have to go somewhere else. So again, they could be liable for restitution, but it's more likely that they're just going to get kicked out of that particular district. Here's the bottom line answer to the question. The Board of Education is required to provide for the enrollment in the public school for each student who, and this is important at the end of this slide, each student who is eligible for enrollment within the schools of the local school system. So the baseline is we're going to enroll the kids in a school district in which they live. Now, as you know, I'm sure you've heard it, sometimes there are disputes about that, but the baseline is the board gets to make the judgment about where they're enrolled. Except as otherwise provided, and there are some other state laws, the authority of the school board in the matter of enrollment of pupils within its system is final. Now, I'm going to tell you a little bit more about that as we go along, but it's up to the board. There's a statute that says no pupil is going to be admitted to any school other than the public school to which the pupil may be assigned pursuant to the rules, regulations, and decisions of the Board of Education. And local boards may, not shall, but may admit pupils from outside their respective school systems. If you haven't already figured it out, one of the things that you need to be aware of on behalf of your clients, or your clients need to be aware of, is that the first step in answering their questions about school districts is to go to the board policies. I don't know of any school district in the state of Tennessee that doesn't have a website. There is a statute that requires school districts, if they have a website, to put their board policies on that website. So basically, your first stop, if you want to get information about enrollment or residency or some of those things, is to look at the board policy. In those board policies, what you will find is, in addition to the fact that they may enroll people from outside their school district, they can limit the application period for non-resident students to come into a school district. They don't have to let non-residents attend, but if they do, there can be a set time when anybody can apply. So you've got two parents, one is in the school district, one is not. They would prefer that the child go to the district where the child doesn't really reside according to the parenting plan. Then this is one possibility for getting that child in the other district, is to apply for a non-resident transfer. The disadvantage of that, of course, is going to be that the school district can, if they admit the student, they can charge tuition to that student per the statute. Prior to admitting non-resident students, every school district by state law has to conduct what is called an open enrollment period. And that enrollment period, this is a recent change in the law, has to last for at least 30 days. You've got to give parents at least 30 days to apply. So the student is assigned, to school A, and the parents would prefer that the school B would be the school where the student would attend. Then this is a possibility. Apply for an open enrollment transfer to go to a different school. The open enrollment period is, once that has concluded, if there are too many applicants to go to a particular school, then by statute, the district has to have a lottery to decide which kids are going to get in there for the open enrollment. This district must allow the open enrollment students to be assigned to schools before they open up any opportunity for non-resident students to go to a particular school. So if you've got parents who reside in one school district and they want to go to a different school district, then they might get in through the out-of-district transfer. If they're within the school district and they want to go to a different school within the district, they might apply for that open enrollment transfer. Sometimes parents come in and they want to do something like an affidavit. They just want to bring an affidavit and say that I'm transferring custody to my ex-spouse. And you would be amazed how often school districts get these affidavits. Occasionally they're notarized. Sometimes, or frequently they're not notarized. It's just a piece of paper that says we're going to transfer custody. Again, I can't speak for all the districts in Tennessee, but I will tell you that very often the school district is not going to accept that. They're going to accept something that is legal from the court. They're not going to accept a piece of paper. Another thing that some people attempt to do is to use the power of attorney for care of a minor child to do the same thing. They want to assign the student from one residential parent to a different residential parent, and they'll try to use this document to do it. That's not an appropriate document, and I don't know of any school system that would accept that as a transfer from one parent to another on the right to enroll into a school. That is designed for both parents to assign caregiving responsibilities to another adult, not to another parent.
Hey, Deborah, we've got a question
Okay.
from Mary Jo. Are magnet schools subject to 49 to 128 and other statutes?
There is the only exception in the law, it would be for a teacher. The children of teachers are not allowed to transfer with their parent into a district to a magnet school. There's a state statute about that. And then if there are federal court orders governing the magnet schools, then probably they would not be allowed to go to those magnet schools. A lot of those federal court orders are disappearing, but there are still some in the state of Tennessee where school districts are under federal court order and they have magnet schools. Beyond that, it's going to be up to the school board. And when they open up their open enrollment, remember that comes first. When they open up open enrollment, what they're going to do in all likelihood is to have a lottery for the magnet school and probably fill up the magnet school first and then say that there are no seats for open enrollment. And I say that because there is no specific statute that I'm aware of that says magnet schools are not included in 49-128. I hope I answered that. I don't know of a statute that precludes magnet schools from being included in open enrollment, but I think as a practical matter, the way the school district would operate, that they would fill the magnet school with opt-in optional students before they would allow open enrollment students to go there. So they may be having a double lottery, but I doubt it. They'll probably fill it the first time. If it's a decent magnet school, they usually fill up very quickly with transfers for the magnet school itself. Good enough?
That's all I've got.
Okay. Sorry, I'm not sure if I did that right. Ooh, I definitely did not. Oh, I'm going the wrong direction. Okay. Now, you all are very familiar with this statute, I'm quite sure. And this is when you're doing your parenting plans, and this is, again, this is not in Title 49, which is the law that I deal with most of the time. This is in your section of the code where you've got parents who have an equal amount of residential time, the 182.5, okay? Then you've got all these possibilities about whether or not there is a primary residential parent, which can be waived or blah, blah, blah. You all know that law. But I want to pay special attention to the end of that statute that says, whatever that designation is, it shall not affect either parent's rights and responsibilities under the parenting plan. And that becomes very important when you typically in your parenting plans check joint educational decisions. And I'm going to talk about that quite a bit today. I hope I'm going to have time to do that. So joint, when you have a primary residential parent, the school district is going to say that is the school district where the child will be enrolled. And that parent's residence will be the place where the child will go to school. and that will be according to board policy. You also are very familiar, I'm sure, with the statute that says if the child is scheduled to reside an equal amount of time with both parents, the address of either parent may be used to determine school zoning. And quite truthfully, the schools don't care which parent is the primary residential parent. That is of no interest to them as far as the court assigning which parent is going to be the primary residential, or you all agreeing in a parenting plan who's going to be the primary residential parent. All they're going to care about is when they see it on the piece of paper, that will help them determine where the child is going to be enrolled. When they have parents who have equal amount of time, first, if they know about the statute, and again, I'm speaking with my experience with our school district clients. If they call us, we definitely make them aware of this statute, and we look at the parenting plan to see if it's got that equal amount of time. Otherwise, we defer to the primary residential parent. The problem with this statute, and again, we don't care which parent, it's immaterial to the school district which parent is going to be the primary residential. But if they've got equal amount of time and they are parents like my uncle and his ex-wife, this statute is not a problem, because the parents are going to do what's hopefully best for their children, and they're going to choose a school and leave the kid alone. The problem becomes when, and this has literally happened, thankfully it was not in one of my client districts, but literally we had parents with equal amount of time and they were in great conflict. So the parenting plan had the student with one parent for 2 weeks, and then the other parent for 2 weeks, and then the first parent for 2 weeks. And the parents literally unenrolled the child every 2 weeks and enrolled them in a new school district. I specifically entitled this Schools, Parents in the Best Interest of the Child, because that's not in the best interest of the child. School continuity is critical for educational achievement. And being present with the teachers, as we've learned during the pandemic, it's very important when kids are tossed back and forth, even if it's not every 2 weeks, even if it's every semester, or if it's every year, when kids are tossed back and forth, it is generally not in their best interest. So if you've got parents like my uncle, no problem. If you have parents like my brother and his ex-wives, the children are going to suffer if the parents toss them back and forth between schools. And that's something that schools do not like, but don't have much control over because of this statute. There is a statutory process that a lot of people don't pay attention to, but there is a statutory process where parents, if they are dissatisfied with the school assignment, it doesn't say school in the statute. It just says dissatisfied with the assignment of the student, but it's talking about the school assignment. There is an appeal process that is in this code. It's very detailed, and I'm not going to go into that, but it tells you that the parents can challenge a school assignment. But again, the board decision is going to be final. That's one of the statutes that I showed you earlier. I see something in the chat. Do I need to stop, Andy?
No, it's the only
Okay.
thing that's come in was Mary Jo's question.
Okay. Another statute that some people, and again, this is in your part of the code, that some people are not aware of, is that school officials are not permitted to change, and this is, I know it's old language, but physical custody during the school day unless there is a court order and advance notice of the school. I've only had to use that statute once. A father showed up at school, wanted to talk to his daughter during final exams, and he wanted to check his child out of school, and he said, nope, you can't do that. So without those documents, if somebody comes to the school to pick up a child, this is a statute that will help us prevent that from happening sometimes. So the bottom line on enrollment in school is that it's going to be governed by the board. The board has some statutory parameters like transfers and open enrollment that they have to do, but the board policies are going to define whether or not they will accept students. When they accept students, there's almost always a proof of residency requirement where the parent has to show something like utility bill in that parent's name or some other documents that show that they actually live at that address. I will tell you that school districts vary on how diligently they pursue that stuff. Some, they used to actually send people out to homes and inspect the homes. That's a little bit more dangerous than it used to be. So many school districts have stopped doing that, but that does not preclude school districts trying to check to see if somebody actually resides in that home and is it really the child, and is that where the child is supposed to be living? Remember, the fraudulent enrollment statute, people might have to pay, or even if they don't have to pay, they may get kicked out of that school district. Does the parent have input on other school decisions? And the answer to that is yes and no. Input, most school districts will seek parent input on a lot of the decisions that they make. Probably not so much about class assignment. Those decisions are made by the school and announced to the parents. And some parents will come back in and say, well, I don't want my child to have that teacher. And some districts and some administrators are more flexible about changing that assignment. Many times they can't because of, particularly in the high school, because of when courses are offered or how many teachers there are for a particular course. But input, yes. Retention and promotion, parents can have input. They can request that a child be promoted or retained. Ultimately, the decision is going to be up to the school. One of my clients actually had a parent to take the district to court because they wanted it was actually divorced parents, and one wanted the child retained and the other parent wanted the child promoted, and they couldn't agree. And the school sided obviously with one parent and wound up in court, but the court upheld the school district's decision. So input on retention and promotion, yes, but ultimately that's going to be a decision by the district. Instructional materials, by both federal and state law, parents have the right to inspect instructional materials. They don't have much control over the choice of those instructional materials. There is a recent change in the statute of Tennessee that says that parents can opt their children out of curriculum that has to do with LGBTQ issues. But generally, parents don't have much opt-out authority over instructional materials. Again, they can review them, but they don't have much control over what they are. Of course, there is a rampant disagreement across the country now about critical race theory and where that's going to go as far as parent control over instructional materials. I'm not sure. The Tennessee legislature did pass a statute this year that restricts school districts from teaching content that is supposedly critical race theory, even though the statute doesn't call it that. So I don't know where that's going. But as a general proposition, parents are not going to be able to choose the instructional materials. Disciplinary consequences are a little different. If the student is suspended more than 10 days, there is a statutory process for the parents to appeal that. So a couple of things, like I've already gone over assignment. There is a statutory process to appeal assignment to a school. There's a statutory process to appeal disciplinary consequences if it's a suspension over 10 days. Not all disciplinary consequences, but that specific one. And then most school districts have a broad general board policy that says something to the effect that a parent can disagree or challenge any decision of a school administrator as long as they have gone through the administrative process and they've gone through that process. They can appeal the decision of the school to the school board. and almost every district has some language that's going to be some variation about that. So input into school decisions is typically welcome, but the ultimate control over most decisions is going to lie with the school district. And I am right now, I'm going to come back to students with disabilities. There's, maybe some slight variation in that, but I'm going to get to that. Well, the thing that I wanted to mention from the school side of this presentation is sometimes schools are put in serious dilemmas, and that is particularly true when the parents have joint educational decision-making. Now, I'm very well of some case law about parents are supposed to enjoy the maximum participation in their children's lives. I understand that. I also understand the parameters of 36.6407 about making decisions about the joint educational decisions or joint other decisions, but I'm focused on education. And in that statute, it says that the parents have demonstrated the ability and desire to cooperate with one another in the decision-making. And I will tell you that they might do that when you're filling out the parenting plan, but very frequently when they get past that parenting plan, they quit disagreeing, they quit agreeing and begin to disagree vehemently about the decisions. And that creates a lot of problems for the school districts. So, and it's very difficult in this format to ask for input, so I'm just going to kind of talk through some of the things that, what would you do if you were in the position of the school principal? And I'd like for this to be interactive, but it's just not very possible under this format. So these examples are things that have actually happened in Tennessee school districts, most of them in my client districts, okay? So for example, we started this school year under face covering mandates. The governor pretty quickly after the beginning of the school year issued an executive order that said parents could opt out of the mask mandate. And now, because of the special session of the General Assembly, with the exception of a few school districts that are under federal court orders, the General Assembly has said that we cannot have a mask mandate. But in spite of that, many school districts still have optional masks. So what does a principal do if you have divorced parents with joint educational decisions, and one parent says, my child should not be in that school without a mask, and the other parent says, my child will not be in that school without one? One parent says no mask, the other parent says has to have a mask, and they have joint educational decisions. What is the principal supposed to do? Let me give you another dilemma. You've got two divorced parents with equal residential time and joint educational decisions. One parent is sitting in a school principal's office. I'm not making this up, folks. Sitting in the principal's office saying, I want to enroll my child in your school. The other parent calls into the school on the phone saying, this child is already enrolled in a different school district, and don't you dare enroll my child in that school. Now remember, they've got equal residential time, which means either address can be used, and they have joint educational decisions. Well, we can't split the kid in two. The kid needs to be in school somewhere. What does the principal do? I literally had a superintendent to call me one morning and say that that was happening while we were on the phone, and ask, what do we do? These are the kinds of very difficult positions that school districts are placed in when parents have joint educational decision-making. And there's many times there's just no good answer. We do the best that we can, but it's very challenging. So,
Deborah, we've got a few people who put their comments on the answers in there.
okay.
On the first one, Mary Jo said that it's not an educational decision, it's a health and safety decision. When it comes to the
Yeah,
mask.
and I'll comment about that, okay?
And then
We have been as a nation and as a state, particularly with a special session of the General Assembly to address these issues, that have created it as a political and educational decision. So whether I agree that it's health and safety. I don't have any dispute with that. We still have a principal sitting in a school with two parents who, forget educational decision, we have two parents and they won't agree with each other. One says the kid has to wear a mask, the other says you will not put a mask on my child or face covering.
so we've got one comment that says to the best interest of the child, not control any conflict between the parents with joint education decision.
Remember that the baseline is parents get to make the decisions for raising their children. And when you've got a school-based decision, whether you want to call it an educational decision or not, yes, best interest of the child should control. Who gets to decide what that best interest is? I started with the premise that it would be better if we were all on the same page, but sometimes we're not. So one principal or one school district will say, okay, I'm going to side with dad. The other principal in another school district might say, I'm going to side with mom. It's a very challenging environment to make those decisions. And what I would add, I'm sorry, go ahead.
Oh, no, I was just going to say, I was going to give the next one, but I'll let you
Okay.
finish.
Okay.
Okay, so the Mary Jo said for the second hypothetical, to enroll and let the court decide.
Well, unfortunately, that is exactly what we have to tell our clients many times. Now, your parenting plans usually, and I know there's no one size fits all, but your parenting plans usually now say that the parents can't go back to court. They have to go first to mediation. So you're going to have a mediation process in most of your parenting plans, and then possibly go back to court. In the meantime, we have a child who needs to be educated. And I'm not saying there are any easy answers to many of these things. I'm telling you that this is what happens in the school districts when you have equal parenting time. That one is not quite as frequent. The joint educational decisions, when I get to special ed, it's going to become even more critical. Was there something else?
That is all I've got for right now.
Okay, and like I said,
Take that back, Mary Jo just
Okay.
commented, move to waive mediation and ask that it be heard as an emergency.
Okay, that's when they're probably calling you. But all we can do is tell the parents, we're not the judge and we're not in charge of your parenting plan. You all have got to work this out. But again, even if you do it under an emergency, it's going to take time, and the school needs to move on and the kid needs to be in school. I agree. Best interest of the child would be that the kid goes to class and the parents go deal with the court or deal with the mediation or whatever. But it's still difficult for the school district. Let me talk about some of the other things that, and again, I'm not offering any perfect answers here. I'm just trying to say that when you check joint educational decisions, be aware that your clients, even though it's in an ideal world, like my uncle, it would be great. And quite truthfully, most parents that we deal with, that's how it works. It's the exception, the parents in conflict where we have constant problems. Let me give you a couple of other examples. and this actually happens, one parent is going back to court to try to get a change in the parenting plan, the parenting order. And I know they're, all that's going to take some time, but a parent will go into the school district, and they have the right to do this usually, and withdraw a student from school, particularly if they're the primary residential parent. They'll go withdraw the student because they think that they're going to get a change, and they're going to move or whatever, and they're going to re-enroll that child. And then either it takes a long time, or the court doesn't do what the parent expected, and that kid is out of school because the school district where they try to re-enroll the child won't take them yet. Now, I will tell you that school districts are not all alike. I hope I've said that clearly enough. Some districts will enroll and say, get me the paperwork later. But a lot of school districts will say, nope, it's got to be legal before you come here. And so if you have an opportunity to advise a client, don't advise them not to disenroll a student in anticipation of what they think a court is going to do. And you think they wouldn't do that, but trust me, they do. Another issue that we have all the time, and this is less, you have less control over this, as if you had control over what I've already been talking about, but we have this won't surprise you. We have divorced parents, and one parent calls the school and says, don't you dare let step parent, the new step parent on the other side, see school records, pick up the child after school, check the child out of school, attend parent teacher. It doesn't matter what the event is. The new step parent on the other side is not a welcome entity. There are both state and federal laws and federal guidance about the rights of step parents. And I will just say basically, and this is putting it too simply, but basically if the step parent is spending time in the home with the child, then they're probably going to have many of the rights of the parent. Maybe not all of them, but many of the rights. I think I need to move on because it's really important that I get to special ed, unless there's another comment or question.
There is one. Says, I'm wondering if tutelage is meaningless if the school is not taking charge of the child's educational interest, and why would the parent's interest control in this regard?
I'm sorry, would you say that again?
Yes, it says, I'm wondering if tutelage is meaningless if the school is not taking charge of the child's educational interest, and why would the parent's interest control in this regard?
If the parenting plan, the court order tells us, if the court tells us that the parents have joint educational decision-making, that is our controlling authority. We don't tell the court what to decide, but when the court tells us what to do, that's what we try to do. And it'll become even more obvious when I get to special education. I mean, school districts, and again, my clients aren't perfect, but school districts do, as a general proposition, try their very best to do what's in the best interest of the child. I showed you a letter at the beginning of this presentation where a principal sat down with a calendar and tried to figure out which parent would, supposed to pick up the kid every day and did it for the rest of the school year. That is not their wheelhouse, but they did it anyway. Schools will attempt to do what they can. But when it comes, when the rubber hits the road, we've got to follow the court order. And the court order says joint decision-making. And again, that becomes particularly important when we talk about students with disabilities. And I'd like to move to that because one of the questions that I'm going to address is, how do students with disabilities become eligible for services? That's not exactly how I received that question. If you want me to be perfectly honest, it was more of a statement. My clients tell me that we have to fight tooth and nail with the schools to get anything for our student with a disability. Well, that is not my perspective. I think for the most part, school districts are doing what they think is in the best interest of the schools. And for the vast majority of parents, the parents are not fighting with the schools. They're in agreement. They work together. They get services for the child. But sometimes there are parents who are going to dispute with the school about what the student needs, particularly when you're talking about a student with disabilities. So I'm going to have to run through this quicker than I thought, but I do want to give you just a very, very basic primer on the laws for students with disabilities. The Individuals with Disabilities Education Improvement Act, the most recent version is 2004, which we call IDEA. It's technically IDEIA, but we don't use that. And then there is Section 504 of the Rehabilitation Act of 1973. Section 504 is the precursor to ADA, and it is more about accessibility to get into and access education than it is about special services. So I'm going to focus more on IDEA, which is what we call special education. And I'm going to run through this, okay? And when I say basics at the top, I'm really talking about the basics. This is a very detailed and nuanced law, just like the laws that you all deal with are. The federal regulation says that a child with a disability means a child evaluated and having one of this list of disabilities. And if you don't qualify under one of these categories, with an exception I'm going to tell you in just a second, you are not going to be a child with a disability under IDEA, okay? States can have additional categories of students with disabilities under this law. And so this is the one time I've put in the Tennessee rule, because the state of Tennessee has added functional delay and intellectually gifted as special education categories under IDEA. You should know, in case you don't, or maybe you don't need to know, I don't know, but intellectually gifted is covered by IDEA with the exception that state law specifically excludes the discipline protections that other IDEA students get. Developmental delay, I've highlighted that at the bottom. That is in the CFR that was on the prior slide, but states can adopt that as an option, and Tennessee has adopted that. So Tennessee has a few more categories of special education disabilities than are required under federal law. So I would look, if you're looking at how can you qualify, I would look at, for this one, at the Tennessee minimum rules and regs. This is important. In order to conduct an initial evaluation of a student to see if they qualify for special ed, must have informed consent from the parent of the child. So how do you get an evaluation started? There's two main ways. Either the educators notice that there is some issue that causes them to suspect that this child may have a qualifying disability, then the school can try to start an evaluation, or a parent can request an evaluation. And if they are going to evaluate, particularly if the school initiates the evaluation, then they've got to get parental consent first. Even if the parent requests it, then they've got to have written parental consent, informed consent under the law. And you'd be surprised how many times a parent will ask for an evaluation and then the school tries to get the consent and the parent says no. Well, at that point, we have to stop. The school district also has to get informed consent from the parent after the evaluation before the child can get special education and related services. Special education simply means specially designed instruction. Related services are things like occupational therapy, physical therapy, transportation. Those are the types of things that are related services. So the parents have to consent for the evaluation. Once the evaluation's occurred, they have to consent for services and related special education and related services. And then if the second part of this, if the parent allows the school district to start special education services and then says, well, we've changed our minds, the school district must stop providing those services. The parents are absolutely in control about the evaluation and the provision of services under IDEA. The IEP, I was asked, what is the IEP? It stands for Individualized Education Program. There are 7 things, I'm not going to read these to you. There are 7 things that the regulations require must be in an IEP. And that IEP must provide FAPE, or free appropriate public education. And where parents and schools fight is not about free, because public education is essentially free. There's some exceptions. And if you're in a public school, it's public. So the fights are going to be about what's appropriate. What does my child need for, to be educated? So FAPE, this is the definition of FAPE. Again, I'm not going to read it, and I'm running a little bit behind, so I'm going to speed up. This is the format of the electronic IEP, and it's about 10 pages, and it covers all of those things that are required by the federal regulations. This is the second page. I'm not going to show you all the pages. If you really want to know, you can look that up. Another requirement under IDEA is that to the maximum extent that is appropriate, children with disabilities must be educated in what we call the least restrictive environment. In other words, as much as possible, they are to be educated with their non-disabled peers. So every school district is going to have a spectrum of placement possibilities, from a self-contained classroom where a child with a disability is going to spend all of his or her time to almost full-time in a regular education class with other students, or any variation in between, part-time in the self-contained setting and part-time in general ed. And the amount of time, that's one of the things you have to put in the IEP, is how much time the child is going to be in each different kind of setting. Parents must be a part of the IEP team, and they have to be aware of the meetings and have the opportunity to attend meetings when the school is going to develop that IEP. As a matter of fact, they have to get a draft IEP in advance of the meeting, so they have time to study it and get prepared to either agree to it or dispute it when they get to the IEP team meeting. I didn't put that slide in there for you. They have to be afforded the right to inspect and review all education records. Okay, then that's true for special education and for general education students, but there's a different statute for general education students. The parents of the child must be afforded the opportunity to participate in all of the meetings about the identification and placement of the child and the provision of FAPE, which basically means all of the IEP meetings. Parents have to have the opportunity to attend. It's up to the district to make sure that parents have the opportunity to be in that group to make decisions. And I'm repeating these. In order to evaluate a child, the parents must provide written consent. In order to provide services to the child, the parents must provide written consent. The parents must consent to the continuation of services. If they want to stop them, they have that right. And then, I haven't shown you this one before, but when the student is reevaluated, which has to happen at least once every 3 years, the parents again have to provide informed parental consent. So again, that's just a very quick run through of the basics of special education law. But here's the dilemmas that schools run into with respect to special education. Federal guidance, it's not, I can't give you a CFR or a code citation because it's in a lot of different guidance documents. But the federal government defers to state law when it comes to which parent gets to make the decision. When you've got divorced parents with a parenting plan that says joint educational decisions, then federal guidance defers to that rule for making these informed consent decisions. So if you're the school's administrator, or if you're the IEP team leader, what do you do when you have divorced parents with joint educational decisions, and one of them says, you may evaluate my child, and the other one says, you may not evaluate my child? And the federal guidance says, defer to the state, and the state has told us that the parents are to jointly make that decision. My understanding of all of the federal guidance is that if the parents don't agree, we are stuck. Even if it's in the best interest of that child to continue with an evaluation, we're not supposed to do it. I will tell you that there are school districts out there that I think are continuing with an evaluation with the consent of one parent. What they do, sometimes they get away with it and sometimes they don't, because the other parent can always take the school district to what the due process procedures that are provided in state and federal law. What do we do if the student has been evaluated and then one parent with joint educational decision says, yes, I want my child to have special education and related services, and the other parent says, not no, but heck no? The school district has the same dilemma. Do we provide services to the child in the best interest of the child? Many times the district would say yes, but technically under the law with joint decision-making, we're stuck. If they have been receiving services and it's 3 years past the initial evaluation, they have to have a reevaluation. You have joint decision-making and the parents disagree. Do we reevaluate or not? Same exact analysis. Under the federal guidance, as I understand it, we are not to move forward without agreement by the parents. And I understand that you can go to court, you can go to mediation, maybe you can waive mediation. I've got all that. It takes time. And again, in the best interest of the child, we probably need to be able to move forward. I'm saying all that to say, when you check, and I understand the preference for joint educational decisions, I got that. And I even believe that that's the best scenario. The problem is the conflicting parents put, I'm sure you, but especially put the schools in a situation where they can't always do what's in the best interest of the child. Do we have more chat stuff?
No.
No, okay. I thought we did. Now, those are the critical decision-making dilemmas that we get into under special education, but there are other things that happen with conflicting parents. Both parents are supposed to be able to have the opportunity to attend the IEP meeting, but one parent gets a restraining order against the other one. And so they can't be in the same place, and yet by federal and state law, they're supposed to both have the opportunity to be in that meeting. We manage that usually by doing one party electronically, but still it's not the best scenario. We have some parents who are in conflict who just will not meet. I won't be there if my husband's or my ex-husband is there, or vice versa. We have parents who are in conflict and they won't share information with each other. Or you have parents who disagree about the IEP, what's in the IEP, what services are going to be provided, what related or special education services is the child going to get. And one parent wants one thing in the IEP and the other parent disputes that. Well, again, there's some due process procedures in the law, but if we're talking about the best interest of the child, then we need to make a decision and move forward with getting those services to the child. Now, I'm going to go back to where I started earlier. Schools aren't perfect. My clients are not perfect. I'm not going to say that every single school decision is the right decision, but for the most part, the educators that I work with want to do what's best for the kid. And again, not being perfect, I do think that that's what they're generally trying to do. And it's very helpful if we have some way to break the tie when there is joint educational decision-making. That's fine with us. As long as it works and it doesn't do any harm to the child until the dispute is worked out between the parents, If it's not harming the child's education, that's okay. But where we think it's hurting the child's education, it would be very helpful to have a tiebreaker. If they can't agree on these legally required decisions, particularly for students with disabilities, who gets to break the tie so that we can move ahead with the kids' education. And I'm not sure you have control over that, but at least maybe if you understand the problem, maybe it will help you as you work with your clients. I'm running out of time, so I'm very quickly go through a couple of other things. Section 504 of the Rehabilitation Act, as I already said, is the predecessor to the Americans with Disabilities Act. The definition under both of those is the same. You're talking about a person or student with a physical or mental impairment that substantially limits one or more major life activities of the student under the ADA, and these two laws are interpreted very similarly. Under the ADA, that's very broad. But again, Section 504 is about access, being able to access the educational system, not so much about, as IDEA is, any kind of tailored educational content or any kind of extra services, although 504 students can get some related services. Another one of the questions that I was asked about is, what should a parent do if his or her child is being bullied at school? The first thing that I will say is that bullying is a word that is thrown around a lot. It is a very serious problem. I am not denying that whatsoever, but some people throw the word around when it's not appropriate. For example, I tell people that my son-in-law harasses me with blonde jokes. Well, he does, but that's not legal harassment. And some parents say their children are being bullied when truthfully they're not. Again, refer to the district policies for the definitions of bullying, or to state or federal law. There's plenty of definitions out there. But having said that parents throw that word around sometimes too lightly. There are students who are bullied at school. And Tennessee law, as well as federal law, but I've put the Tennessee statute in there, every school district must have a policy, and that policy must include a procedure for reporting and a procedure for the prompt and immediate investigation of that allegation. So if a parent truly believes that their child is being bullied, they need to document that in writing to a school administrator with as much detail as possible. It's not helpful if the parent just calls and says, my child is being bullied at school. We need to know how that's happening. Is it cyberbullying? Is it physical bullying? When is it happening? If possible, who's doing it? In other words, it's very difficult to investigate when we just got, my child is being bullied. So if the parent can document as many details as possible, that is helpful for the school district to do that investigation and try to address. And they are required to address bullying, true bullying, they're required to address it. So having said that, on educational decisions, general educational issues, and enrollment issues, consult board policies and contact the district's attendance supervisor. Every district in Tennessee is required to have one of those, or school administrators. If you're talking about issues with students with disabilities, again, you're going to find some content in board policies, but the best people to contact will be the school administrators, the district's special education supervisor, or the IEP or 504 team leader, depending on what the situation is. Those are the persons that I would suggest you contact. I am so sorry I rushed through the end of this, but I do appreciate the opportunity. I don't know if it was helpful, but I certainly hope that it was.
Great. Thanks so much, Deborah. We will go on into our last presentation now. Next up, we have Alex Camp. All right, Alex, you should be able to unmute yourself, share your screen, all that stuff.
Okay, let me see what I can do here. Can you hear me?
Yes.
Great. Now, how do I find out where my presentation is? Do y'all have it up? Or how's everybody?
Everybody was given it, but everybody's been sharing their own from their screen.
Okay. Well, shoot. Bear with me real quick. I see share screen now. Great.
Yeah. Alex, I've got it pulled up on mine. You want me to share my screen?
Yes, I do.
All right. hold
I'm
on.
looking for the system preferences, but I'm trying to see.
Actually, I take that back. Hold on 1 second. Make sure I do the right one. Sorry, my computer's being slow too. All right. All right. All right. Let me just make it full screen and we'll be good to go.
Thanks, Andy.
You're welcome. There you go.
Okay. Well, hello, everyone. It is a pleasure to be your keynote speaker at the 4:22 hour on Friday afternoon. I know that's a very competitive time, and I was fortunate enough to be able to be selected for it. So let's dive into it. I have the pleasure of introducing to you all the language, justice, and cultural humility topic. And I think the reason why I got selected for this is because I have a knack for being able to speak the Spanish language. And because of that knack, I have had the opportunity to be able to represent a large portion of my clientele, being the Hispanic population. And so in doing that, I've come across and come to learn certain nuances of the importance of this topic. And so in saying that, this is the title, Presentation by Me. And Andy, if you could move to the next slide. Okay, so this is what I'm going to dive us into. 7 things that a culturally aware attorney must keep in mind. If we could move forward. All right, so what I more or less gather here is we're a melting pot with people from all over the world. If you're a participant in this seminar, it's highly likely that you in your practice have encountered and represented people from all ethnic, religious, and racial backgrounds. What's critical, in my opinion, is we must understand and be sensitive to the fact that many non-English speakers specifically find our language, legal system, and the American way of life in general to be foreign and confusing, to say the least. Okay, so what is language justice? The first thing that we ought to be aware of is that language justice, in my opinion, is the right everyone has to communicate in the language in which we feel most comfortable. And one thing that I first came to learn when I dove into this practice is that speaking to an individual, a client, in their language opens up an endless supply of information and ability to provide the best representation I can for that client. One thing I've noticed personally in handling these clientele is that they are very timid, reserved, and almost seemingly mistrusting of an individual until they are able to speak to you in their language. They're certainly more comfortable in their language. I don't think anybody doubts that, but it's, in my opinion, at least in my experience, very fruitful, because whenever you begin speaking to that individual in their language, it's often difficult to get them to stop talking to you. It's almost like they've been begging for an opportunity, and it's a refreshing breath of fresh air for those folks to be able to open up and communicate with you. They certainly become more comfortable. And I think that's justified. And I think that that's deserved. And I think a lot of times they're not understanding. And it's very obvious and apparent in my experience that that's the case. So what I say is there are linguistic and cultural nuances as well, sometimes lost in translation, that can make the difference between winning and losing on an issue. And what I mean by that portion of this paragraph is that essentially, from my experience, one thing in Spanish and concepts in Spanish may be different than those concepts in English. And concepts culturally for my Hispanic clientele may be different than those concepts in English. And if you don't understand truly their background or what they're saying, then it's very difficult to represent them effectively on the issue that they're presenting. And so, to be frank, I think language is so critical in our line of work, in our field, probably more so than a lot of other fields, that it's important to fully understand and grasp that client's interest through their language. Now, conversations between a client and attorney can become very personal. And that's another thing I point out. So it's important to provide their language to them as an outlet to concisely explain their true feelings. One thing that we have the benefit or ability in our line of work is we do dive into very personal emotions and effects of our clients. And from experience, from everyone's experience, quite frankly, listening to this conversation, everyone has had a very personal conversation with a client at some point in time. One thing I've noticed is providing them their language helps you dive into that valve of being able to get personal with that client and being able to get information that and gain trust in that client. One thing that I've learned in addition to that is trust is key with your client-attorney relationship. I tell my client oftentimes, I want to be prepared for a negative issue that you're going to tell me the truth about, hopefully, months in advance, not 5 seconds in advance. And to be honest, I can be quick on my feet sometimes, but obviously, I would much prefer to have myself an opportunity to prepare for that and explain and fully flesh out whatever issue that may be. And concisely explaining that issue with the client is important. And so that's more or less how I dive into and I view the take on language justice. We could move on to the next slide. And Andy, part of this screen sharing, I can't necessarily see myself or if there's any comments. I think I'm on your screen.
Yeah, I'll monitor the comments. If any
Okay,
come in, I'll let
appreciate
you know.
Thank you, sir. All right. The next thing that a sensitive attorney or that a attorney must do, I think, to be culturally aware is be sensitive. And what I dive into that is an attorney must be sensitive to the fact that people from different cultures or religions may have a different view on marriage and divorce. And one thing that I've noticed in my line of work, and the key to that sensitivity, is dealing with different backgrounds yields and produces different opinions on divorce or on marriage or on custody or those types of issues. Some families and backgrounds may hold the male or the patriarch figure of the home as a very dominant figure, that essentially the wife may not have a full understanding of her rights as she goes into a divorce proceeding. Education is lacking a lot of times in the legal field, especially when they don't possess the ability to communicate or understand our language. And in doing so, we have to be sensitive to the nature of their circumstance, because truly, and speaking for myself, more so than others, I can't relate necessarily to a lot of these individuals' backgrounds, experiences, and circumstances. So all I can do is more or less be sensitive to the fact, or mindful of the fact that these individuals, may not fully understand or appreciate their rights and things. And so being able to conceptualize different viewpoints and accept, for what they're saying to you is very helpful. It's helpful in being able to explain to them their rights and have them understand things that are important. Religion becomes a big factor for some of the individuals that I help, because it may be them of the opinion that, well, Alex, when I entered into marriage, it's against my religion and my culture to divorce. I can't divorce. It's a religious violation, which is going to be the most devout thing in that individual's mind that they could possibly cross. So it's a difficult conversation, because I'm not necessarily in a position to advise them that if the husband wants a divorce in this community, it's very likely he'll be able to obtain it. And if he doesn't have the same religious viewpoint as my client, that becomes a very difficult explanation. And you've got to be sensitive to that feeling and that issue, because it can be impactful, it can be moving, and it's just something that I try to handle delicately. Now, an attorney who truly understands the client's culture will know how to effectively explain certain customs, rituals, religious perspectives, or why something's important to that client. I say this portion because, again, kind of going back towards that language justice notion, understanding their culture and their background oftentimes helps emphasize things that are very important to the outcome they're seeking. And so, though it may not be important to you, your opinion's not necessarily relevant in a lot of circumstances. And so I maintain an urgency to be sensitive and mindful of things that, although you might find yourself in disagreement personally, that's not really a relevant play, as long as it's appropriate, I suppose, or legal. I mean, you've obviously got to maintain, ethics, but if they are doing something or stressing something important to them, we have to maintain a sensitivity to their wants and needs, even if we don't fully understand. And so there's a certain level of respect that we owe our client, and sensitivity is no exception here. Thank you. If we can move to the next slide. Okay. The next thing that a culturally aware attorney ought to do, number 3, is listen. Now, what I've got here is an attorney must listen to what you're saying and also try to put things into context of where you're from. Listening is a powerful way to glean knowledge about a matter, and sometimes may be the only way to glean certain knowledge, like credibility evaluation, things of that nature. In researching this topic, it comes to mind that listening, quite frankly, is an ethical duty that we as lawyers have and owe to our client. I cite this Rule 1.4 of the Model Rules of Professional Conduct that sets out a duty of communication. And though it doesn't use the word listening explicitly, I think it implies its importance. Under this rule, 1.4A2 specifically, the lawyer shall reasonably consult with the client about the means by which the client's objectives are to be accomplished. Implicitly, this means listening to the client about the client's objectives. There's a commentary that states when the client must make a decision about the representation, the lawyer must promptly consult with and secure the client's consent, unless prior discussions have resolved what action the client wants the lawyer to take. So through its reference to consultation and discussion, this rule establishes an implied duty to listen. This duty has a substantive and procedural component. The substantive aspect is that a lawyer must listen to what the client says regarding the client's objectives, as well as the means of accomplishing them. Listening is implicitly required because the lawyer cannot reasonably consult about these things unless the lawyer has, to some degree, listened to the client's point of view. If you don't know your client's culture or background, I encourage you to listen and learn. Now, in saying that, essentially, how can you convey your client's position without first having listened to their position? How can you communicate the legality or the circumstances or the outcomes of their position without listening to them? And so to be mindful and aware of their position is to listen to their position. And so I think that's critical to maintain that cultural awareness that I'm trying to encourage you all to hopefully open your minds if some of your minds have been closed to it. I doubt in this bar that any of your minds have been closed to it. So what I'm saying is falling on everybody's agreed ears, I'm sure. But nevertheless, that's my position on listening. We can move on to the next slide. Expectations. Now, we've talked a lot about what the client wants, what the client says, what the client thinks, what the client feels, and I know all of that's important, but lawyers obviously have to maintain their own and stroke their own ego. And expectation here is an attorney must explain to clients what to expect based upon the legal system, but also understand that the expectations of someone from a different cultural background may contrast. So I put this prong as relevant because, to be frank with you all, they come to us because they want us to assist them in the legal system. We're their guide, we're their hand, we're their source. We possess the knowledge. We went to law school. We've trained and gained experience. And so at the end of the day, these clients are going to be looking at us and looking to us to provide them the service and explanation and representation that they're seeking. So obviously we have to keep in mind and explain to our clients our expectations and allow them to gain an understanding of their rights in this legal system. But of course, one thing that comes to play in this different cultural background that may contrast, in my experience, is mischaracterizations that sometimes come to play, or misunderstandings, or thoughts that are completely in contrast with what's legal. You all may or may not be surprised, may or may not have been surprised throughout the course of your practice in folks thinking things are done certain ways because what they see on TV or what they hear from their friend or what they just think. Maybe, for example, if I pay enough money, I'll get accomplished what I think ought to be done. And that's not always the case. How much does this cost, Alex, to make it go away? That's not always the case. And so those types of expectations need to be, with all honest and fairness to our client, dealt with appropriately and accordingly. And so in saying that, I think that oftentimes different cultures and applying different cultures that our clients possess and in coming into our culture is a culture shock. And it's a different expectation or circumstance or scenario that, jumping back to sensitivity and listening to those clients and their explanations and thoughts, sometimes require us to still maintain our own footing in what we know is appropriate, what we know is right, and what we think is appropriate and right at times too, in the best interest of our client and representing them as effective as we can. You want to move to the next slide? Do we have a?
We actually do have one question.
Hey,
Says,
Dr. Reed, what you got?
how would you achieve this when the attorney's mindset is to prevail?
Now, Dr. Beach, you have me lost on this. How do I achieve what, sir? Which prong are you referring to, I guess? Would be I've got to follow up with a question.
I was going to say, it came in when you were on this prong, but it was at the very beginning. So I'm not sure if it was on 3 or 4 is when he typed it, of trying to understand the culture.
Right. Okay. Well, so this is where I get to answer it depends, which is a fun answer to say, but in my opinion, oftentimes I would revert back to that listening prong. And what I would say is you gain insight from a client's position or relation back to an experience or dilemma from their explanation. And they may even invite you into what they're accustomed to in terms of their culture. And so whatever insert variable dilemma here comes to play, hear them out and explain to them, because oftentimes I've seen it both ways, but clients will surprise you with excellent ideas. And I adopt those ideas oftentimes. I'm balancing a lot in my practice, and as I know you all are as well. And that's all they focus on is their case. So sometimes when they put so much thought in something, they come up with some good ideas, but you can play a filter system as well, which is to their benefit. But ultimately, I would say that you achieve an understanding through listening to those clients and applying your legal concepts to whatever their situation is. If they're there, though, Dr. Bede, to see you, they want to win. And the attorney wants to win too. So the mindsets are unified. Or you just want to see a fair outcome, maybe, or something to that effect. You want to gain an agreement at minimum. And so understanding culture is important in so many ways. That's just to name a few. But if it's culture to have to explain to them, it's maybe a bit different here, and being sensitive to their culture, but making them aware of what's legal, that may be at play. If it's explaining to them, or them explaining to you, this is very important for me pursuant to my culture. And you have to be sensitive and mindful of keeping that importance in the back of your mind going forward when you're representing them. You're always going to gain the advantage of having your client in your corner, trying to be aware of understanding their background. That's important to them. Clients like to feel like you care about them. They'll say to you oftentimes, or say to me at least, I know you've got a lot of clients, Mr. Camp, or I know you're a busy man. And it's just it sounds almost ironic and to an extent, I would almost suggest that they're not meaning what they're really saying when they say that, because you don't want to make them feel unimportant. They need to be made to feel important. And so understanding their culture can only help that. I hope that answers your question, but please feel free to shoot me another one if you need some more, or you want to go into conversation with it. But anyways, Andy, if we can move on to the next. Okay, holidays. So this is another example that comes to mind with culture. And one thing that I've noticed that, it just kind of dawned on me in actually looking into this is we use a very Americanized, understandably so, version of a parenting plan. And they have adjusted even since I began practicing way back in 2016. Now we have Spanish translated parenting plans. But one thing is, the Spanish translated parenting plan, make sure you're going to celebrate July 4th. And perhaps my Guatemalan client from Guatemala that came over here doesn't necessarily recognize that holiday. Or my Mexican client. And my Mexican client may think that Dia de los Muertos is something that's very important for them and their children and customs and background. And I don't see that holiday represented in our parenting plans. But I'm not advocating that we need to contemplate every single holiday in a parenting plan or encouraging extra work for us on a parenting plan. But what I am saying is maybe that should be taken into account. Because even though those holidays are atypical to our culture and our customs, they may be significant to other backgrounds. And those folks may not know to ask you that question. They may not understand. They may not feel comfortable. So part of being able to access that personal conversation, show that sensitivity, listen, make them feel important, and overall get them in your corner. It may be suitable to ask them about celebrating holidays of that nature. Something like Ramadan or Diwali, or like I said, Dia de los Muertos, or National Hot Dog Day. I mean, there's every single day represents something. And so, at this point, but tying in different cultures and different folks' background is relevant and important and shows cultural awareness, which is why I put number 5, holidays, as the 5th concept for a culturally aware attorney. We can move on to the next one. Okay, translations. Folks, this one, in my opinion, is the most critical. And the reason why I say it is because I promise you that in my experience with my Hispanic clientele specifically, when they nod their head yes, they don't understand you oftentimes, more times than not. That's just a courteous way that they act like in a gesture they know what you're saying, but they really don't. There may be full-blown English speakers that nod their head yes to your contents in your MDA or your, whatever, insert legal jargon here, and they don't have a clue what you're saying or what's going on. There's oftentimes we're in the courtroom and the only 3 people that know what's going on is the defendant's attorney, the plaintiff's attorney, and the judge. And it's easy to forget that. It's easy to neglect that. But at the end of the day, to provide the most effective representation we owe, in my opinion, to our clients, we have to make sure they understand. That avoids future hassle, that gets the message across clear, and that provides the best representation that we can do. So attorneys should be aware that translations of all documents are key. If you are aware that your client does not speak English, that document that they receive in their hand needs to be translated in Spanish or whatever language the client is proficient in. Judge Butler, that I can say for certain, required all documents be translated in Spanish for my Hispanic clientele, whether it be an MDA, a final decree of divorce, a parenting plan, what have you. If he was going to sign his order to it, he signed that order, he signed the Spanish order, and he signed the English order. I think that's important, and I agree with him on that. And I hadn't had one with Chancellor Moroni yet with a Spanish client, but I'm sure Judge Butler's passed the message along, or Chancellor, if you're listening. It's just something I think is important. So I would just encourage continuing on that trend, because it avoids headache and confusion in the future when they're reading it in their own language. And Google Translate is, Google Translate is an excellent translator tool that will provide actual and substantive meaning of those documents. And in essence, folks, even though I know it may not be orthodox or fully certified, at the very least, this Google Translate, I've seen from experience, is it's good. It works well. And these translating tools are getting better as the days go. And so that is a nifty thing. Get on Google, type in Translate. There are hundreds of languages that you can translate from English to whatever language needed, and take care of your clients in that respect. Okay. All right, my seventh prong. If there are issues involving green cards, citizenships, visas, it's imperative to find out those implications and deal with them. Now, I cited a case from the Supreme Court as relevance, persuasive authority at a family law seminar, but nevertheless important. And what that is that case, if you all are not familiar, decided an ineffective assistance of counsel concept, and that was failing to advise a client of immigration consequences upon a plea of guilty or a finding of guilt. Rather, more important, a plea of guilty in a criminal context. In this instance, the defendant was actually a long-term permanent resident. He had a green card, which is a permanent resident card that provided him essentially a permanent stay in the United States until he pled guilty to an offense, a criminal offense. Deportation initiated upon his plea of guilty, although his attorney had advised him there was no way that was going to be at play. The Supreme Court of the United States took this case up, and they held that ineffective assistance of counsel exists in not advising the client of this consequence, this deportation consequence. And it resulted actually in enough prejudice to reverse and remand his conviction. I would argue to you all that from a practical standpoint, this impact affects more areas than just criminal law. I would say that, for example, one thing I've noticed in my practice is there are oftentimes very bitter divorcees. And I notice citizens marrying non-citizens, and those non-citizens losing leverage in custody issues by virtue of the citizens claiming that they have more permanency and therefore more rights. And folks, that is simply not the case. And we all know that. And to be frank with you, you see very unfortunate circumstances at times where, maybe the citizen spouse will call the immigration authorities on the non-citizen spouse. And you need to, I think to be a good practitioner and a culturally aware practitioner and a responsible practitioner, advise your client, if they are the non-citizen client, of immigration implications to the best of your ability. Because they will sometimes deal with threats to lose leverage in things. They will give up things before they even come see you because they are scared. And it's important that because they have rights, just as much rights as everyone else in this state and in this context, that I think that it's important for them to understand from a practical standpoint their immigration consequence or lack thereof. Of course, You even go as far as folks not being scared to come to court because they think that, deportation authorities are waiting for them. ICE is waiting for them at the courthouse, at the divorce court. And it's just things of that nature that I have found is from a culturally aware standpoint, an important role that we as lawyers play in our clients' lives, advising them and comforting them and assuring them of their implications, because they truly don't know. And I think we need to assume they don't know, because it's a very, very important context. And if we can move to the next slide. So in closing, the legal system is oftentimes difficult, painful, and confusing, to say the least. If we apply these 7 culturally aware constructs in our practice, we can hopefully make the experience a little less painful. Keep in mind that we all came from somewhere else. And with that, I am pretty much closed, everybody, unless anybody has any questions for me.
All right, there are not any questions in the chat.
I hate that.
All right, thank you so much, Alex. And with that, we will end today's seminar, and you will receive an email here in a few minutes. If you can't find the form to complete your CLE, it will be in that. And thank you all for attending.